Hi everyone, welcome to Immigration and Jobs Talk Show. I am Rajni Bharara, your host, and today we have a topic that strikes at the very heart of the American dream: birthright citizenship, a legal principle rooted in the 14th Amendment. It has long been a cornerstone of US immigration policy, but now it's under fire. Now, before I say more about it, I would like to read out this very important disclaimer, which is here on the screen. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back, everyone. Today, we are going to dive into a very important topic, like I said. And to talk about that topic, we have none other than Jonathan Boston, a renowned immigration litigation attorney with years of experience navigating the complex intersection of law and policy. Together, we'll unpack the implications of the lawsuit challenging President Trump's policies and its potential ripple effects on immigrant communities. What's at stake? How might this case shape the future of citizenship rights in America? And most importantly, what does this mean for immigrants today and in the years to come? So, without any further ado, let me give a very warm welcome to John. So, John, welcome back to Immigration and Jobs Talk Show. It's always a pleasure having you. And today we have a very important topic to talk about. So, welcome back again.
Thank you. Thank you for having me.
Thank you so much. John, without wasting any time, I directly would like to jump into my very first question, which is that is Trump's executive order on birthright citizenship constitutional?
I don't think there's very many people who think it is. I think the general consensus is this is something he did just to beat his chest and show his anti-immigrant following that he's doing something. So the general consensus, like I say, is that this will more than likely be invalidated by a court, and it'll be the end of it. Now, in the interim, until that happens, the real impact is going to be, if you're applying for a passport for a newly born child, the State Department may not issue it right away until a court order comes down telling them that this executive order is unconstitutional.
Okay, but John, can a president really change who becomes an American president? Oh, sorry, American citizen?
No, it's governed by the Constitution, and it's governed by statute. And to the extent that the Constitution doesn't contemplate every possibility, the statute takes over. What Trump and his administration are trying to do is they're taking the very, very clear language in the 14th Amendment that says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state where they reside. What they're saying is that "and subject to the jurisdiction thereof" clause somehow allows them to prevent the people being born in the country who are born to non-permanent residents and non-US citizenship. But when you look at the history of that clause, what they're really referring to is diplomats who have diplomatic immunity, who are not subject to the jurisdiction thereof. And diplomats' kids, when they're born in the US, have never been granted US citizenship. And so, they're really pushing against common sense, the plain language of the law, and also history. And there's just really no angle that they can take on this that's going to be appealing to a court.
Okay. But then why do you think they did it in the first place? Like, why did they think about doing it if it's not going to go forward?
Yeah, so I mean, Trump's base, they are very upset about illegal immigration from the southern border, and that's understandable. Especially, if you're living along a border state, that's an issue that you're going to be voting on and you want tougher enforcement on. They were also keyed in and aware of the fact that there have been clinics and hospitals set up, mostly catering to Chinese clientele, where the Chinese clientele will come on a visitor visa shortly before baby's due, have the baby here, recuperate, get citizenship for their child, and then go home. And those are the two scenarios that they're trying to prevent and they're trying to stop, is the illegal immigration and the birther tourism, for lack of a better term. But in the mix, anybody who's on a non-immigrant visa here legally and lawfully is also most likely going to be impacted by this executive order in the interim.
Okay. Okay. But then, John, also I would like to know from you that how could the government legally stop granting automatic citizenship to children born in the US?
So I think the way that they will do that, the only way they really can do that is through the issuance of passports or the non-issuance of passports. And so, if you were to apply for a passport for your child right now, proving citizenship would be an issue potentially if you're a non-immigrant or you don't have legal status until that court order comes down saying, no, this is not legitimate.
Okay. But then has the 14th Amendment ever been challenged in a similar way before?
No, probably because it's so clear on its face, nobody's ever thought that this was a good idea to do. Just looking at the language of the 14th Amendment, it's abundantly clear. And it's, the history of it shows that it was designed to grant citizenship to anybody born in the US, regardless of the status of their parents. So, the people that it affected back in the day were not documented aliens, right? They didn't come here with a visa. Their parents didn't come here with a visa, rather, and they were born to people who didn't have visas or legal status other than slaves. And so to say that the executive order has found some gaping loophole in the 14th Amendment is kind of stretching it a lot, actually. And so I just don't see a whole lot of courts having patience and time for this. I think it's going to be something that gets kicked out very quickly probably in the first month and a half of the Trump administration. They'll take a beating on this one. But it's more of a distraction, I think, from what's going on with the grander issues within the Trump administration on immigration. And it's also indicative of where he's headed. So, there's a lot of buzz earlier about, Elon Musk saying great things about the H1B visa, right?
Mm-hmm.
So there was some optimism that maybe Trump's second time around wouldn't be so bad for immigration or legal immigration and high-skilled immigration. But, the birthright citizenship issue and the extreme vetting issue, all of that's lining up to show that no, it's just going to be just as bad as it was the first time.
Or maybe worse?
Yeah, it could be worse. I think what they learned from their last time around is, what not to do. They jumped in and rushed into a bunch of things without going through the right process. I think this time they've figured out how to game the system a little more effectively.
Okay. Okay. Well, let's wait what actually, happens there. And the first day itself had so many things coming. So we weren't really, somewhere we were expecting, but we weren't really expecting this much to happen. But then let's see what really happened. But then, John, I would also like to know from you that, how might this challenge to birthright citizenship impact future presidential actions?
So probably not much because the other court cases are going to be brought against his policies are on issues where the law is not so clear and potentially not quite so favorable to plaintiffs. The extreme vetting piece, that is something where courts are more likely to give the executive branch a lot more leeway and a lot more flexibility to accomplish their goal of protecting the US. So as obvious it is as it is what they're trying to do with that extreme vetting, I think the courts are probably going to be more inclined to let that happen. And let him have his executive order on that issue.
Okay, okay. And could this set a precedent for presidents to reinterpret constitutional provisions through executive orders? Do you think?
Where they're clear like this, I don't think so. Where there's a little bit of ambiguity, there's always the possibility that they can find a loophole or they can find some exception that a court's going to agree with. But with this case, you know, the language is so abundantly clear, the history is so abundantly clear, and the reason for the amendment is so clear. I just don't see it, getting any traction with the court. Even if they get lucky and they get a Trump appointee from the first administration as a district court judge, that first trial court level, any court of appeals that hears this, I think is going to shoot it down.
Okay, okay. But John, even if let's say it goes through, and then what might happen to the children born in the US?
Well, that's a great question, right? Because they're born here, they've been here for a while, at least over 180 days, without any type of visa. There's no provision in the law that says that if you're born in the U.S., you're granted immediate or automatic residency status, right? Or non-immigrant status if your parents are non-immigrants. And so, you know, what is their status? That the law doesn't anticipate what that would be because the law has always assumed that they would be citizens if they're born here. So there's a lot of questions that are going to be raised if this was, allowed to go through, and you would find the odd circumstance or the paradoxical circumstance where an infant born here in the U.S. who can't even speak would have a ground of inadmissibility for having overstayed and been in the country without authorization for more than 180 days. And that just seems incredibly crazy that they would do that, but that would be a natural consequence of, birthright citizenship being destroyed.
Yeah. And do you think would this create a group of children, who don't belong actually anywhere?
Possibly, yeah. But again, I don't think this is going to stand. But hypothetically, yeah, it could cause problems like that.
Okay, okay. So moving forward, I would like to also know about, how will calling cartels and gangs terrorist groups change immigration enforcement?
So when you throw out the magical T word, the terrorism word, it does loosen up certain funding within the federal government to do emergency, actions. It also gives the federal government a little bit more flexibility in what tools and what things they bring to combat the issue. By labeling it terrorism, theoretically, they're opening up activation of military to combat terrorism. Historically, if you look at it, it wouldn't be the first time that the country has brought the military in to the southern border to fight amounts to a terrorist organization. Back in the early 1900s, there was Pancho Villa. He was a Mexican rebel that was leading border incursions across and attacking settlements on the U.S. side of the border. And we sent the American Army down there, and they had the punitive expeditions fighting in Mexico, chasing down Pancho Villa. And so there is precedent for using the military along the border. Whether or not we're going to get into that remains to be seen. I would hope not. I think that would be a catastrophe. Having been in the military, in my lifetime, I just don't see that as an operation that we would be set to excel in, because we've learned one thing from the U.S. military over the past 20 years, and that is fighting an insurgency or fighting what's called asymmetrical warfare is something that we're just not very good at, and no country's terribly good at. So it would be a catastrophe if we sent the military south of the border.
Okay, okay. But do you think also, this designation can lead to increased a legal risk of migrants, accused of association with such groups?
hmm Yeah, it does open up new grounds of inadmissibility, or it makes people, qualified to be in grounds of inadmissibility that would prevent them from getting visas or admission into the U.S. if they've been labeled. The problem with that is the way that USCIS in particular and DHS has been dealing with these issues of inadmissibility is completely illegal. What they're supposed to do when they take an adverse action against somebody is they're supposed to give them notice, they're supposed to give them opportunity to respond to the allegation, and then they're supposed to make a decision in writing and give that explaining the law and the facts that their decision is based on. What we see DHS and USCIS doing, however, is they're entering these findings in secret, not telling anybody. And the only time you ever find out about these findings is when you go to a consulate for a visa stamp or you go to the port of entry for admission. And that's when you find out that you've been, listed as inadmissible for one of these categories. And I see that all the time in regards to alleged false statements, inadmissibility based on false statements. And am suspecting that we're going to see that happening with the terrorism related grounds, is that they will just start using that incredibly freely without a whole lot of thought or discretion, and it's going to be a tool they use to eliminate a lot of people from the pool of those that can come to the U.S.
Okay, okay. Thank you for answering the question, John. Also, what could happen if military is used for border enforcement?
You know, so the border enforcement is an interesting question. It's an easier question to say, can we send the military south of the border to combat narco terrorism? Legally, yes, I think we can do that. I think, practically it would be a horrible idea. Border enforcement's another issue, though. It's quite a bit different and it's more nuanced. So there's this thing called the Posse Comitatus Act. And it goes all the way back to post Civil War when the US Army was occupying the South. And they were the law enforcement, for the South in the Reconstruction era after the Civil War. And part of the compromise of ending Reconstruction, getting the levers of power restored to the civilians in the South, was the Posse Comitatus Act that said that the US military will not be allowed to enforce civil law, and they have no authority to do that in the United States. And so, the question is whether or not border enforcement, which is on our side of the border, would violate Posse Comitatus. And I think, the US military could serve in a supporting role legally to CBP, like logistics and things like that, because they're not enforcing law. But once they start putting the military into an enforcement role, there becomes a whole lot of problems with the Posse Comitatus Act. And I think that's something that it's a little bit more nuanced, but I think it's also something that the administration will lose in court.
Okay, okay. So, also, how might stopping asylum and refugee admissions affect international human rights?
Yeah, so the asylum and refugee issue, it's a program that in theory is very valuable and it's very noble. What the Trump administration, I think, is responding to is pretty well documented cases of abuse of that noble policy. And yeah, there are pretty good documented cases of people that are just running these asylum mills where they give people these backstories, they prep them for these interviews based on facts that never actually happened to the person, and then they send them for their asylum or their refugee screening. And that's probably the minority of cases by far, but it's something that has happened in the past, and I think that's what they're responding to is the abuse in the asylum system. I think for the legitimate folks that are truly impacted by oppression in their home country, it's going to be a catastrophe. They're going to be stuck in refugee camps. They're going to be stuck in their home country with really no protection or no sense of certainty of what's going to happen in their future. But again, asylum and refugee policy is something that the law does give the president a lot of discretion over and how he administers it. So it's something that's probably not going to be very easy to challenge in court.
Okay. Okay. And John, with this, I would also like to talk about, the government and workplace changes. So I would like to know from you that what might happen legally if diversity and inclusion programs are ended in federal agencies?
If there were which program, sorry?
If diversity and inclusion programs,
City inclusion programs?
yeah, diversity and inclusion programs.
Oh. Yeah, so the DEI stuff or the D, yeah, I think that's any mandatory or encouragement on the federal level is going to probably end if it hasn't ended already. Individual states, individual cities, they're completely allowed to have their own policies on that. However, it remains to be seen how courts are going to handle challenges to that under the Equal Protection Clause. So as we look at the history of affirmative action and how that's fared in courts, the current Supreme Court, being very conservative, they have a view of the Equal Protection Clause that says that you can't give preference based on race to anybody, even if it is as somebody who's been historically oppressed or disadvantaged. It has to be race neutral. And I think where these DEI policies are going to run into problems is, when they're giving preference to certain categories of folks and disadvantaging others, that's going to have equal protection ramifications. And that's something that, in theory, the federal government could proactively sue the municipality or the state on.
Okay, but do you think that cutting federal jobs, can face constitutional challenges?
No, it would. Let me put it this way. If Congress authorizes money, then the president's hands are limited because Congress has said this is how we want to spend our money, and this is the only way you can spend that money. So as long as Congress keeps pumping out the money, the executive branch, is in charge of spending it and has to spend it typically. The if Congress is working with the executive in cutting jobs, it's very easy. There's no constitutional issue involved. The only time there becomes a constitutional issue is a separation of powers issue between Congress and the executive. If there's a disagreement there about how the law is being enforced and whether or not the executive is faithfully executing the laws that Congress has created, then that's an issue that can come about. One way that they typically are going to do things like this is not overtly. It'll be attrition, hiring freezes, pushing people out through retirement, just subtle changes in process as opposed to outright layoffs and firings to eliminate positions. So I would expect it to be death by 1,000 paper cuts as opposed to, chopping the head off the snake.
Okay. John, thank you so much for answering all these questions. With this, I would also like to know your viewpoints on that the CBP app shutting down. So I would also like to know from you that how will the sudden shutdown of the CBP One app impact nearly 1 million migrants who had scheduled legal entry appointments?
Yeah, I think it's just indicative of where the Trump administration is headed. They want to make life as difficult as possible for people trying to enter the U.S. And that's simple, full stop. They are under no obligation to make things easy. They're in charge of creating process. They're in charge of dictating how services are delivered. And if they throw up obstacles or they eliminate efficiencies, it's annoying, especially if you're an immigration lawyer or you're the person impacted. But it's something courts are not likely to get involved in and tell the executive, you know, no, this is the process you must follow. So as long as they're not overtly doing something illegal, those process type of issues tend to get a pass in court.
So then, what legal challenges can migrants potentially can take against the abrupt cancellation of their pre-approved appointments?
So not much on that. There's if they're outside the country, especially, you have very few rights when you're outside the country, and the executive branch is given a lot of authority to determine, who can enter the U.S. And if you don't have a right to enter the U.S., then you clearly don't have a right to a scheduled appointment. So I don't expect that there's going to be a whole lot of legal challenge to that aspect.
Okay, so John, also does the executive order violate any existing immigration regulation or international asylum protocols?
Well, international asylum protocols probably, but the Trump administration has never really shown themselves to be big fans of international law, and international law is one of those things that is tough because it's all based on agreement to cooperate and to follow. And if somebody opts out of following international law, there's really not a whole lot that you can do, especially when you're the biggest kid on the block. You're the one spending money to support the UN, and you're the most powerful country in the world. There's not much people can do to punish you for violating international law and conventions like this.
Okay. And what immediate risks do migrants face after having their appointment suddenly cancelled?
Just being stuck in place where they're at. I think that's the unfortunate situation is just they're on hold and their lives are on hold while they're waiting for those appointments.
And how might this action potentially increase unauthorized border crossings?
So, interestingly, right now, illegal border crossings that are kind of at a historic low, they're greatly decreased during the Biden administration. So I don't know how much of an effect it'll have, because typically the unauthorized border crossings are more a reflection of disruption and problems in people's home countries more than anything. And the lack of border crossings that we've seen, I think, is indicative of countries starting to get more stability and addressing their internal problems, which takes away the incentive for people to leave. So I'm not sure how that'll play out.
Okay. And then how might courts also view the sudden revocation of scheduled legal entry appointments?
I don't think the courts will get involved in that one. I don't think there's really a legal hook to have a successful lawsuit on. Like I was saying earlier, the courts have historically given the executive branch a lot of latitude and a lot of authority to determine who is admitted into the United States. And if the courts have given that authority to determine who gets in, clearly the executive has the authority to determine who meets the first step in that process of admission, which would be those interviews.
Okay. Okay. And then how does this action align with existing US immigration laws?
So in terms of the appointment cancellations, I think US, especially under Biden, US immigration law had been trending toward a more user-friendly experience. And clearly under Trump, they're going to be retrenching. They're trying to make it as difficult as possible.
Okay. John, also, I would like to know from you that, all that this is happening, do you think, is this about fixing immigration or punishing immigrants? What do you think?
So I don't think the Trump administration and the Trump supporters have any desire to fix immigration. I think they just want to end immigration. And so I think it's all about making life as miserable as possible for people in the US or trying to come to the US as a way to discourage them from coming to the US or staying in the US. And I think that's you know a trend we'll see as long as Trump's in power, to be honest.
But then, US is a country who's built by the immigrants. And how will this work if this happens?
That is the grand irony. Not only are we a country built on immigrants, immigrant populations have historically, spawned great innovation, economic, recoveries, and success. And the problem we're having in the U.S. right now is that we have a very small number of people that are going into the hard sciences, getting degrees in things that matter, and being prepared for even college and degree programs that are valuable to the economy. And so we're not generating enough brain power in the country to sustain the economy that we currently have. And the only way that we're going to fill that gap is frankly to poach the best and brightest from other countries to come to the US and work and drive the economy. And excluding immigrants, in the Trump mind, if you keep out immigrants, then automatically somehow some kid in the US in the Midwest that didn't study hard in school is going to be qualified to be, an IT professional. And that's just not reality. You know, they didn't study hard enough in high school, they didn't study in college, they didn't prepare themselves, they got an English degree instead of a computer science degree. You know, there's just not, qualified US workers to take these roles over. And so, immigration has been a way that we've been covering that for a long time, basically since the early 90s. And if we cut that stream off, we're really shooting ourselves in the foot.
Okay. Well, also, John, with this, I would also like to know from you that do you think that with these rules coming in, we are actually changing the rules of who actually belongs to America?
So I think they're definitely trying to reshape the landscape. They want to decrease the number of people that are coming. And Trump's made no secret that some immigrants are good, and then some are completely undesirable. And those good immigrants, are Northern Europeans for in Trump's mind. And so, yeah, they would definitely like to change the mix of people coming to the U.S. But frankly, I mean, anybody who's been to Europe and has seen what life in Europe is like probably isn't a whole lot, doesn't have a whole lot of motivation to come to the US, where we have very expensive healthcare, we have ridiculous working hours, and, you know, the lifestyle is just not very good. And so I don't think we're going to be getting the immigrants from Northern Europe that Trump sees as, valuable to the US.
Okay, and also very recently I saw, I think on the inauguration day itself, I saw a tweet from Elon Musk, and where he wrote from MAGA to MEGA, I think make America great again to make Europe great again. So, what do you think this means? What do you think he meant by this?
So there's an American perception of Europe. I don't think it's terribly accurate, but the American perception of Europe is they have let so many Arab and North Africans into Europe that they've destroyed European culture. And you know, basically, it's they want to make Europe white again and eliminate those folks. And that's what you're seeing there when they make Europe great again. Is they're saying return back to your genetic European roots and stop letting those North Africans and those Arabs in.
Okay, so you mean that that whatever decisions this administration is going to take will not directly impact America, but the whole of Europe?
Well, I don't think they have a whole lot of impact over Europe. And I think most European leaders think that Trump's a bit of a buffoon. So I don't see him having a whole lot of sway over their internal policies. But the perception that certain Americans, especially in the MAGA crowd, have is that Europe is, somehow destroying itself internally by allowing immigrants to come in. That's their mindset they have about the U.S. That's the mindset they have about Europe, and you know, I think it's an unrealistic view of Europe, especially. Europeans aren't clamoring to come to the US. So they must be doing something right there.
Okay, thank you so much for answering the questions, John. I have a lot of questions from our viewers, so let me quickly take them. So I think AD Sterling is here, and AD says the ploy was to get thus into the courts so the Scotus can decide the matter. All I read is the term immigrants. If you cross into the US, that person is here illegally. Okay, I think this is a comment that he made. Do you have anything to say to him?
Is that in regards to the birthright citizenship?
I think so, yeah.
Yeah, I think what the Trump administration is trying to say is that U.S. citizens and permanent residents that have children, those children have automatic citizenship. But if you're a non-immigrant or you're an undocumented immigrant, then your children do not get automatic citizenship. And that's the spin that they're putting on this.
Okay, and Tricia is also here, and Tricia says 93 countries have ended birthright due to the abuse of the original meaning.
Mm-hmm.
What do you have?
So, most countries, the way they handle citizenship, it's through, their legislatures, and then their parliaments. And that's a very easy change to make. If the sentiment in the country is we want to change, legislatures can do that very quickly. Our legislature in the US, not quite as efficient. We haven't actually got anything meaningful done in Congress in at least a good decade and a half. And it's just mostly been the administration, the executive branch that's been running the show. But our Constitution is the one that creates the birthright citizenship. And historically, changing the Constitution has been a very difficult, very prolonged process. And the vast majority of proposed amendments to the Constitution have failed and haven't gotten off the ground. So because it's in the Constitution and because it would take, going through all of those incredible hurdles to get an amendment done, I just don't see it happening.
Okay. And Viking for Life is also here, and Viking says UK got rid of birthright citizenship a long time ago. Two illegal aliens couldn't. Oh my God, this is a big statement that he said. Okay, let me quickly take Monali Thakur's comment. Maybe. How do you think the outcome of this lawsuit will impact the lives of immigrants and their children born in the US, considering the potential consequences of denying birthright citizenship, such as loss of access to federal benefits, social security numbers, and voting rights? What do you have to say, John?
Yeah, I think the lawsuit is just going to preserve the status quo. So I think at the end of the day, we're going to see, people that are born in the United States getting citizenship, unless you're a diplomat's child. And I don't think it'll have any long-term effect, is my prediction. I think in the short term, the only impact that we're going to see is the State Department potentially not issuing passports. And so, people who have newly born children that haven't gotten a passport yet, they may have to sit in place before they can travel with their kid.
Okay. Okay, so Manali, I hope you have got your answer. In case you want maybe More answers, you can continue writing or posting your follow-ups. Meanwhile, let me take Ram's question. Ram says, how does this lawsuit affect the immigrant communities who are already living in the US as permanent residents or asylum seekers? Could their children be impacted even if they are illegal, even if they are legally here?
Yeah, I again, the only thing that's going to be impacted, I think, long term is, or short term rather, is the issuance of passports. That's, the only thing that's going to be a problem. I think, at the end of the day, at the end of the lawsuit, we will go back to status quo. There won't be any changes. And, anybody born here in the US, except for diplomats' kids, will get birthright citizenship.
Okay. Thank you so much, Ram, for your question. Continue posting your follow-ups if you have more. And let me take Girish's questions in the meanwhile. Girish says there are people saying that this lawsuit is just a political move. Do you think there's any validity to that argument, or do you believe there are strong legal reasons behind challenging birthright citizenship?
Well, so just to be clear, the lawsuit is challenging the executive order, and the executive order is the one that's attacking birthright citizenship. So, do I think the executive order is a political stunt? 100%. I think any legitimate, thinking lawyer realizes that this is going to die, that the courts are going to shoot this down. So it's definitely a political stunt. And you know, in terms of whether or not ending birthright citizenship has merits, that's a question that is going to have to be resolved through a lot of debate over time, and it's going to have to go through a constitutional change that's going to require a lot of public participation and input. And I think even if we did see changes to birthright citizenship, I think we're looking at years and years and years down the road.
Okay, okay. Thank you so much, Girish, for your question. If you have follow-up, please continue posting them. Meanwhile, let me take Arpita's question also. Arpita says, what's the long-term impact of this lawsuit for immigrants who are still hoping to become US citizens? Would it make it more difficult for families to navigate the citizenship process in the future?
I think if you're here and you're on that path, it's not going to have any impact on you, because all the executive order is doing is trying to limit, going forward from the date of that executive order, who qualifies as a U.S. citizen, when you're born here. So the lawsuit, the long-term impact of that is just returning us back to where we were at the day before that executive order, and how citizenship is dealt with. Now, whether or not USCIS and the Department of Homeland Security are going to make the naturalization process more difficult for people and for applicants, that is a possibility. I mean, that's something the executive order can do, or that the executive branch rather can do pretty easily, just by saying this is a higher priority. We need to investigate people more thoroughly. We need to make sure they qualify. Yeah, all of those things can impact the naturalization process. But in terms of birthright citizenship, the executive order's impact is going to be very short-term, temporary, and limited. And I think we will return to birthright citizenship very soon.
Okay, okay. Sarvesh is also here, and Sarvesh wants to know that what role do you think international human rights laws, such as the Universal Declaration of Human Rights and the Convention on the Human Rights of the Child, might play in shaping the court's decision, particularly with regards to principle of non-discrimination and the protection of vulnerable population, including immigrant children?
Yeah, so when it comes to international law, the courts don't really give it a whole lot of credence, to be honest. Yeah, if you make international law arguments in a federal court in the United States, it's like, oh, that's cute, that's nice, that's interesting. But anyway, let's focus on the real issue. Very, very, very few cases in the American judicial process have ever turned on immigration or international law. And so I wouldn't expect those conventions to sway anybody in the court.
Okay. Okay. Let me quickly take Sanjay's question also. Sanjay says, how might the judicial outcome of this birthright citizenship case influence the evolutionary trajectory of US citizenship laws, and what potential far-reaching consequences could emerge for the future landscape of American immigration policy? What do you have to say, John?
So I think in terms of naturalization policy, again, the executive order limiting birthright citizenship, I don't think is going to stand. I've been pretty clear about that. But changes to the naturalization process could take the form of statutory changes, limiting who's eligible for naturalization. That is something Congress can totally do, and they're authorized to do. And frankly, if Congress creates rules on naturalization that are more difficult, those are going to stand. The courts aren't going to overturn those. And so, that'll just be at the end of the political process, the political debate and codification of the law. So, if you look at our Congress, we haven't really accomplished any major legislation or major policy changes, especially in immigration, in decades. So I'm not expecting anything, dire or dramatic to happen anytime soon, just because, the procedure used in Congress to get things done is very unwieldy, very difficult, and, hot issues, difficult issues tend not to get resolved because they're too difficult to resolve.
Okay, okay. Thank you so much, John, for answering all these questions. I think we have covered all the questions from the viewers as well. But with that, I would also like to know from you that what more can we expect? It's just been a day since Trump has taken the office, but what more can we expect in terms of, what might happen to immigrants and immigration policies and visas? So what more can we expect?
I think if you're outside the U.S., you can expect the consular process to be much more difficult, much more limited. I think they will scale back appointments. They'll make everything as hard as possible to get a visa. And then at the port of entry, there's going to be much more scrutiny. So if there's anything in your immigration history that's been flagged, you're not going to know about it until you get to the port of entry. And you may face, questions about something that happened a decade ago, in your immigration process. So I think those types of things are what we should expect, especially for the H1B population. I expect that the FDNS, which is a branch of USCIS that is like their immigration Gestapo, that goes out and does these visits and harasses H1Bs. I think those investigations are going to increase dramatically. And the important thing for that population to understand is that they have a right to a lawyer in that situation. And having a lawyer represent you in those cases is about the only way that you can protect yourself from getting bullied and pushed around and, having your statements twisted and mischaracterized in some report that is going to impact your immigration future forever. So I would say get with an attorney immediately, have what's called a Form G28 signed between you and the attorney. And if there's ever a FDNS officer that shows up on your doorstep or comes to your work, give them a copy of that G28 and say, I have a right to a lawyer. I'm using that right. Please contact my lawyer for further inquiries on this issue, and leave it at that. And don't let yourself get bullied into talking further.
That's a great advice. Thank you so much for that, John. And guys, if you want to directly get in touch with John, make sure that you give him a call on the number 844-592-7336. Yes, I would like to repeat the number 844-592-7336. You can also email him. His email ID is support@waston.law. And you can also visit his website, which is www.waston.law. So make sure that you give him a call, reach out to him on his email, and you can also visit his website. Thank you so much, John, for being here. It was great speaking with you. Thank you so much for your insightful answers on all these trending questions. People are really looking to get an answer for these questions. So thank you so much for answering them in so much detail and depth. And we're looking forward to doing another great episode with you on another great topic. But until we meet again, thank you so much for being here.
Thanks for having me. It's good talking to you.
Likewise, thank you so much. And to our lovely viewers, thank you so much for posting so many questions of yours, and we enjoyed taking them. Thank you so much for that. And we are going to see you very soon in another webinar. And we are going to have another webinar at 12, so make sure that you tune into that. And if you want to get in touch with me, my number is 732-707-9151. My email is rajni@staffingly.com. So if you have any queries for me, make sure that you give me a call, send me a text, or maybe email me. But for now, I'll have to take your leave. I'll be seeing you soon on another webinar. But for now, I'll have to take your leave. Make sure that you like this video, subscribe to the channel, and share this episode with anyone looking for answers to these questions. But for now, have a great day. And I'm Rajni, signing off. Bye. Take care.
Hello and welcome everyone to Immigration and Jobs Talk Show. We are lined up again with another very exciting and amazing episode that is lined up just for you. So do not forget to like, share, and subscribe to our channel. I'm Sam, your host. And before moving ahead, before diving into our today's topic, before also announcing the name of our guest, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not a legal advice. So, use of information is at your own risk. All right, after this very important disclaimer, I would also like to tell our viewers that we are live on YouTube, LinkedIn, Facebook, and on X as well. So join us from these platforms and let us know from which platform you guys are watching us right now. So I think without any further ado, I would also like to talk about today's topic that we are going to talk about, and that's about E2 visa updates 2025. What should international investors know? So I think it's a very important topic for everyone, those who are watching us right now. So today we are going to explore everything like what should be the main factors that international investors should look upon. Then also certain mistakes. Also we are going to talk that what the international investors mostly do and how can they avoid them. Then certain different things also like what are the perfect places or how they can build their connections over there. There are so many things that we are going to explore in today's topic. It's going to be extremely informative. So do join us and watch this session till the end. All right, and to help us in exploring this topic in a very detailed way, in a very simple way, I would like to welcome our today's very honorable guest, who will be joining us today for the very first time. So please help me in welcoming none other than Attorney Marcelo Gondim. So, Attorney Marcelo Gondim is a highly respected immigration attorney and the driving force behind Gondim Law Corp, Los Angeles in California. With years of experience, he is a member of the American Immigration Lawyers Association and is also licensed to practice by the State Bar of California, the U.S. District Court for the Central District of California, and the U.S. Court of Appeal for the Ninth Circuit. So, welcome, Marcelo. We are really honored to have a show with you. Welcome to our very first episode that you're going to have here. And we are really grateful that you have joined us. So, thank you so much for being here.
My pleasure. Thanks for having me.
All right. So, Marcelo, why don't you go ahead and share something about with our viewers, like how did you come into immigration field and what was the motivation behind it?
Well, back in the days, I came to the United States as a visitor, and someone told me this is over 25 years ago, and someone told me that I could actually become a lawyer in the United States as well. And that kind of opened my eyes for this possibility. So I changed my status, did not go back to Brazil. That's where I'm from. And I stayed here, changed my status with my whole family at the time. And then I started working as an immigration paralegal for a law firm in Miami. Later on, I found out that I could actually get a license to practice law in California, and I had to take the bar exam. So I did it. And in 2010, I became a lawyer here in the US as well. And I already had some kind of clientele, let's put it this way, because people knew me from when I was a paralegal. So I started my practice with some clients already, and I've been doing this ever since. So it's been now 15 years
Wow.
working as an immigration attorney. And if I count the time that I was working as a paralegal as well, I can say probably about 23, almost 24 years working in this field.
Wow, that's great. That's really amazing to know about it, and that too you have been for quite a long time. I mean, a very long time in this field. But Marcelo, I would like to just know it from you because you are also an immigrant, so you know the struggles, you know the problems, mostly the immigrants they face. So when you came to US, I mean 25 years back, so how was your immigration journey? Was it okay as compared to now immigration journey? Most of the people that they are looking ahead to go to the US. How can you compare these two time immigration journey?
Well, it was much different because at the time, cases would take much longer than they take today, even though people complain about how long the cases take today. But for example, labor certification case will take about 6 years back in 1999, 1998, 2000. And today it takes about 2 years to complete this phase on the EB3 process, for example. But most of the cases will take much longer than they take today. And it was more difficult. The law was more difficult at the time. It became more simple over the years, despite some change in policy regarding whatever president comes to office, and they change the policy, and the whole country changed their view on immigrants. But overall, it's easier to immigrate today than it was back in 2000, even though it was easier to come to the US in 2000 than it is today.
Oh, wow. That's something different we are going to listen today because most of the time we are listening that now immigration journey has become very difficult under Trump's administration. So, also, Marcelo, I would like to know your call, your views on Trump's administration, how you're seeing US future under Trump's era.
Well, I think that despite each one's political views or political affiliations, we had to give him a pass the first time around because we didn't know how it was going to be. So I lived during the first 4 years of Trump as a president. And I can tell you that it was not good for immigrants in general. Not only undocumented immigrants, but legal immigrants as well, or people pursuing their green cards or legal status. It was bad for everybody. There was about 400 different policies or executive orders that he issued, all of them bad for immigrants. So we've been through a lot of abuse. The local government, the federal government, I'm sorry, the local government committed several forms of abuse against immigration and immigrants in general, and there was a lot of federal court litigation. Some of these cases made it to the Supreme Court. Uh, Example of DACA, he tried to undo DACA because DACA was made by Obama. So he tried to undo everything Obama did, and he fought to destroy DACA. I don't know if he's going to get in this time around, but he did. He did try a lot and could. I don't know how DACA survived the first 4 years of his administration by any chance. But the fact of the matter is, it was a bad administration for immigration. There was a lot of different rules to make everything more difficult. Even during the pandemic, he was mandating that students, international students, they had to go back to class, or if they didn't have a class during the pandemic, they should go back to their countries. So it was kind of inhumane the way immigrants were treated by the federal government. Most of that stuff was successfully litigated by the ACLU, ALA, which I'm a member of, and other organizations that sued, and individuals also that sued the federal government, and they won in courts many times. So the federal court was very important during the first term of the Trump administration, and it's going to be important now. So, based on what we saw during 2017, 18, 19, and 20, we should not expect anything good coming out in the next 4 years. And we already have signs of this. You already have violation of Constitution with the declaration that people born in the United States, if the parents are not legal, they cannot be considered U.S. citizens. It's a violation to the 14th Amendment of the Constitution. So that's going to be challenged in court. It's already being challenged in court, and he's going to lose, but he's doing it. So that shows the anti-immigrant intent, the anti-immigrant intent of this administration. So that's what we're going to expect now um, for the next 4 years.
Oh my God, I think that's a lot to process, and also, most of the news also we have went through, and there are so many different statements that Trump is putting on. And latest today morning, also we went through some H1B visa statements also. So, few days back he was against the H1B visa, and now he's towards H1B visa. So we can see that he is quite in favor, or maybe he will try to have some leniency towards the H1B visa. But Marcelo, I would like to know this in terms of E2 visa. I mean, can we expect something for the E2 visa applicants under Trump's administration? I mean, how can we expect the future for the E2 visa applicants?
Well, I don't see anything major changing in terms of E2 visa applications. Those visas are based on treaty between the United States and other countries. So I don't see a lot of it didn't there was not a lot of damage to the E2 visa at the time he was president, the first term. So I'm not expecting anything major now. Of course, the immigration in general can get a little more difficult. More people can get denials, and some kinds of visa will be less favored by his administration. But I don't see a lot of this happening to E2 because E2 is based on investment. So I think any country wants immigrants to come and bring money and invest and create jobs, and maybe one of those companies can be a successful business in the future. We have many companies in the U.S. that were founded by immigrants, and today there are some of the top 500 companies in the world. So it's not something I see anything bad that I can see happening to E2, but I expect some kind of hardening of the approval process.
All right. Okay. So I think E2 visa applicants can feel little relief that there won't be any, much challenges or much obstacles. I think the process will be little harder, but not that difficult, right? As compared to the other visa places. Okay, so I think now it's time. I would like to directly jump into my questions that we got the overall perspective of what do you think about Trump's administration, and also what can be the future of E2 visa. And now, Marcelo, I would like to jump into my very first question that is just for you. So, what are the most important factors that international investors should consider before starting a business in the US?
Well, they should understand that starting a business in the U.S. automatically does not make them qualify for an E2 visa, but certain types of business are better for the H2 visa than others. So instead of just coming here and investing and then say, now I'm going to apply for an H2 visa, it's better to first study the market and consult with an immigration attorney so you know the types of business that will be more favored by an E2 application than others. So you don't go for those types of business that normally make it much more difficult to get your E2 visa application denied, approved. So in cases like this, it's crucial to understand also that there are some certain requirements for the issue that are not even in the law, but it's in practice, something that you should be aware of. One of them is the minimum investment. What's the minimum amount of investment? The law talks about substantial investment, but what's substantial to one might not be substantial to another. So the attorneys, almost all the attorneys, they come up with this $100,000 as the minimum for the investment. It's not in the law. I've seen cases approved with 50, 60, $70,000. But we try here at Gondim Law, for example, we try to keep it above 100 to increase the chances of the person getting approved. There are some other things that people need to uh, be concerned about, which is, for example, in order to apply for an E2 visa, you have to have already established your business. You cannot just apply for the visa at the embassy and then they'll give you the visa so you can come here and then you can open the company and all that stuff. No, you have to do that before. The company has to be in existence by the time you apply, and the investment has to have already been made. On top of that, you need to have spent the money that you invested in the business, meaning the investment was made at risk. So you cannot just transfer the money from your individual account to your business account and say, "Oh, I made my investment. I want my visa." Doesn't work that way. So you need to commit those funds at risk, meaning if you get the visa approved and you don't work with the business, you're going to lose that investment. So it just transfer the money is not enough. So there are some other things that need to be taken care of, but basically, this is the first step if you're planning on coming to the United States as an E2 investor.
Wow. So I think that was a pretty long and detailed explanation that we got. So thank you so much, Marcelo, for letting us know about how the process goes and also about the amount, the minimum amount. And that's very important. I was about to ask that question, but you already mentioned that. Also, Marcelo, I would like to know the common mistakes that, the investors, the international investors mostly do. So I think it would be great if you could mention about some common mistakes that international investors do and how they can avoid them.
Well, one common mistake is going for the wrong type of business and try to get the E2 um, on that type of business. So, for example, if people want to invest in franchise, they're going to buy a franchise, and that franchise is going to be your investment. Is it doable? Yes, it is doable, but it needs to be first investigated and analyzed by an immigration attorney that handles E2 visas, because sometimes franchises can be too intrusive. The franchise corporation might be dictating all the rules in your business. For example, what time you open, what time you close, where you have to buy the products, the raw materials, whatever you sell. So if it's too intrusive to the point that you're just being merely a manager for their business and you have no say in the operations, that might be difficult to approve on an E2 capacity in some cases. So it's very important to know before you invest what kind of business is good for the E2.
Absolutely. And I think that's a major thing that, we should understand firstly what is a good option for their business. So Marcelo, are there any business types that you want to recommend to our viewers that these are the safer business options that they can invest over there?
Of course, I think a better way to handle this is to tell the visa types that are not good for the E2, because everything is good for the E2, but some types are problematic, and that's for a reason. I'm going to tell you the reason now. So let's say companies that provide services like consulting services and services in general, sometimes those types of business can be very challenging for E2 because how are you going to say you're going to spend $100,000 in that business? Sometimes consulting services or say any kind of service that there's no physical location necessary, there is no uh, manufacturing or inventory, those are bad for E2. Sometimes it might be even impossible to approve E2 cases if you have a business like that. Also, some businesses that are too small in terms of growth, that can be problematic because there's one of the criteria for the E2 visa is that the enterprise is not marginal. And marginal means it's only there to pay for your subsistence, to pay for your bills, and so you can stay in the US. It's not really any corporation that is going to have some growth and some financial progress. So that's not good either. So you need to have a business that is going to grow eventually more than what you need to just to pay for your bills, just to pay for your existence in the US. And you're going to have progress with this company, even if you don't actually reach those numbers, but at least the business plan is showing that you're going to have progress. It's not going to be a marginal enterprise. So businesses that are too small and businesses that are purely service businesses, they are not very good for E2 visas. Everything else is okay.
All right. I hope our viewers are getting to know, and I hope they are finding it very helpful and very informative, because it's not just about, how much investment you are putting on it. It's also very important, like which business you are selecting and what can be the process and what are the criterias that that business is going to be suitable for you. So there are very small points, very criteria, small criterias that most of our viewers, they skip those, maybe by mistake or maybe something. But I think this session is going to be helpful for them, and it's going to be very important for them to understand that these small pointers are very important. All right, so thank you so much, Marcelo, for taking these questions and explaining this to our viewers. I'm sure they are loving it. And with that, I would also like to ask the importance of the investors. How can they build the connections? How can they build the network? I mean, can you please explain what is the importance of having a connection in US investing about it?
Well, yes, because if you make the investment and you open your business, if you don't have a network or if you don't know how to establish a network, it's going to be hard for this business to take off. And
Right.
maybe in a few years, you're going to have to renew this visa or get an extension of this visa, the status, and you're going to find it challenging because your business did not take off. So it's good to have this network. Sometimes suppliers, sometimes buyers, distributors, logistics. Depending on the type of business, it's good to know already the market. And so what you can do in order to acquire that information prior to applying your E2 visa is obtain a B1 visa. A B1 visa is a visa for business. So some people are from countries that don't require a visa for tourists. For tourists, they can just come over, but they have to leave the country in 90 days. In some other situations, if you come with a B1 or B2 visa, B1 being for business and B2 being for pleasure, as like a visitor, like a tourist, then you get 6 months and you can extend the status. You can apply for an extension of status or even change from B to E status. So that's important because that's going to give you time to sort out your area where you're going to open your business and how to establish this network. If you already have people that you know in the US that are in those kind of businesses, you might be in a better situation to start something because you already have the supplier, the provider, the contractor, the partner, whatever you have here. So it can be it can be a good start.
Absolutely. All right, Marcelo, here's my another question that I would like to know it from you. That what should international investors know about the US labor market before hiring employees for their business?
Well, the U.S. labor market is very strong right now. We're coming off the 4 years of the Biden administration where there was job growth every month, and sometimes making record of job growth, job creation. So the job market in the U.S. is very hot at this moment. We don't know how this is going to continue in the next 4 years, but as of right now, it's very hot, and that makes it challenging for some investors, some entrepreneurs to find labor. So you have to actually offer competitive rates, salary, wages, so you can hire people because it's really not that easy to find people that are unemployed just waiting for someone to offer them a job. You don't have that in the US right now. So the job market is very competitive for the employer to find good employees. And but also remember that as an investor, an E2 investor, you can actually sponsor other immigrants through your business. So if you don't find employees here in the US, you can bring them from abroad. There are certain tools that you can use for that. And just because you're not a legal permanent resident or citizen doesn't mean that your company cannot sponsor someone on some temporary visa.
Wow. I think that's one of the biggest advantage. So, Marcelo, is this the advantage only for the E2 visa, or do other visas also have the same benefit?
Yeah, other visas have the same benefits. The same benefit. It depends on really the characteristics of each person and their financial goals and their credentials, of course. So there are certain visas that overlap some of the benefits, but they also have some differences that will make sometimes a person that qualifies for the E2, the H1B, the L1, they qualify for all those visas, but the E2 has something that the other doesn't have, or there's a requirement that I cannot meet on that visa, but on the E2, I don't have that requirement. So it's always good to compare. Never settle just with one type of visa, you know. And you asked before, what's the main advice that I will give to people that are interested in applying for the E2? I say this to any non-immigrant visa and non-immigrant worker visa. Never try to adapt your whole life for the visa. If you try to conform to the visa that is not organically available to you, it's going to be challenging. It's going to be very difficult. So if you already have all the elements and the E2 visa or any other non-immigrant visa requires such and such, and you have those things already, it's fine. The visa is going to be your tool to come to the US and operate your business, do whatever you have to do with that visa. But when you don't have those organically available and you're going to try to conform to that in order to get that visa at any cost, the cost might be too high.
All right. So, Marcelo, do you think that these benefits or these advantages for the E2 visa will remain same during Trump's administration, or will he try to put some more hurdles into the benefits of the E2 visa?
I believe that the Department of State, which is the agency that controls the consulates and embassies of the United States all over the world, I think they're going to be a little more selective on who they should apply for the E2, who they should approve for E2. So, and we know that from the previous administration, previous Trump administration 1.0, what to expect in 2.0. So in 1.0, some nations were more favored than others. Um, Unfortunately, sometimes based on race, sometimes based on economic status, and sometimes based on immigration status of those nations. Like nations that send a lot of immigrants to the U.S. might be less favored than others. But that's just something that it's so far from the E2 that I don't think is going to directly affect E2 applicants.
We hope so. That doesn't affect much. All right, and that's all. I think we have covered a few questions from my end. And I would also like to greet our viewers, Marcelo. You know, here are Geeta, then Krishna, Ashwarya also. So, welcome everyone, and thank you so much for joining and putting these questions. We are here for an hour, so it would be great if you could also put more questions, and we are definitely going to take all those questions up. So, feel free to put any questions regarding our today's topic, and we'll be taking that up. I think, Marcelo, let's take the first question that we got from Geeta. And Geeta is asking that as I'm considering investing in a startup, I would like to understand how the recent E2 visa updates will impact my eligibility. Specifically, will the changes make it more challenging or easier for me to qualify for the visa, given that my investment is in a new venture rather than an established business?
No, there's not going to be any major change to that aspect. So if you are going to invest in a new enterprise, you have certain things that you need to take care of that you don't have to take care of if you're going to buy an enterprise. For example, investment at risk. It's one of the criteria for E2 petitions. So if you buy a new business, an existing business, you already made the investment. You already invested at risk because you already committed to those funds. Now, if you open a new business, it's different because you're going to transfer the funds to the business account, and your business has not started yet. It's a startup. So you're going to have to show that you committed those funds before you can apply. So that can be a little challenging for some types of visa. For example, real estate business, it's difficult to say that you committed the funds because sometimes, and also because of the liquidity of the assets. If you buy real estate to manage, so you can sell that real estate really quick, and then you don't have any investment at risk. So those things can be challenging for new companies more than for buying an existing company. On the other hand, when you buy an existing company, you might be buying a bad business or sometimes a business that has problems that in the due diligence process you might not be able to catch. So then you're going to have trouble down the road. What sometimes we suggest people to do if they want to buy an existing business is to hire a CPA, a certified public accountant, to do a whole background study on that business and see if it's viable and there's some fiscal problems, and but also create a separate company to buy the assets from that business rather than buying the company altogether. But if you're going to have a startup, you can do that too. You can have a startup, like you said in your question, but your startup buys assets from the existing business rather than buying the existing business. In that situation, you're just buying the assets, not the problems.
Wow. I think that's wonderfully explained, and thank you so much, Geeta, also for putting this important question. And I'm hoping that Marcelo's advice is going to be very helpful for you. But still, in case if you have any follow up question or any other doubt regarding this topic or regarding the explanation, then please go ahead and put it on the comment section. We will definitely take them up. Moving ahead, I think Krishna is also here, and Krishna is asking a question that let's say I invest a significant amount in a business, but due to unforeseen circumstances, the business doesn't perform as well as expected. How flexible are the E2 visa regulations if my business faces financial setbacks? Can I still maintain my visa if the business struggles? Yeah.
Yes, if your business struggles and you don't meet the goals set forth in your business plan that was presented to you to the immigration authorities to get your visa approved, it doesn't mean that you are unlawfully present in the U.S. You have to leave or any of that stuff. But that's not saying that if you don't operate your business at all, you're still okay to stay in the U.S. So, for example, if your business doesn't have any growth and you don't even sell anything and the business does not operate, you cannot just say that just because the market is tough and you couldn't get around to sell your products, you are not maintaining your visa, your status, if you're not operating the business. But now, if your business is struggling, but you're still trying to make the business take off, no problem there. Even if you can, if you have to do an extension of your status or your visa, or renew your visa, even if your business is not that successful as you thought it would be, you can still apply and you can still renew that visa or extend your status. As long as it's showing that you're trying and the business it has the ability to eventually grow to the point that it's not going to be considered marginal.
Right, right, absolutely. All right, so I think Marcelo, here's another question that I would like to know it from you. That is it possible for an investor to use borrowed funds for their E2 visa investment?
Well, this is an excellent question, and this is actually a topic that has it's been subject of litigation over the years. So the regulations authorize that you use borrowed funds for the investment. However, you have to be responsible for to repay that loan or that loan or whatever, however you borrow the money. The business itself cannot be responsible for that, not even a collateral or a security for that loan. So if you, for example, buy something, you're going to buy a company here in the US, a small business, and you're going to invest in E2, and you go to the bank and say, I want a loan so I can buy a business. And the bank gives you $100,000 to buy that business cannot be secured a security to that loan. There has to be you personally or some other assets that you have. That's not a problem. Even if it's a family member, or even if you buy, for example, inventory of the merchandise that you're going to sell, you buy the merchandise and put that merchandise in the business as an investment. You have to be responsible for that, not the business
Yeah.
at that moment. Because if you really put the business as a security, then the investment is not at risk. The business is at risk. So you have to invest and have the possibility of losing everything. So in this case, you need to be securing that loan or however you borrow that money.
Absolutely. I think that should be there, and being informative, it's also very important. So I think it's very important for everyone, to stay updated and to let everyone knows about the latest updates and what's so happening regarding the E2 visa. It's very important for them. So with that, I think that's very well explained from your end, Marcelo. And there's another question that I would like to know it from you. That how much might stopping sorry, yeah, India is not applicable for the E2 visa, right? So how can a prominent Indian businessman proceed in the case? What's your call on that?
Well, I would suggest to try to see the L1A visa. So the L1A visa can be much better than the E2. Actually, not better, possible, because for
Mhm.
India, only once India has a treaty with the United States, they can Indian citizens can apply for an E2 visa. So the L1 is not country specific. So that one anybody can apply, but that requires a different set of rules. That requires you to have your business in India. You have to have a certain number of employees, three, levels in your organizational chart, so that you are on top. And then you create another company in the US. This company can be your affiliate or subsidiary from the Indian company, and then you get transferred as a international, multinational executive or manager. I've done actually this kind of visa for Indian citizens in the past, but that requires you to have a company well established in India with a certain number of employees, and that you have to have your company very straight with the government so you can show the documentation like payroll, um, uh, how you have your premises, if it's leased or if it's on property. So you have to show all that stuff to the government related to your company in India and create your company in the United States that's going to be receiving that manager. That can be yourself. That's a better option, a viable option, because it's not country specific and there's no minimum investment also.
All right. Also, Marcelo, here's another question: that what type of businesses are considered to qualify for the E2 visa investments?
What are they? I'm sorry, I didn't.
Yeah, basically, I want to ask the types of businesses that are considered qualifying for the E2 visa investments.
So basically, any kind of business will qualify. So before I talked about the ones that don't qualify, they don't qualify, no, they make it a little more difficult
All
to
right.
be. So basically, there's no limitation in the law that any business will qualify for the E2 as long as you can show all the five criteria. And the most important of them is that the investment is at risk. The investment, substantial investment, was made at risk, um, and it's very difficult to do this with companies that provide services, for example, because you don't need to invest $100,000 in a company. Even if the company is going to make millions, you don't have to invest $100,000. There are some ways to do this by securing an office space and pay everything up front so that you can get close to 100,000, or committing to contracts for vendors and contractors, and that kind of situation is going to show that even though you didn't spend the money yet, but you committed to those funds yet already. So that might be a way to go by, but normally any kind of business qualifies for the E2 as long as you can show all the five criteria successfully.
All right, that's great. Okay, and with that, I would also like to know it from you, Marcelo, that what are the options for someone in case if their investment fails while on an E2 visa? I mean, can they reapply for the visa?
Yeah, they can reapply. They just have to make another investment or go to a different business, and they will be able to. It's not bad faith or not fraud or any violation of the immigration laws to fail
Mhm.
your business. A business can always fail. That's why they require that your investment is made at risk.
All right. Absolutely. And most of the people get so much worried about these things that now they failed in the investment. So what else can they do? But I think it's not much to worry because it's just a process. And by being updated and by knowing everything, I think they can reapply with the process. So I think that's another question that we have received from Ashwarya. And I think I should pick up this question. So Ashwarya is asking that are there any changes to the list of treaty countries eligible for the E2 visa? Has the minimum required investment amount been revised? If so, how does it vary by industry or region?
Well, there was the most recent change to the list of countries was Portugal being admitted to the list of treaty countries. So the last one was Portugal. So there was also some projects that didn't go through yet, but they would limit the ability of people applying for E2 visas if they can get citizenship in those countries just by making a small investment or buying real estate. So that's not the case yet, but there's no significant change to the list of treaty countries. You can access this just by Googling. You can just Google E2 treaty countries, and you see the list right away. The first link is from the Department of State, where you have the list of countries there for E1 and E2. Remember, the E1 is the cousin of the E2. But those two visas, not every country qualifies for both. Sometimes they qualify just for the E1, sometimes just for the E2, but most countries qualify for both. And
All
in
right.
terms of the investment, which was another question, the second part of the question,
Yeah.
um, there's no minimum requirement for the investment. The only requirement is that the investment is substantial. To better understand this, imagine that, let's give an example so we can uh, picture this better. Let's say that your investment, you're gonna invest $1 million. So that's the amount that you have to invest. Is that substantial? Most people will say yes, because it's way over $100,000, 10 times $100,000. So that should be substantial, but uh, not quite sure yet. It needs to be substantial in relation to the industry or the type of business that you're going to open. If you say that your business is like an automaker, like you're going to manufacture cars, $1 million doesn't get you started with this business. Doesn't get you anywhere. Not even to develop to build the gate of the facilities where you're going to build those cars. So that's not a substantial investment. But if you say, I'm going to open a small coffee shop, a small restaurant, maybe $1 million is too much. Who knows? So it depends on the region based on the cost to start a business in some regions of the United States versus others. But in terms of being a substantial investment, that is going to be defined by the initial capital necessary, which is established on your business plan.
Absolutely. And I think with that, Ashwarya has also got her answer. And I think let's move ahead with Jitendra. So Jitendra is asking about the do you think specific industries or sectors are more favorable for E2 visa approval this year?
Well, in this year and always, it's like basically those more favorable um, or more favored, I should say, are the ones that you're gonna actually spend the money right away. So let's say you're gonna manufacture things, so you have to buy machinery, you have to buy raw materials, you have to buy supplies. So those in those cases, it's very easy to establish that the substantial was the substantial investment was made and it was at risk because you already spent the money buying those things versus service companies, like I said before. Some others are the ones that are like a distributorship, like you're gonna import products in the United States, so you have to buy inventory. So the first initial investment can be committed at risk if you're gonna buy inventory. So those businesses are always easier for E2 to get approved.
All right. I hope, Jitendra, you got your answer. In case if you still have any follow up, then please go ahead and post them on the comment section. And we will definitely try our best to provide you the best answer and the expert advice over that. Also, you can also consult attorney Marcelo Gondim over there. And I think it would be great if you could directly reach out to him, on the given details, on the given contact details. You can call him on 323-282-770. You can also email him on the given email ID, that's frontdesk at gondim-law.com. And you can surely visit his website, that is www.gondimlaw.com. I think reaching out to him directly will be one of the best advice I could give you in this session, and that will be very helpful for you. So thank you so much, Jitendra, for your question. And here I can see Shraddha's question, so let's take her up. She's asking, can you elaborate on the feasibility and potential risk of an Indian investor partnering with business partner from an E2 treaty country to qualify for an E2 visa?
Well, that's not going to happen for the Indian citizen, Indian investor. They can partner with an E2 investor, but they're not going to get a visa because they're not from a treaty country. So India doesn't have a treaty with the United States. The only, say, since you mentioned partner, if it's another type of partnership, then maybe that would be the case. For example, if an Indian citizen is married to someone who is from a treaty country and they make that investment together, the the person who is from the treaty country will get the E2 visa, and the Indian national will also get their E2 visa, even though they are not from a treaty country. So that's possible, but not business partnership. It has to be a marital partnership.
Absolutely. I think, yeah, with that, I would like to move ahead with another question that Jitendra has asked. And he's asking that have there been changes to work authorization or benefits for E2 visa spouses or dependents in 2025?
No, there has not been any changes yet. We're going to have to see what the new administration is going to come up with. But as a general rule, the E2 derivative, or in this case, the spouse, not just all the derivatives, because children are not allowed to get employment authorization, but the spouse will get work authorization. And it's actually funny that in the E2 visa, the investor has less rights than the dependent or derivative because the derivative has a work authorization to work in anything, including their own business. But the investor can only work in that business and doing what they said they will be doing.
But why is it that the dependents they have more benefits and why not the actual applicants?
Because of the nature of the application. So if the investor is saying, I'm going to invest in this business, the only reason they're getting the visa is because they're going to invest and manage the business. So they have to manage the business. If you allow the main investor to invest, get the visa, and work in multiple jobs, then that business is going to be probably forgotten if they start to work for large corporations and make more money than the business is rendering at the time. But now for the spouse is different because the spouse cannot just be sitting around and waiting for the working spouse to come home. So they need to
Yeah,
also work. So in that case, they can work anywhere.
absolutely. All right, so I think these were some of the questions that we received from our viewers, and we also have a Facebook question. So I think, Marcelo, we can, if you allow, then we can also look for the Facebook questions because they're also a group where most of the people, ask the questions. So I think that will be okay, right? If we are going to take those questions up.
Absolutely. Let's go.
All right. So I think this is the first question that we got from our Facebook group. And it's about hello everyone. My mom will be visiting the USA on a B1 B2 visa. Could you please suggest the best insurance for her? She's 50 years old. Is it necessary to have insurance during her visit? And it's regarding the B1 B2 visa, but that's okay, Marcelo. I mean, would you like to take this up or would you like to pass it on?
Yeah, no, that's fine. You just have to get like traveler's insurance.
Hmm. All right. Okay, I think let's move ahead with our next question. And this is the question that we have regarding the H1B. So I'm on H1B and I got impacted by the layoffs at my company. I had booked a Dropbox appointment for next month to get stamping done. I will have to cancel it now. My question is, once I find a new job, can I use the fee I paid earlier to secure a new appointment or will I have to start all over again?
It depends on the amount of time that you're gonna take from to transition from one to another. So it's difficult to say. If you have the appointment already scheduled for that employer, and then you have to go to another employer, sometimes the consulate might just make an amendment to your application, but sometimes they're going to say no, you have to apply all over again.
Yeah, absolutely. I hope our member got his answer, and I think we should move ahead with our next question. So, I think this question can be skipped. This also can be skipped. I think we should more focus on the E2 visa because that's more important. All right. I think meanwhile the control is giving the question regarding our E2 visa. I would also like to know, Marcelo, from your end, that how long can someone stay in the US on an E2 visa? I think first answer this. After that, we can come back to FB1. Yeah.
So the question is how long can someone stay in the US on a E2 visa? Well, the maximum for each visa is 5 years. Once they
Mm-hmm.
come to the US, they will be given a status. That could be 1 year, 2 years, and they can just go out and come back and renew that status, and or they can apply to extend the status here. But there's no limitation on how many visas you can get. So you can
Yeah.
have a visa for 5 years, get another one for another 5 years, and you can be doing this your whole life. As long as the business is operating and meeting the criteria, you should be okay.
All right. Okay. And I think now we should come back to our Facebook question. So, yeah, here's a question that I would like to read out. That's hello, I'm an E2 visa holder based in the US with natural born children here. Does anybody have insight on what a removal of birthright citizenship would mean for my children? So it's a very latest question that we got. So what's your call on that?
Well, first of all, if this person already has the natural born children in the U.S., they're not going to be affected by this ridiculous executive order that the president issued. This is just for people who are born after that. Okay, they could be impacted. I don't
Mhm.
think necessarily they're going to be impacted because I'm confident that the courts are going to issue an injunction. They probably have already issued an injunction even before we finish this meeting here. because it's
Yeah.
just ridiculous. It's just unconstitutional on its face. I think this is just a political stunt. It's not really something that he is expecting to get traction and to become a valid rule. It's not. So I don't think that's going to affect this person because they already have their children that were born here. But for future babies, if they have babies in the U.S. and this executive order is in place, which I doubt it's going to be, then they might be not considered to be U.S. citizens. These children. I don't think that's going to happen, honestly.
Also, Marcelo, you said that this executive order is ridiculous, as you mentioned right now. So, can we know the reason behind, like, why Trump is about to end this birthright citizenship? I mean, what can be the reasons behind it? We would just like to know that.
It's just that he doesn't like immigrants, and the person behind the administration immigration policies is Stephen Miller. It's not even Trump. I don't know. I don't think he knows any of that
Mhm.
stuff. He doesn't have the capacity of understanding those things. But there's some people that have the capacity, but they're just mean. They're just, unfortunately, I don't like to say this, but they are racist. They are xenophobic, and they just don't want immigrants to come to the U.S. And they cannot stand the fact that immigrants from different backgrounds come here, and when their babies are born, they are now U.S. citizens. So you have a U.S. citizen population that is getting less, that looks less like them than they would allow to be. They would like it to be. So that's their problem. I think it's just racism.
Oh God, that's a lot to process, and I think that's very great of you that you are being so straightforward. So I hope that our audience can understand these factors and they can connect with you more. But also, Marcelo, here's another follow up that I would just like to know it out of curiosity. That as you said, the reasons behind, like, why is he going to do that? So do you think it's going to also somehow limit the illegal immigrants to come into the US? Because his main motive is to stop the illegal immigration, right? And if he is putting up this executive order, this birthright citizenship, so I think automatically there will be less immigrants in the US. And somehow it will also limit the illegal immigrants. So, do you think it's going to be effective towards the illegal immigration concept?
Honestly, I don't, because the reason we have illegal immigrants in the U.S. and people coming through the border, it's not because of the policy of the government here. It's because of the situation in those countries. If someone tells you, if you don't do what I want, we're gonna kill you and your family, and you know that you have that border over there. If you manage to just cross that border, you're safe, you're gonna come. Doesn't matter who's the president, doesn't matter what the policy is. In terms of people illegally crossing the border, let's talk about CBP one.
Yeah,
So
sure.
President Biden came up with CBP one, where the person doesn't have to come to the United States and cross the border and then apply for asylum here once they get caught. They can just apply through the app. They're gonna be vetted before, and then once they give them the appointment, they will come to the border, present the app showing that they have the appointment for that day, and they will be heard according to the U.S. asylum laws. So
Yeah.
that's an orderly way to do things. But in the first couple of hours after swearing the oath, which he's not going to comply with it, we know that, respect the Constitution. He already showing that. So once after hours after doing this, he canceled CBP one. So now
Yeah.
people don't have to orderly apply for asylum. They have to cross the border. Even those who were waiting patiently for sometimes 7 months to a year, waiting for
Yeah.
their appointment, those people are going to feel frustrated, and they don't have a better choice. They don't have the choice to say, okay, well, they cancel my appointment. I better stay in my country then and face those cartels and the economic instability, all the crime, the corruption. They're going to try to come no matter what.
Absolutely. And we also come across to the news that CBP1 app has also banned. I think few days back, yesterday only we got that news. So it's very
Mhm.
sad for those applicants because they most of them they were expecting their schedules were there and they were waiting for their appointments, but somehow they couldn't get into it, and it's very sad for them. But I think that was the only option, right, Marcelo, for them to come to the US legally, and there won't be other option. And
There's no other option. If you come to
yeah,
the US, but the law says if the person is found in the US, it doesn't matter how they got here. If they are found in the US and they have a reasonable fear to go back to their countries because they are part of one of the five grounds of protection under the asylum laws, they have to have an opportunity to present their case, to be heard, and see if they have a credible fear to go back, if they're going to be harmed by going back to the country. It's illegal for under the law for the United States to deport someone that they know it's more likely than not to be harmed just because of their political affiliation, nationality, race, religion, or membership in a particular social group.
absolutely. I think that's very well put up. And I think we should not divert our ideologies towards the other topic because for that we need to have another session to discuss
Yeah.
everything about Trump's administration. But I think that's so good of you, Marcelo, for putting these thoughts up. And I think there are a lot to know it from you, there are a lot to learn it from you. And I think we should come back to our topic that we would like to take up from the Facebook group. So there's a question that hi, I'm an E2 dependent spouse, currently pregnant due on March. Will the birthright citizenship removal take effect that soon, or will it be on hold due to 22 state lawsuits contradicting it?
Well, I'm pretty sure that the judges are gonna enjoin this executive order. So I wouldn't sweat a little bit with this executive order. It's just making people angry and
Yeah.
making some people happy. But it's really a sandcastle. The first wave would take this down.
All right. So I think we can expect something better after your show. That we can expect that something better will happen. But I think with that, we have one more question, and that's about. I think this would be the last one. Can we travel on B1, B2 if we have applied for EB2? Any issue in it? What would you like to say on this?
Well, it's not an issue according to the law, but sometimes the immigration officer might think that you have the intention to live in the country because you're applying for a green card. So the B1, B2, they are non-immigrant visas. They are not dual intent, meaning you cannot have double intention. You can only have one intention, which is to come to the United States, visit, and leave. So if you're already applying for EB2, that might be maybe this person doesn't have the real intent to leave later. They have immigration intent, but that's not the only thing to look for. So sometimes, even if you have an EB2 that is pending or approved, you can still come with the B2, B1, B2 visa, and you'll be admitted normally, unless we see like a tougher approach by CBP during the Trump administration.
Right, right. So I hope he got your answer, and thank you so much for participating in today's session. And Marcelo, we already come across an hour of this session, and I think there were lots of informative pointers that you put up, and I think that was wonderfully put up. Everything, even the political aspects, also we got to know it from you. So that was wonderful, and thank you so much, for joining us. Any last message, Marcelo, that you would like to share with our viewers, especially regarding the people who are applying for E2 visa or those who are looking forward to the E2 visa?
Well, don't have the wrong image of the United States. Okay, as an immigrant and now United States citizen since 2010, I can
Mhm.
tell you that this is not the United States. This is not even the majority of the opinion here. This is the majority of the people who voted, which is the minority of the population. So this is not, and also if you want to immigrate to the U.S., try to look for some of the states that are more welcoming to immigrants. Because if people vote for these politicians because of their rhetoric against immigration, then probably the population doesn't like immigrants either. So in this case, why would you go to those states? So if you want to have a list of the states, it's very simple. Go to Google and type 2024 electoral map. Whatever you see blue, you can safely go to those states. And when you see red, you might think twice.
Wow. I think that's wonderful, and I think that was very important for our viewers also to know about it. And I think that was very well put up. So, thank you so much, Marcelo, for making us aware about these things. Because even I, whenever we mostly used to think about like where you want to immigrate yourself, first thing comes up is US. But I think putting these pointers up that it's not very much important to go to that country where the people are not very much friendly towards immigrants. I think that's very important to know. But also, Marcelo, if there are other countries that you would like to recommend, I mean, would you like to go ahead and share some two or three names of those countries that are pretty friendly towards immigrants?
Well, right now it's difficult to find countries that are really because this right wing movement that is going globally. So I
Yeah.
think the United States is the most favorable to immigrant country, besides having Trump as president now. Other countries like Canada, they are changing their policies as well. Maybe because they don't want people to go to Canada to try to cross the border to the U.S. So they're being forced to be less pro-immigrant because of those including a lot of people from India. They're going to Canada and try to cross the northern border to the
Yeah.
United States. And the majority of border crossing, there is apprehensions in the northern border is Indian people. So it's happening a lot. So Canada is trying to block this by being a little less pro-immigrant. Um, I don't think necessarily the countries in Europe are very pro-immigrant either. A country has that kind of nationalism. They like to
Yeah.
preserve their people. I think the United States is actually the differential in this whole thing, even with Trump as president.
Absolutely. Well, I think that's very well explained, and thank you so much, Marcelo. For your time, for your informative session, and I think it was really great. It's not only me who was feeling so filled up with different knowledge, but I hope that our viewers are also getting to know a lot towards E2 visa, a lot towards the political aspect also. So I would say thank you so much for joining us. We are really honored to have a show with you, and it was a first show. And we really didn't feel like that because you were so much involved into the conversation. So thank you so much for bringing up that energy, bringing up that insightful discussion to this platform. And we are really obliged for your time and for your sessions. Thank you so much again, once again.
Likewise, I'm always honored to be here.
That's so sweet of you. All right, everyone. So thank you so much for joining in today's session, and those who have commented here. I think all the insightful answers that Attorney Marcelo Gondim has given it to you, you feel it very helpful and very informative. So do like, share, and subscribe to our channel. Don't forget to stay connected and stay tuned. And the best part is you can also contact our today's attorney on the given details. You can call him on 323-282-770, and you can also email him on frontdesk@gondim-law.com. And you can also visit his website, that is www.gondimlaw.com. So I think these are the contact details, and you can go ahead and reach out to him as soon as possible. That will be the best thing. And yeah, stay connected, everyone. Stay tuned, and thank you so much once again, everyone, for joining this session. And thank you so much, Attorney Marcelo, for being here and making this session a great one. So I hope to see you soon. And as we are covering lots of details and lots of different topics every week, so stay tuned, stay connected. Meanwhile, me, Sam, signing off for now. So goodbye and take care.
Thank you. Take care.
Hello, everyone, and welcome to today's episode of Immigration and Jobs Talk Show. I'm your host, Sam, and I'm back again with a very exciting episode that is lined up for you today. So, before diving into topic and announcing the name of our guest, here's a very important disclaimer. That is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. All right, friends, once again, welcome back to Immigration and Jobs Talk Show. I'm your host, Sam. And today we are diving into a very important and timely discussion. And the topic is how can E2, L1, and EB5 visas open your path to US immigration through investment? So if you have ever considered starting a business or expanding your enterprise or making significant investments in the US, I think this is going to be a perfect opportunity to explore how the E2, L1 and EB5 visas can open doors to your American dream. And to help you in this, we are honored, to have one of the best attorneys. That is attorney Alessandro Giordano. Alessandro Giordano is a highly experienced immigration attorney licensed to practice in Florida, New Jersey, and New York. He has also dedicated his career solely to the practice of immigration law, helping individuals and businesses navigate the complexities of US immigration. So, Alessandro, first of all, a very warm welcome to Immigration and Jobs Talk Show for the very first time. And it's an honor to have a show with you, and we are really grateful that you are here with us. Thank you so much for joining us.
Of course, Sam. Thank you. Hello, everybody. The pleasure is all mine. I look forward to sharing this important information with you all.
Wow, that's lovely. So, Alessandro, why don't you go ahead and share something about you, like how did you started your immigration journey with our viewers who don't know much about you?
Sure. So, my name is Alessandro Giordano, and I am an immigration attorney. For the past 10 years, I have exclusively practiced immigration law. I am an immigrant myself, and having gone through the immigration system, so to say, I really found my vocation in helping others navigate the, as you said, the complexities of the immigration laws and the immigration journey. And this is why I almost exclusively practice immigration law.
Yeah, I think you were immigrant yourself, and that's why you decided to help, as you mentioned. So I think that was
That's
lovely, and that's why our viewers can connect with you more because you yourself is an immigrant. So I think yeah, that was a wonderful introduction, and now our viewers also got to know about you. So Alessandro, my question, before diving into today's session, I would like to know from your end that how are you seeing the US in the upcoming year under Trump's administration? Do you think there will be a new era for the US people or it's going to be a nightmare?
There will definitely be significant changes. I
Hmm.
practiced during the first administration of President Trump between 2016 and 2020. And I can tell you that things were different compared to the previous administration, the Obama administration, and the current administration, the Biden administration. So I definitely foresee changes. What I can tell you is it's something that all practitioners say, and I would say it's common knowledge that things will be hard for people who are in removal proceedings, people who are undocumented. But what I can tell you is that when it comes to employment-based and investment-based immigration, I have not seen or as many changes, I would say, during the past, the previous Trump administration. So while there will definitely be things will definitely be different for people in removal proceedings, family petitions, and many other things. Hopefully, we will not see as many changes for people who intend to invest in the United States or intend to immigrate through a lawful path, such as investment-based visa or employment-based visas.
All right. Okay. Thank you so much, Alessandro, for letting us know about it, how the future we might think and we might predict regarding these visas. So with that, here's my first question to you is regarding today's topic that how can E2, L1 and EB5 visas open your path to US immigration through investment? I mean, what do you think? What our viewers can expect from today's episode?
So these are three different options: E2, L1, and EB5 visas. Um, E2 and L1, the first distinction that I would make is that E2 and L1 visas are non immigrant visas, which means that they allow you to live and work in the United States temporarily, right? The EB5 is, on the other hand, an immigrant visa, so it will lead to once the requirements are met, to a grant of permanent residency. So these are three very good options for those who are seeking to live and work in the United States, either temporarily or for those who are seeking a settlement in the U.S. for a longer term, permanently.
All right. So, Alessandro, here's my another question with you. Like, this is a question that majorly most of the people, the investors,
Mhm.
they ask for. Like, which visa from E2, L1, or EB5 would you consider most suitable for an entrepreneur, and what are the key reasons for your recommendation?
That's a great question to begin with. So, as I mentioned, the first distinction to make is that the E2 and the L1 are non immigrant visas. So, they will allow you to live and work in the US temporarily, but do not directly lead to permanent residence. So, both E2 and L1 visas can be renewed. The E2 can actually be renewed indefinitely, so long as the business still qualifies for E2, for the E2, and the investor qualifies for E2 status. The L1 can be renewed for a maximum of 5 or 7 years, depending on the type of visa. On the other hand, the EB5 is an immigrant visa, so which leads to a grant of permanent residence, leads to a green card if the requirements are met. Now, that said, the most suitable option, the most suitable visa, depends on one's specific goals. So the E2 is a great option for entrepreneurs from 3D countries, and we will discuss also what that means, what 3D countries mean within the context of an E2 visa. No, it is a great option for those who want to establish or manage a business, grow a business um, by investing a substantial amount of money. And we will also discuss what a substantial amount of money is considered for E2 purposes. The L1 is the ideal option for those companies seeking to expand into the United States. And the EB5 is the option for those with the resources to make a significantly higher investment and who wish to obtain permanent resident to live and work permanently in the United States.
All right. So thank you so much for letting us know about it and giving us a detailed explanation on this. Also, Alessandro, I want to let my viewers know about it that friends, we are live on YouTube, LinkedIn, Facebook, and Twitter as well. And it would be great if you could join us. It would be great if you could post your questions from any of these platforms that you are watching this session in, and we are here for an hour, so it would be great to take your questions up and we will definitely answer them. So, yeah, I think with that, as we already understood about the basic understanding of the E2, L1, and EB5 also. Here's another question that how does the E2 visa allow investors to manage their businesses in the US and eventually bring family members?
So that's what the E2 visa is designed for. So the E2 visa is designed to allow investors to come to the United States and direct and develop, so actively manage and grow their business in the US. Besides that, the E2 investor, can bring his or her spouse, and the spouse can apply for work authorization and pursue employment anywhere in the US. Doesn't have to work necessarily in the E2 company like the investor has to do. And then the investor can also bring children. Children are those, under 21. Children are under 21 that can attend school or college in the US. So I never stress this enough. The E2 visa is temporarily and must be renewed. But if the the business keeps meeting the eligibility requirements, it can be renewed indefinitely. So if the business remains operational and meets the requirements, it can be renewed, for indefinite period of time.
All right. So, also, Alessandro, here's a question that's coming in my mind, and that's a very basic one. Like, till now, we have been discussing regarding visas. But if
Mhm.
we specifically discuss about the business, then is there any business or is there any other options related to business that you would like to suggest to our viewers? Like, this business will be a good one, good idea in US to put an investment to it. Is there any business types or is there any recommendations to it that you would like to tell to our viewers about it?
I would say that again, we have to look at this question within the context of each specific visa, right? Referring to E2s, there is a requirement that the business in which the E2 investor will invest has to be an active business. It cannot be you cannot obtain an E2 visa by making a passive investment. For example, I cannot invest money in the stock market and apply for an E visa based on that investment, or purchase real estate and rent it out as is. That's a passive investment. That's not going to work for an E2 visa. So definitely for an E2 visa, what we're looking for is an active investment. There has to be some sort of a entrepreneurial activity or commercial activity that supports the business.
All right. And would you like to say about the L1 and the EB5 as well?
The EB5, there are two ways to invest, quote unquote. There is one can apply for an EB5 by making a direct investment. So applies it, investing in a new enterprise, or investing through a government approved regional center. So somebody who wants to take a more, I would say, quote unquote, passive role within the investment and just invest the money without having to manage the business can apply through a regional center. These are the two ways that we're, the one can invest for within the EB5 context. As far as L1, really there is no type of business that's more suitable. The L1 boils down to I have a company. There is a company abroad that's seeking to expand in the United States. They're looking to transfer either somebody who has held for 1 year within the past 3 years, managerial, executive, or specialized knowledge, capacity, or role. They're seeking to transfer this employee to work for a sister company, an affiliate company, a parent company, or a subsidiary company in the United States in one of these three roles.
All right. So I think that was a very insightful answer that we got from you, and thank you so much, for putting that up. And let's move ahead with another question that is of L1 visa. So, Alessandro, we all are aware that L1 visa is known for intra-company transfers. So, can you please explain like how a foreign company can use the L1 visa to expand into the US?
Sure. That's exactly the purpose of this type of visa, of this visa classification. The L1 visa enables a foreign company to transfer employees to the US to establish or grow a US branch, affiliate, or as a subsidiary. So the very first requirement, when we're looking at L1 visas, is the qualifying corporate relationship. For example, shared ownership. As I mentioned before, the foreign company and the US company, they have to be their affiliates. They have to be, one has to be parent and the other has to be a subsidiary. That means that one has to own and control the other, or they have to be owned and controlled by the same person, the same company, or the same group of owners. So that's the first requirement. Second requirement is that the transferred employee has served for 1 year in the past 3 years as an executive, as a manager, or as a specialized knowledge employee or worker. And this person needs to be transferred to the US to hold one of these three roles. And the role doesn't have to be the same. So if I was a manager for a year within the past 3 years in the company abroad, I worked in managerial capacity. The company in the US does not have to transfer me necessarily to work as a manager. I could be an executive or I could be a specialized knowledge employee. These are the pretty much the nuts and bolts of L1 visas and how they can help companies, foreign companies, expand into the US market.
But Alessandro, I am thinking about it. Like as you mentioned that the company can. It's not important to have the managerial post only. If a person is manager in this company, then through L1, it's not compulsory to have that managerial post. Then don't you think it's going to reduce the skills because if the designation is not exactly the same, how they are getting in that different nation, with the same company, then don't you think it would be a little affecting the employer in a negative way because the designation won't be the same? So, what's your point on this?
Not necessarily, not necessarily. That's the so there is no legal requirement that the person holds the same role abroad and in the United States. And if, given the fact that there is this flexibility, if the petitioning company in the US decides that that employee is better suited or is needed in the US in that new vest, quote unquote, or in that new role, maybe there is a reason. So I would say that pertains more to business decision rather than a legal decision. From a legal standpoint, we can have somebody who was a specialized knowledge employee in their home country for the company abroad, the foreign company. Maybe they're needed managing personnel or managing, department or a unit or of the company in the US, and that's perfectly fine. How that affects the operations of the US company, that's more of a matter for the US company from a business standpoint, I think.
All right. I think that's very well explained, and I got my answer. I hope our viewers too got the answers. And meanwhile, Alessandro, the great thing is that there are some viewers who has joined us, and I can see Sanjay, I can see Sudhir, I can see Ravi. So, friends, it's lovely to have you all. And do let us know from which platform you friends are watching us right now. And keep on posting a question. It's not mandatory, to just post one question. You can ask follow up. You can ask any question related to today's topic, and we will definitely take them up. But till then, wait for some times. After asking some random questions from my end, I'll be coming back to your questions. Okay, so now, yeah, Alessandro, now I have another question regarding the EB5. So we know that EB5 is more for the green card and it provides the permanent residency. But we want to know more about it. Like, what does the EB5 visa offer other than just a green card?
So I would say that there are three main benefits. Number one, the EB5 investor can live and work in the United States permanently because they're going to get their green card if they meet all the eligibility requirements, and they can work anywhere in the country, and they can you know do any kind of work, lawful work. Obviously, they don't have to work in the business where they invested funds in, like the E2 investor has to do. The E2 investor has to work in the E2 business, in the E2 company. The L1 transferee has to work for the L1 petitioning company. The EB5 investor, once they get their green card, they could live and work anywhere in the United States. So there is that kind of flexibility. Then family, they can bring along the family, so spouse and children under 21. And once they get their green card, they can also work and live anywhere in the United States, right, indefinitely. And they have access to, especially for the children of EB5 investors, they can gain access to US schools and colleges at the same tuition rates as American citizens. Usually, that obviously, you know, depends from school to school, college to college, but that's what I have seen and what the trend I think is. Then number three, after 5 years of being a permanent resident in the U.S., If you meet all the other eligibility requirements, you can apply for U.S. citizenship. These are the three, I think, most important things that EB5 um, option offers more than E2L1, just beyond getting, yeah, I get my green card. This is what happens when you get your green card. You can live and work anywhere. Your kids can go to school at the same rates as, American citizens. Um, and then you can apply for citizenship after 5 years.
Wonderful. I think that's wonderfully explained, with the pointers. So thank you so much, for letting us know about it. And I think it was a great answer. And most of the viewers, mostly think about there's a confusion regarding EB5 most of the time because EB5 mostly they consider for the permanent residency. But now I think after watching this session, they might be knowing more about it. But I have another question that it's just a random thing that what can you say about the visa process out of like E2, L1, and EB5? Which visa process takes more time or maybe less time? Can you just talk
Definitely
about? Yeah.
the EB5, this is notorious. EB5 processing times are way longer. E2, E2, you can apply for an E2 visa in two ways. If you're in the United States in lawful non-immigrant status, you could apply. You could apply for a change of status. That doesn't give you a visa. That puts you in E2 status, right? If you are abroad, you apply for the E2 visa at a consulate. So the processing times depend on the times of the consulate. There are consulates who have higher backlog or lower, more of a backlog or less of a backlog. So it depends. The L1 visa has two steps instead. Well, you could also apply for a change of status, but let's say you're abroad and you're applying, you want to the actual visa in your passport to be able to travel and enter as an L1 transferee. So you first petition, the U.S. company first petitions for files a petition with USCIS, so in the United States. And then once approved, the petition gets transferred to the consulate abroad. So we also got to wait for, consular, for the consular interview or consular appointment. And that depends on how long the consulate will take. EB5, different ball game, very long times, could take up to 2-3 years. But, if you're looking to get your green card and establish yourself permanently in the United States, it's definitely worth waiting.
Absolutely. I think waiting for 2 to 3 years instead of and getting in return for a lifetime
For a life.
permanent residence, and I think it would be much worth it. But I think that's great, and we are getting to know about the visa process also with these three visa categories. So thank you so much again, and.
Yes.
We have, I think let's take a few questions from our viewers because we are getting so many questions, so I don't want to upset them.
Mhm.
And let's take Ravi's question. So, Ravi is asking that my passport is currently under renewal and I have a valid H1B visa stamped until September 2025. However, my I-94 is set to expire on January 12th, 25 due to the passport's expiration date. Once I receive my renewed passport, what steps should I take to extend or update my I-94 to reflect the visa's validity? Can I do this within the US or do I need to leave the country and re enter?
Can you go back to the slide before?
I think, okay, let me read out this another question. And what can I do if my passport is received after my I-94 expiry?
I'm assuming this person is in the US, right? Ravi, I'm assuming you're in the US.
I think Ravi, it would be great if you could let us know where you are actually asking this question in US or some on the other
I
country.
think I
It would
think
be
you are in the US. So the I-94, so this is a general generally speaking, the I-94 is what dictates your period of authorized stay in the US. You have to be very careful what's the expiration date of the I-94. And also if there are very fact specific questions, I would rather address them individually. So I encourage you to give me a call or to contact, an immigration attorney. Um, there's my contact information is right there. because there might be other questions that I want to ask you, and that might play a role into the answer.
And here Ravi answered yes, he is in Denver right now. So I think you predicted right.
Right. Yeah, I would assume so. So seems that there is a 994 that is expiring soon. That seems something time sensitive, very delicate. I encourage you to schedule a consultation. Um,
All right. So I think,
Generally speaking, you can extend your status. You can extend your status being in the U.S., but you have to file, paperwork. You have to wait. So it really depends on what the facts are, what the circumstances are, um, to determine what's best. Because you could, leave and re-enter if your visa is valid.
absolutely. So thank you so much, Ravi, for asking this question. And in case if you still have any follow-up question or would like to know more about any other question, any other topic that you would like to know, then please post them on the comment section and we will take them up. And meanwhile, you can also consult with our today's attorney, Alessandro Giordano. And the contact details are visible on the screen. You can see the telephone number is 973-494-5649. And you can also email him I would like to spell it out. That is AGIORDANO at THECOMPASSFIRM.com. And you can also visit his website, that is www.thecompassfirm.com. So I think it would be one of the great thing, if you could directly ask this question or any other question if you are
Right.
facing related to immigration process. So I think this
Yes.
would be a great one. And with that, I think let's take the another question that we received from a YouTube viewer, and that is from K Vishwanathan. So his question is that L1 visa petition to be filed this month, but mostly after 17th Jan or 20th Jan. What will be the challenges and new rules with Trump administration? What would you like to say?
So it's hard to predict exactly if there will be any new rules. I think that after January 17 or January 20, after when? You know, how long after those dates? I think that's still early in the administration. Maybe it might still be early in the administration to have any meaningful changes. So I would just, unfortunately, that's the only thing that you can do for now. Wait and see. But I don't know if there will be, again, catastrophic changes for these kind of business visas. I've seen, yes, during the past administration, the previous Trump administration, um, adjudicators were a little tougher. I could, I noticed that trend, you know, um, tougher decision making on immigration officers' part. But really, the big changes that I expect are for people in removal proceedings, individuals in removal proceedings, or individuals who overstayed their visas, individuals who are here undocumented. Um, I'm not saying not to worry, but yeah, wait to worry.
Absolutely. And, with Trump's administration, we have also come across that in his first term, he was trying to limit the H1B visas, but now most of his statements, he is actually favoring H1B visa. So,
Right.
H1B visas, people are more into it. But what's your opinion on this?
Yeah, as I said, employment-based and investment-based visas, I have not seen the administration being so tough as in other aspects of immigration. I practice a great deal of not only E2s and L1s, but also EB1s and EB2s. And to be honest with you, I haven't experienced that much difference. One thing that was different was when the travel ban was implemented. So that could affect the ability to travel, but that's not specific to L1 petitions or E2 petitions. That is across the board. Um, only thing that I can say is that we're all, anxiously waiting for these changes. We just need to wait for now.
Absolutely. We can just hope that everything goes smoothly. But
Right.
as most of the people are very much concerned about like what's going to be under Trump's administration, but mostly, we have seen that he has been very stiff towards the immigration. But
Right.
if we look now for the H1B visa, I think that's the mostly highly skilled workers that people need, right? And he's actually in favor of that. So I don't think any other visas like E2, L1, or the EB5 will also going to face some kind of hurdles or problems, regarding this
Yeah,
administration.
that's consistent with what I've seen before. Yeah, they were a little tougher. Administration was a little tougher, but nowhere near other areas of immigration law. So yeah, I don't expect a catastrophe like for other immigrants.
Well, we hope so. And what do you think about the Biden's administration? Was Biden administration more in favor of immigration as compared to Trump's administration? What's your call on that?
I have seen. So I have two takes on this. Definitely more in favor under certain, um, you know, from a certain standpoint, not as tough, not as hard. When it came to individuals in removal proceedings, um, seeking benefits before the immigration court, and even adjudication of benefits like L1, C2s. Yes, not as tough, but also I have not seen this current administration favor immigrants and the immigration system as much as I thought it would. But now it's passed. We have, 2 weeks and we have to move forward and look what's ahead.
Absolutely. And I think it would be a great year, and that's what we can hope. So, good luck to Americans, and obviously not just to Americans, it depends upon the whole globe. So,
Right.
yeah, and, I think with this, Ravi has commented, I will definitely contact you, Mr. Thank you so much, Ravi. And it would be so good, that if you could directly consult with our attorney. And Vishwanathan is also here and saying thank you. Thank you so much,
Of
Vishwanathan,
course, you
for.
guys are very welcome. My pleasure.
Absolutely. And with this, Alessandro, I'll be coming back to our viewers' question after some time. But I would like to continue with another question that's mine. For someone who is considering the E2 visa, what are the common mistakes that applicants make when proving their investment?
That's a very nuanced question. I like it. I will give you first the three most, I would say, common misconceptions of the E2 visa.
Yeah.
First, you know, so that we clarify what the E2 visa is for and for whom it is. The E2 visa, people think that E2 visa is for everyone. Unfortunately, it is not. It is for only nationals of certain countries. Is a treaty investor visa. That means that the U.S. has to have a treaty with your country of nationality or your country of citizenship. Okay, so only citizens of E2 treaty countries can apply for the E2 visa, and it's simple to find out what are the E2 treaty countries. You just Google E2 treaty countries, and one of the first results is the for the website of the Department of State, and they will tell you what the treaty countries are for the E2 visa. So another misconception is that any kind of investment will work for the E2 visa. That's not correct. Um, what I said, as what I said before, the investment for a E2 visa for an E2 visa is to be active, cannot be a passive investment. So many people ask me if they can buy real estate and rent it out as is for profit, and then if this kind of investment is suitable for an E2, and it is not. So an E2 investment must involve some sort of commercial or entrepreneurial activity. So passive investments such as in the stock market or buying real estate and renting it out typically do not qualify. Another misconception is that you know the E2 visa might lead to a green card. No, there is no direct path from an E2 visa to a green card. So if you, after you're here in E2 status, you want to apply for a green card, you have to, seek an independent basis. And you cannot pass from an E2 to an EB5 automatically or directly. That there is no such thing. However, the E2 can be renewed indefinitely if the business keeps operating and qualifying. So you could be here for as long as you want, so long as you keep meeting the eligibility requirements. Now, as far as mistakes when it comes to E2, one of the main mistakes is failing to demonstrate that an investment is substantial. We have to demonstrate that we have invested a substantial amount of money into the E2 business. And then another mistake that I see frequently is insufficient documentation of the source of funds. Remember, when you invest in the United States, this is valid for both E2 and the EB5, but you have to demonstrate that um, your funds, the funds that you're investing, originated lawfully. It's called the source of funds. So we have to thoroughly document the lawful source of your investment. I would say that these are the main misconceptions and most common mistakes when it comes to E2 visas.
Absolutely. And I think that was a great one because it's not just important to understand the mistakes, but also, what people predict and what people think
Right.
with that, what mistakes they do. So thank you so much, Alessandro, and also for letting us know that these mistakes are not common only for the E2, but also for the EB5 visa. So
Right.
I think, it would be great if you could also, the EB5 investors can also look for these mistakes. And with that, here's another follow up question that we received from Ravi, and it is: will having a child born in France provide any advantage in expediting the green card process for an H1B visa holder? What would you like to say on this?
Not directly, not that I can think of.
Okay.
Not that I can
That,
think of.
okay, that's not an issue. I think,
I don't, not that I can think of in the sense, I don't think so. I don't think it will provide any advantage in expediting the green card. No.
okay, I hope, Ravi, you got your answer. And let's move ahead with another question also that I have in my mind. That is, Alessandro, we can say that I want to talk about the entrepreneurs and the business people. So, is it like, can an entrepreneur start a new business in the US under the E2 visa, or do they need to buy an existing business?
Great question. I get asked this question 100% of the time that I have an E2 consultation. People ask me
Right.
all the time, do I have to buy, do I have to start from scratch, or can I buy an existing business and maybe keep it as is or make some changes? The answer is both. Either option is viable. Entrepreneurs or investors who are looking to come to the United States on an E2 visa, with an E2 visa, they can either start a new business from scratch or purchase an existing business. So starting a new business allows obviously more control over the business, but it requires, there are some hurdles to starting from scratch, right?
Absolutely.
Purchasing an existing business offers the advantage of maybe an established business, some maybe operational history, customer base. So from a legal standpoint, both options are viable. You can come to the United States with an E2 visa by both starting a new business or purchasing an existing business. Which one is better for you depends on what you want to do.
Absolutely. And I think that was a wonderful answer. So I hope our viewers got to know that it's not exactly necessary, that to have to start a new business or to buy a new one. It completely depends upon your situation. And if and still you want to need a further clarification, or still you want to personally connect with our attorney, then you can directly contact him on the contact details that's visible on the screen. and that is 973-494-5649. And with the email ID that is definitely, I would like to read it out, and that is Agiordano at thecompassfirm.com. And with the website, you can also visit there. That is www.thecompassfirm.com. So with that, we have another viewers also, and Sanjay is here. So I would like to take up his question. And Sanjay is asking that I am running a successful IT business in my home country, and I'm thinking about expanding it to the US. Would the L1 visa be a better choice than an E2 visa for me? What factors should I consider when choosing between the two?
The very first factors that you want to consider, Sanjay, are number one, are you a national of one of these treaty countries? Meaning you have a passport from a country that qualifies for an E2,
Mhm.
right?
Right.
Not all countries qualify for an E2 visa, right? So if you're not a national or a citizen from an E2 treaty country, your only option would be the L1. So that's the first thing that you want to look at. Number two, the investment. This is something that we haven't discussed, but I would like to touch on it, Sam, if that's okay with you. The
I
difference
think
between
that's right. Yeah.
right, the difference between the investment part, between E2s, L1s, and EB5s. They're
Mhm.
three completely different, type of investments required. For E2, the investment has to be substantial. The law doesn't tell us what is substantial, right? What substantial means doesn't say under 50 is not, over 50 it is, under 100 is not, over 100 it is. No. Usually what I like to see is at least $100,000. So Sanjay, you want to look at, the funds that you can invest. Number one, if you're a citizen of a treaty country. Number two, if you can invest $100,000 at least. Um, those are the two requirements that I look at. Now, circling back to the differences, between the investment requirements, E2 has to be a substantial amount of money. L1 doesn't mandate a specific investment. We just need to show that the company's operations in the US are adequately supported in terms of resources, personnel, but there is no set amount. And for EB5, the EB5 calls for a more significant investment, $1,000,000 or $800,000, depends on where the funds will be invested.
All right. Okay, so here's another question, Alessandro. And with that, thank you so much, Sanjay, for participating. And in case, if you have any follow up question, then please post them on the comment section. And with that, here's another question, that what are some of the challenges and advantages of using the L1 visa to move employees or executives to the US?
Interesting question. So, the first challenge that I see when it comes to an L1 transferee, this is more for larger companies with a lot of owners, right? We have
Yeah.
to we have to prove that there is a qualifying corporate relationship between the company, the foreign company, the company abroad, and the company in the United States. When you have a large multinational company abroad with a lot of owners, it's complicated to prove that there is that relationship. Maybe the owners are not the same in the US. Maybe
Right.
ownership is not the same in the US, right? And that's the first thing that usually, you know, could be challenging when we deal with large multinational companies. And then number two, it's something that USCIS tends to question a lot, and it's the capacity in which the individual worked in the foreign company, right? So this is always challenging, demonstrating the employee's executive, managerial, or specialized role. So we have to be very, very detailed in the description of the duties. We have to be very, very specific. because that's usually a challenging part.
Absolutely. And also, what would you like to say about the advantages?
So the advantages for the L1, I would say off the top of my head, um, number one, there is no minimum investment required. It's
Oh,
not like the
that.
EB5 or the E2. E2 again, as I said, I would like to see at least $100,000. For the L1, there is no such thing. There is no minimum investment amount required. Number two, if you qualify for an L1A, chances are you also qualify for an EB1C, which is a type of green card, an immigrant visa petition that leads to a green card that has the uh, same or very similar requirements to an L1A. So if you have L1A status, you qualify for L1A status, you're here in L1, as an L1A transferee, chances are you can pursue after some time, you can pursue EB1C classification and apply for your green card. So that's the second advantage that I would say. Then number three, you're allowed to bring your spouse and your children under 21. So you can come with the entire family. That's the third
Wow.
advantage that I would say.
I think there are lots of benefits to it, and I think it would be one of the
Yeah.
great, a very safe kind of visa category to invest on. So thank you so much, Alessandro, for letting us know about it and for explaining not I won't say in a very detailed format, but in a very crisp and clear way. And I think with this, you were correct. The short answers are more correct and more accurate to understand. So with that, I would like to continue with my next question. That is, how do E2 visa holders navigate the challenges of renewing their visas, especially if their business is still growing? And what steps can they take to ensure smooth renewals and improve their chances for the approval?
So when you renew your E2 visa, I feel like renewing is a kind of an improper term because you're reapplying for the visa, right? And you have to
Correct.
show exactly the same requirements that you made the same requirements of eligibility that you showed the first time. Just you don't have to invest again because you can use the initial investment, right?
Yeah.
But the renewal success for an E2 depends on a few things. First of all, the business has to show continued operations, right? The business has to still be operating and running. So we want to provide financial records to show that the business is operating and financially healthy, quote unquote. Then we want to show. I like to show that we are employing people in the United States, so job creation. These are usually the main point. There are obviously other requirements, but these are I think that the things where an E2 visa holder that wants to renew his or her E2 visa should be more proactive about.
All right. Okay, and with that, here's another question: that how does the E2 visa allow investors to manage their businesses in the US and eventually bring family members?
So this is what the E2 visa is for. If you are an E2 investor, you're investing in a business in the US, has to be an active and operating business. And as an E2 investor, you're coming to the US to direct and develop the business. That's what you have to do, and that's all you can do. Um, Differently, the spouse can come to the United States as an E2 dependent, apply for a work permit, and work anywhere else. They don't need to work in the E2 business. And then children under 21 as well, they can hold E2 status up until they're 21. They can go to school. They're allowed to study here. So this is
No.
something that's definitely worth considering. I would say it's a great advantage for an E2 family that wants to move to the United States.
Absolutely. And I think it's one of the most good benefit. It's going to be a very beneficial for them as well. So we can see, a lots of benefits regarding L1, E2, and the EB5 as well. Though the visa process are different, but it depends which category they are choosing for. But these three categories have their own benefits. And if we also look for the 2025, then we can just hope that it's going to be beneficial year for these categories too. And I think with that, Alessandro, we have covered almost all the questions. And
Mhm.
with that, we have been left for 10 more minutes. So I think with that, want to take my. Okay, let's take the viewer's question. And here's another question that I have got from Sudhir. That is, if I apply for an EB5 visa and invest in a regional center, how do I ensure my investment qualifies under USCIS rules? Also, what happens if the project fails? Will I lose my visa?
That's a loaded question. So if you're going through a regional center, these centers are pre-approved, so they should already qualify, under USCIS rules. But still, EB5s are very complex and nuanced. So get a lawyer to assist you, even if you're filing to a regional center. Okay. And then what happens if the project fails? There could be an issue. There is a conditional period of 2 years. And after 2 years, you have, after the investment, you have to show that the project is still standing. So EB5s are complex. If you have the intention to invest a large amount of money, 800,000 and up, I would say it's worth contacting an attorney and being counseled and assisted by somebody who has experience with EB5s, because again, it's very nuanced, very complex, and there could be some pitfalls. And you need to be explained all these things so that you can make an informed decision.
Absolutely. I think taking expert advice would be a great suggestion here. So, with that, we have touched Sanjay's question, Sudhir's, and Ravi's question. And Alessandro, we have more questions from our Facebook group, because there also we have our viewers who regularly post questions regarding the immigration topics, that we mostly have our webinars with. So, here's another question that I would like to ask from you. That is, does buying an existing home care facility qualify for EB5?
Overbroad question, I think. There are many requirements to an EB5, many requirements to an EB5. So, you have to invest in a new for-profit enterprise. So a new, commercial for-profit enterprise is one established after a certain date, or if it was the certain date is November 29, 1990. If it was established before, you have to restructure or reorganize it, or make some changes. So it really depends. Is a very fact-specific question. And you need to invest the required amount. And that depends on where you're investing. You need to show that you are creating a certain amount of jobs. So I think that it's hard for me to answer this question based on the very, very, very little information provided.
Absolutely. I think it would be great, the one that who has posted this question. And if you're watching this session, it would be great to have more details. And, it would be better for us, and it would be better for our attorney also to answer your question. So, no worries. Let's move ahead with the next question. And the question is that I'm a Canadian citizen of Indian origin. What is the processing time for obtaining a green card via the EB5 route? Are there any quota restrictions applicable to individuals born in India?
So for the EB5, again, the timings are very, very long. What does it mean, a Canadian citizen? So you have a Canadian passport, but Indian origin. Where were you born? Because the restrictions are for certain nationals. Um,
I think he has been born from, I mean, in India only, and after that, sometimes he took Canadian citizenship.
Right. Right. There is some backlog. And nationals of India are a little, we know that there are some restrictions. Um, but again, I would need to have a little more information to answer this question. To answer this question, there are some restrictions. Most EB5 categories now are current, or they have been current as of recently. But again, I would need a little more information to answer your question. So if there are questions that are very fact specific, I encourage you to, you don't have to. I like that you're posting anonymously. So I'm a big fan of confidentiality. um, but
Right.
if there are, if they're very circumstances or fact specific, I encourage you to shoot me an email and we can take it from there.
Absolutely. I think that would be the great one. And thank you so much, Alessandro, for taking this up and at least letting our viewers know about it, like what they can expect from you. And with this, we have another question that how long does it currently take to receive an EAD and an advance parole card? Are applicants still getting a combo card? Also, are these cards being issued for 2 years or 5 years?
Again, I don't have enough information to answer this question. I can tell you that yes, combo cards are still being issued. It depends. For example, recently I had a husband and wife. One of them got the combo card, the other one got the work permit only, and that got the advanced parole in the good old paper fashion. But yes, combo cards are still being approved, are still being issued. And then it asked if there's being issued for 2 or 5 years. So at times the duration of the work authorization document, employment authorization document, depends on the category under which you're applying. So I would need to know maybe more about the about the
Yeah.
situation.
Absolutely. We completely understand this thing. And with this, I hope this question looks a bit detailed. So let's expect something from this. Control, if you could zoom in a bit so that it will be clear for
Thank
us.
you.
Thank you. Yeah. So it's the question is that good day to all. I have a few questions regarding E2 visa and would appreciate if some experts can provide advice. Firstly, if my spouse gets E2 visa and dependents, myself and kids, gets E2S, can the spouse who got E2 visa switch to E2s subsequently and dependent become E2 status?
I think
Let's,
this question is asking if this person has E2 and the spouse has E2 as a spouse, and then they
yeah,
switch. So the
true.
main E2 becomes the E2 spouse, and the spouse makes the investment. I mean, if you qualify, that's what I'm understanding, but it's a bit confusing to me. um, the way it's posed. If I understood correctly, it would be possible so long as you meet the requirements. And then I see that there is another question. After changing the status from B1, B2 to E2 while staying in the US, how E2 applicants may leave the US and re-entering. So I'm assuming the person enters the US with a B visa, a tourist visa, or B1, B2 business or tourist visa, with a visitor visa, and then change status. So if you want to re-enter in E2 status, you need to go to a consulate abroad and get the E2 visa stamped in your passport. And then you can re-enter with a E2 visa and have E2 status. So you would need to get the actual visa stamp in your passport for E2.
All right. So I think with this, Alessandro, we have completed our Facebook questions too, and I think most of our viewers also got your answer. And it's almost 1 hour, but there's one more question that I would like to know it from you because this is a mandatory one and it's very important to know. So, is there a famous company or entrepreneur who used the L1 visa to enter the US? And how did they ensure that their visa approval and what can others learn from their journey?
I love this question. So
Yeah.
I love this question because many large multinational companies used L1 visa option. Like many large multinational companies,
Yeah.
go have their employees go this route, to transfer them to the US. However, this is something interesting that I actually want to emphasize. The L1 visa is not just for large corporations. Small and even new companies can also take advantage of this option, of the
Yeah.
L1 option, provided that they meet the requirements. Like there is something that is called L1 visa for a new office. So if you are a new company in the US, you can apply for an L1. If you're starting brand new in the US, you're in business for less than 1 year in the US, you can use the L1 to transfer employees from the foreign company into the new company in the US, even if you have nobody working in the US yet. So it is not just for, again, many large corporations use the L1 visa, but it is not only for large corporations. Small companies can use this too to establish or expand operations into the United States.
All right. So I think with this, we have almost reached to an end. And this was the last question that I wanted to know. And thank you so much, Alessandro, for taking this up and letting us know about it. And I'm sure, our viewers loved this session. They got to know so much about it. And the most importantly, I think they got more clarity regarding these three visa categories. And I think most of the people, they were concerned about the complexities and the problems, that is going to happen, that they predict that's going to happen in the upcoming year. But thank you so much to you for clearing that up and, taking all the questions very patiently and answering them. So from my side, I think this session was amazing one. And after all, this was your first time on our show. So I want to know, how did you feel? How was your experience?
I am very happy that you guys invited me. I appreciate the opportunity to be here and to share, all this information with your public. I hope they enjoyed it as much as I did.
Absolutely.
Um, Thank you again. It was a pleasure for me.
Same here. And I think it was truly an honor to have you with us today and, to have this session and to introduce you to our viewers. It was one of the great thing. And thank you so much to our lovely viewers also who participated in today's webinar and asked their questions. And even after this 1 hour that got ended, after this also you can keep on commenting, you can keep on posting your questions. And in the next show that we are going to have with Alessandro, we will definitely take that up. So don't be upset with the fact that we are not going to continue our live session, because soon or the later we are definitely going to come back with another very exciting episode. And that's all. I think it's almost a wrap, and we have reached 1 hour. So thank you so much, Alessandro, for being with us, for sharing such an insightful answers with us. I'm sure our audience loved it, and it was truly an honor to have a show with
Thank
you.
you.
So thank you so much.
Pleasure was all mine. Thank you.
All right. So thank you so much, everyone, for this amazing session. Don't forget to like, share, and subscribe to Immigration and Jobs Talk Show. And we will be coming back with more exciting episodes with different attorneys. And stay tuned. Keep updated yourself by also clicking on the bell icon that is going to visible on the screen. So thank you so much, everyone. And yeah, I think good luck and take care. Bye bye for now.
Hello, everyone, and welcome back to Immigration and Jobs Talk Show. I'm really happy to have you, and thank you so much for joining us. And before we have our guest for today's discussion, and I introduce you the topic of discussion for today's webinar, I have to this very important disclaimer, which I have to read it out. So, yes, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, and on X. So please feel free to, join us by commenting and participate. You can also join us on call, by the way, and this is a new thing that we're doing. And if you want to join us on call, all you have to do is dial this number 425-436-6335, and the access code is 988-888. And yes, once again, friends, I'm very, very excited. And we actually have a very fantastic guest joining us in today's session. So she's going to bring us a wealth of expertise and insight, especially into the US immigration policies. So, yes, we will be, exploring this topic, a very, very timely one, I would say. Merit based immigration. Is it the future of US immigration under Trump 2.0? And yes, with so much uncertainty around immigration reforms, the conversation is more crucial and interesting than ever before. So, yes, I'm very, very thrilled and very happy to introduce you to our special guest, none other than Sophie Alcorn, the founder of Alcorn Immigration Law and a leader in the field of immigration law. Yes, Sophie has been recognized as a 2024 Woman of Influence by SV Biz Journal, a TechCrunch Disrupt Audience Choice Award winner, and she is also the best selling author of Ask Sophie. She also hosts the popular uh, Sophie Alcorn podcast and serves as an advisor in the immigration space. So, yes, without further ado, please help me welcome her back. Hi, Sophie. Thank you so much for joining us today. Really excited to have you and very good to see you.
Hi, Nipasa. It's wonderful to be here on the Immigration Jobs and Talk Show. Thank you so much for having me back, and Happy New Year.
Happy New Year. Yes, our first session with you. So I'm very excited to have you and I'm really looking forward to, for a great 2025 ahead.
Thank you
So
so much.
yeah, Sophie, how are you doing? How busy is it at your end? And what can folks out there expect from today's session?
Uh, Thank you so much. We're very busy. I'm doing well. Thank you. There's a lot of people who have questions, and it's really a changing landscape, and that's okay. It is what it is. It means that I have some answers, but not all answers, because nobody has all the answers right now, because nobody knows, because the whole immigration system is in flux right now. So um, particularly for folks coming into the United States through our high skilled and STEM immigration and startup founder pathways, uh, I mean, it's there's a lot of tumultuous announcements for every immigrant or aspiring paying attention to what's going on in U.S. immigration right now. But for this audience, I do have some hopefully words of assurance to share about the system overall, and that these pathways will continue, and we can get more into those details. There's a bunch of things happening. Obviously, President Trump's executive orders, H1B season coming up, the H1B modernization rule that just got published. So there's a lot of topics, and I'm happy to answer whatever questions everybody to be here.
Thank you so much. Thank you, Sophie. And yes, I'm very excited to have all our folks join us. And we already have some of them commenting. So I would just like to tell all you folks out there to please stay with us because we're going to take up your questions. Hopefully, each one of them will be answered. But yes, a big hello to Rag as well. He says, "Hello, Napasa. Sophie, excited for this episode." Thank you once
Hi.
again, Rag, our very, very frequent viewer. So thank you once again. So, Sophie, yes, I think we will waste no time and get into our topic of discussion. And I have a few questions prepared and lined up for you. So I'll hit on, with the first one. And that is, what changes can we expect, with the shift to a merit-based immigration system? And how do you think this might affect the workers who are selected?
Yeah, great question. So we are not seeing any wholesale shift to a new merit-based immigration system as of yet. We are seeing shifts to the overall immigration system. We've seen the declaration of an emergency at the southern border. We've seen a lot of changes to various law enforcement agencies when it comes to immigration. As of yet, when it comes specifically to employment-based immigration, I have not seen any specific executive orders or changes that directly affect any of the existing visa types. There are many calls to improve the system. So I'm actually a little bit excited and hopeful that maybe after everything shakes out, we'll see some ease of processing for employment-based visas and green cards, maybe new priorities for who we want to welcome into the United States. Some of President Trump's key statements on this issue included last summer when he spoke on the All In podcast, and he said that we should have an opportunity for anybody pursuing higher education in the United States to have a more immediate path to a green card. So that inspired a lot of hope in many individuals. And there was a lot of questions about, is that just campaign rhetoric? Is that one of the things where President Trump is referring to, promises made, promises kept? How will that play out? Because there's several different voices in his administration who all care about this issue deeply in different ways. But a couple of his comments that you can watch on YouTube in the last few days, one of them was on the first day of his presidency when he was signing executive orders, and he spoke about the intersection of potential tariffs and immigration. And in that, I believe he said that he likes competent people. He's familiar with the H1B program, and it's basically a good program. So that is positive news for this audience. And then there was another comment, I believe on Wednesday, where he was at a press conference with technology executives, and the H1B came up again, and the president said something to the effect of, it's great to bring in highly competent people, and maybe we could pair it with training up the American workforce. So that's a very interesting policy development that could be mutually beneficial. There was also some talk about how with potential tariffs, this I believe was in the context of Canada and Mexico, that might encourage more immigration to the United States, and we're trying to build up more manufacturing here. So it could be that the president and his advisors are even contemplating an expansion to high-skilled immigration, and that would be consistent with a very conservative think tank, the Heritage Foundation, and what they wrote about in their brief called Project 2025, which has been a conservative Republican roadmap for policy priorities in this administration. And one of the topics in that document was actually that their position was we need to fix immigration enforcement and fix our immigration process. And therefore, it would help employers recruit the world's best and brightest talent to work here legally on these shores and get here quickly and efficiently. So there's no immediate changes to high-skilled worker immigration that I am aware of right now, this instant, although I'm like watching with bated breath and checking the news all the time to see if anything has happened. But I do see a lot of shifts that could potentially come into play. Some of it could require new legislation. I don't know if that's a priority, but we're definitely, or a priority yet, but we're definitely, going to continue having high-skilled immigration, and it might theoretically get easier within the bounds of our current framework.
Thank you so much, Sophie. I mean, those were some very unavoidable updates, and yes, very recent ones, which, Trump has been making statements across. We have been watching him on news every day, and it's only, I think, day 3 Trump in the office. And yes, so much has been happening. He's signed a lot of things. He has said that he wants to start so many things. And absolutely what you have mentioned. So hopefully, yes, for especially high skilled immigration, or, folks out there who are studying in the US and who are excellent at what they are doing, I'm sure
Right.
it's going to be a little easier for them. And whatever Trump has stated, I think it's also, bringing in like an air of competitiveness,
Yes.
where people are, really going to pull out their socks to be better at what they're already good at. So
I
I
think
think,
so.
yes.
And one of the things that was interesting too was I saw there's two other factors that I'm watching. One of them is Elon Musk, who's tweeted repeatedly about improving startup founder immigration and removing immigration barriers through his work at Doge. And then additionally, I saw an interview from very conservative Republican Senator Ted Cruz of Texas, who actually shared that his father was an immigrant from Cuba who came on an F1 student visa and, found his way through working at a restaurant to pave their family's way in the United States. And so as more of those stories are coming out, it seems like a more broad consensus is emerging in support of high skilled immigration, which is exciting.
Yes, it is. It is. Thank you so much. A great start to our session. And thank you for shedding light again and bringing up those very important updates. So, yes, to Sophie. And this gives me lead to another question that I have, for you. And this is with what's getting stricter, when we talk about checks on companies, whether it's, hiring H1B holders or even site visits for that matter. How do you think that this, stricter checks are going to affect or impact the employers, and what should they really do to be ready for all of these more strict policies that are coming up?
Yeah, great question. So another factor amidst all of this legal shakeup is that President Biden and his administration took several initiatives in the last month, which have also changed the immigration landscape. So one of them is called the H1B rule, and it's the H1B long time. It became 1 week ago, January 17th, and the administration went through great lengths to secure this regulation by very intensely following all the proper legal procedures to ensure that this regulation would have to stand and be upheld, whatever this new administration brings. So theoretically, there are still ways, like if Congress passed a law, that they could get rid of it, or they could create a new regulation after going through another year of paperwork. But for right now, this new H1B modernization stands. And one of the other things that it includes, in addition to making the H1B more accessible and more clear, is that it also includes many mechanisms for stricter checks on employers to ensure that the jobs are being offered in good faith, that there is a bona fide job offer. And indeed, some of the language even shifted from the H1B about the employer-employee relationship to the structure of the bona fide job offer. So that's a new standard that got put into place. But in order to ensure compliance and that the companies do have that bona fide job offer, employers should prepare for potential increased USCIS scrutiny. So that could include things like mandatory site visits. It could include things like enhanced documentation requirements. And it could also involve potential challenges with offsite placements. However, there is specific language in the H1B modernization rule that does take into account that work from home and hybrid work are viable options. But theoretically, the beneficiary who's working from home could have a site visit to their home. So a really important thing to remember if you're on H1B and if your H1B is set up so that you can work from home all or part of the time is if you move, you don't just need to update human resources so that your paycheck gets mailed to your new address and your tax information. But you have to make sure that human resources is working with your company's immigration counsel to potentially update the address on your H1B in case of any site visits. So there's more compliance. Employers should ensure that they have the public access folder for each H1B ready to go in case of a visit. For early stage companies, if you're just like renting a WeWork somewhere, it's really important to make contact with that office, actually visit there, pick up the mail, go in person, get the keys, get to know people, because if there's an inquiry, you want them to be able to attest to how your company is doing business and how it's a good faith job for the candidate. So those have always been requirements, but paying more attention to them again coming out of COVID will become even more important.
Right. Thank you so much, Sophie. And talking about COVID, we also hear that with Trump coming in, he's trying to, implement the Title 42 once again. And he's, trying to make the vetting system more hard. So what do you want to say on that?
Yeah, so this primarily asylum seekers, and it came out of coronavirus and quickly expel people coming in through the southern border. And
Right.
so we're going to see a completely different situation at the border moving forward. There have been at least, this immigration policy website that I use to track what's going on. It has 60 immigration policy actions that have happened in less than 48 hours. So it's an overwhelming amount of changes. It includes interim guidance for civil immigration enforcement. It includes new migrant protection protocols. It includes new sanctuary cities enforcements. It's changing what enforcement they can do near protected areas. It has border patrol updates. So they're really trying to close off the southern border for asylum and refugee entry into the United States. And so I think we're going to start seeing those changes take effect immediately.
Right, right. Also the app, there's a shutdown of the app.
Yes. Yeah, and that app was only for people from a few specific Latin American countries.
EB1 app, yes, right. EB1.
Yeah. So it allowed people with a financial sponsor to like proactively come here with permission ahead of time. So yeah, that has ended. But most high-skilled immigrants have not been using those pathways because for people who get involved in that system, there's a ticking clock. Like maybe you get into the United States, but you're probably going to have a court date and you are here on a finite timeline, even if you can get a work permit. So for people in the high-skilled immigration arena who have a great job at a company, who've worked hard for their education, the H1B and O1 routes and employment-based green card pathways have definitely remained the choice option, because that allows you to actually put down roots and have a life here instead of living in constant uncertainty. So there's, a lot of changes that might be happening, that are happening.
I know there are just too many updates to catch up on, and just under one question. I don't think 1 hour is even enough to keep discussing about the changes that are coming up. So, but yes, thank you so much, Sophie, for those highlights as well. And yes, that brings me to also, I have another question, and that is, since we're talking about H1B as well. So the modernization rule, which happened last week, the 17th of January. So, it's really making headlines. And can you break down what it means for employers and even applicants in simple terms, in short?
Okay, sure. Employers, there's good news for employers. There's streamlined approval processes for H1Bs. There's more flexibility to retain top talent because extensions will get easier. There is improved program oversight, which I mentioned, which is, you should really like review your internal hiring policies, make sure you have comprehensive documentation prepared about any H1Bs or other visas. Definitely now's the time to get an immigration lawyer if you don't have one. And you want to make sure you have strategic frameworks to comply with immigration, as well as clear hiring policies around immigration. And for candidates, some of the interesting news is there's updated definitions of specialty occupation. There's potential to get cases completed and adjudicated more quickly. And there's also benefits for F1 students in the STEM fields and other fields as well for cap gap extensions. So if your employer isn't paying for premium processing, or if there's a subsequent lottery round for the H1B that happens after October 1st and somebody is on cap gap, historically they would have to stay in the US but stop working with a pending change of status on October 1st until the H1B gets approved. But now that date is going to extend until, I believe, April 1st. So folks on cap gap won't have to stop working if they're still waiting for their change of status to H1B. So that's a really exciting benefit for candidates and companies.
Right. And also, how is this going to affect the entrepreneurs? That's my next question. Is it encouraging immigrant entrepreneurship?
Yes, the rule, and this is a large part of my practice, in addition to helping established companies and individuals with self-petitioning employment-based immigration green card pathways, we help a lot of startup founders. And so the H1B modernization rule specifically authorizes many of the things that we've been developing as like our tactics to help founders get approved, but it calls them out. It makes them even more explicit. One of the key benefits is that founders who now own their companies are explicitly allowed to get H1Bs to work at those companies. And so we don't have to go through a bunch of like setup anymore to try to make those companies in compliance. It's just very clear that that type of setup is allowed. And that is not just for startup founders. That also applies to people who want to own consulting firms. And some of the questions I've been fielding show that there's a lot of ways to use this. So one really great option is for somebody already in the United States on an H1B working at a tech company. If you want to start a side job as your own consultancy to be able to take on extra work. Now you can start your own company, maybe an LLC, maybe a corporation, doesn't really matter, but get that set up. And we could get you a 5 to 10 hour a week concurrent H1B in addition to your day job. And that's also wonderful because it serves as a type of layoff insurance, because if you have that H1B going and you get laid off on your main H1B, you're not in a 60-day grace period. You're still in H1B status. So that's been really valuable as we've done that for people over the years. Now that's explicitly allowed. And there is one drawback for startup founders and people in this situation, but it makes sense given the increased oversight and compliance mechanisms. If you own more than 50% of your company and you're getting an H1B to work there, your first 2 H1Bs are going to be valid for 18 months each instead of a total of 36 months. So that is one thing to keep in mind. If you do this part-time H1B concurrent setup for your own company, it's initially going to be valid in 2 18-month increments and then on to 36 months as normal. So that is very exciting for people to have other options.
Yes, Sophie. And one more thing I want you to speak about is, how entrepreneurs can sponsor themselves under H1B.
Yeah.
Another very interesting thing.
Yes. So we've done it a lot. Like a few days ago, we just got another H1B approved for somebody who owns 100% of their company. And it's a wonderful new mechanism that we've had in place now for about 2 years, actually, but it's sort of been under the radar, and we were testing it with clients for a while to make sure it could work. But essentially, if you're a founder and you want to sponsor your own H1B, first of all, you got to make sure you're not working without authorization. So no work at this new company until the H1B is approved. But assuming you're planning the company and doing research and figuring things out, that would be the appropriate time to have a consultation with me to discuss based, because it's different for everybody based on your immigration status, what state you're in, what type of business you want to create. There are different economic, financial, and legal considerations that might affect, the type of company you're creating, and on what timeline, and with what co-founders, and with what funding source and capital or loans. So there's a lot of nuances, but once we get that setup planned, within 6 weeks, we can file an H1B for like part-time employment, or just to completely transfer all in to your new startup. So we do that a lot for founders, and it's really exciting and rewarding every time we get those approved. People are really grateful.
Yes, thank you so much, Sophie. And, that brings me to one of the very important questions I can see in our audience. So I think this is ZQ. So I would like to take this before we head on with our other questions, Sophie. And that is, he's asking, more and more questions are coming up that people are being deported because they have been in the US for more than a decade or dozen years, and still they do not have legal documents. So why don't people collect these documents? Is it so expensive?
That's a really great question, Nipasa and ZQ. There's a lot of people who are economically motivated to work in the United States who don't have a high educational background. And there are many people who are fleeing persecution, and so they're coming here for safety. And although we have an immigration framework that theoretically allows some types of people to get jobs here and work legally, whether they're high skilled or low skilled or able to work because of their, asylum seeking status, the system's extremely backlogged. So, for example, I've had several owners of Mexican restaurants say, I have this amazing Mexican restaurant. We serve Zagat rated gourmet food in the San Francisco Bay Area. We've identified the perfect chef from this little town in Mexico who has a gourmet restaurant there. I've flown there many times. They're an expert chef, but they've never won awards and nobody knows about them. But I want to do all of their immigration right and hire them to bring them here. Well, you know what? It's going to take 4 years to get that person into the United States, and employers can't wait for that. So the system's so backlogged, there's a huge disincentive for people doing it right. And then we've seen such an influx through the southern border of people who are able in the last few years to get work permits that has been in this country. And for the people who are in that situation, very, very difficult to fix your status and to get into some sort of normal, correct status. And so there's just a lot of structural barriers in the system that prevent it from working functionally for people.
Okay, and how do they come in otherwise? There's another question. So why allow them first place and not stop them in the first place itself?
Well, president has decided to do. He's trying to stop me in. And because our political parties have different views about this, and whether they're choosing to value the humanitarian situation or the economic situation, our border has been in flux, and the policies on this have been in flux for several years.
Right. Thank you so much for patiently taking up ZQ's questions. And thank you so much, ZQ, for joining us with your comments. I wish you could join us, on call. To all the folks out there, AJ, Rag, we have ZQ, Vihan, Yash, and Akshay. Thank you so much for all your questions. If possible, join us in call, okay? We are online and the phone number is up there, 425-436-6335, and the access code is 988-888. And also to folks out there who are in a dilemma on what to do with their status or visa, and you want to have a consultation, why not contact, alcorn.law, and you can actually contact Sophie herself, and her phone number is 855 644-2581, and you can even email her. I think emailing will be better, so go mail her hello@alcorn.law, and go visit www.alcorn.law to get to know more about Sophie Alcorn and Alcorn Law. All right. So, Sophie, getting back to our questions, I have more. So, with this new definition of specialty occupation, which we hear is changing soon. So, how do you think, this will affect who qualifies for an H-1B visa?
It's a completely new definition of how the specialty occupation is defined, which is one of the most critical components of the H-1B. And there was a lot of regulatory pushback and back and forth on this in the notice and comment period. And the qualification criteria have changed and potentially in some senses narrowed. And so now there's a more stringent interpretation of what type of degree is normally required for each type of job, because the government is asking to see a logical connection between the educational background and the job duties. And so as we're seeing this push to have the degrees directly related to the specific occupational position, we're all, this has been in effect for like a week. So I'm not aware of any cases that have been adjudicated on the new framework yet, but it's definitely we're gonna see a lot of new RFEs in the coming months, and also especially with H1B lottery season, where practitioners are going to be experimenting with how do we argue that the degree qualifies under this new regulation? How do we get the H1B approved? I mean, the Biden administration's intention in all of this was to make the H1B more efficient and more accessible and more clear. So hopefully, all in all, it will be, overall clarity for people in the field to get H1Bs approved. But we're still seeing how it will shake out.
Yes, we will. And, they say January is just buffer time. The real year starts with February. So I think you can just count in 2 months because the lottery, I mean, the system starts on 1st of April, right? And you have to register before the October, I think, the month of October. So yes, a lot is
Sorry, I was just going to add, Nipasa, that
sorry.
if people have a company that wants to put them in the H-1B lottery, this is absolutely something that we help with at Alcorn Immigration Law. And we would recommend that you reach out sooner rather than later, because we get really busy close to the H-1B lottery. And so it would be better if you reached out now. But in addition to the new benefits for entrepreneurs and people with consulting firms, people who don't have an H-1B yet, who are not being entered in the lottery by an employer, those individuals could start their own companies, even if they're in India or some other country, to create a bona fide job offer, and that new company could put them into
Wow.
under the new guidance.
Yes, that's very interesting. And folks, I think you should not wait too long. And it's the perfect time, to plan your H1B out. So why not contact Alcon Law? And yes, thank you, Sophie, for that update. And that brings me to my next question, which is very much related to what you just said. And that is, if someone really wants to start a new business out there in the US as an immigrant, what challenges do you think they might face, under these new rules? And you think there are still opportunities for them?
Oh, absolutely. Yes, there are new and stricter visa requirements in certain ways, but in some, it's much easier and much more clear than ever before. And so, we can't just do this for a company that got set up yesterday, right? You need to have a business plan. You need to have potential customers lined up, or you need to have investment or loan. The company still has to meet the fundamental H-1B requirement of having the ability to pay any workers the prevailing wage who are on H-1B. So it's really, designed for people who are serious, who have customers lined up, who have investors lined up, who are investing their own capital into the company because they're really, dedicated to setting up operations. And the fact of the 18-month renewal period, demonstrates that there is going to be stricter oversight to make sure that the company is operational and can continue hiring you for the second 18-month period. So I would say the clarity helps, and people who than ever before to get their own H3 company.
Okay. Thank you so much. Thank you so much for taking that up, Sophie. And yes, very interesting how it's all getting and shaping. So there's so much more going to happen. We just have to wait, watch, and stay ready, I think. So thank you, Sophie, for that as well. Now, coming back to folks out there who are students, international students, they're moving from their F1 status to an H1B. What do you think the challenges that they're going to face, especially with these new updates? And how can they set themselves up for success with all these changes that are happening?
It's a great question. I think some of the basics that international students should know to continually, be set up for success, as you mentioned. One of them is probably basic, but I've met a few international students over the years who didn't know this. But if you major in a qualifying STEM degree, you will get 3 years of work authorization instead of 1 year after you graduate. So choosing your major are very, very important. If you are able to secure a job, graduate, please ask your employer into the H1B lottery 4 times. One while you're still enrolled in school, second on your first year of regular OPT, and the third and fourth on your next 2 consecutive years of STEM OPT. Additionally, there are more and more opportunities for CAP exempt H1Bs as a backup option if you're not selected in the H1B lottery. So as you're working with your employer or as an entrepreneur in OPT and STEM OPT, and you're gaining that relevant work experience and you're developing your skills aligned with these, merit-based criteria, there's a lot of actions you can take to secure your future beyond STEM OPT, which can include building up your portfolio of accomplishments for an O1A visa for extraordinary ability, or an EB1A green card that you can self-petition, an EB2 national interest waiver green card that if you're from India, you'll have a long wait time, but at least you'll get a priority date, which is a spot in line. And then the other new development regarding H1Bs is the CAP exempt H1Bs are becoming more accessible. And this is something I'm testing out with some select clients right now. But they've changed the definition. Somebody who is working at a qualifying educational institution or research nonprofit could qualify for an H1B without. So that's a really exciting field to be watching in the coming months and years. And if and when I have more details on success stories, you can follow me on LinkedIn and Twitter and other social media avenues. I have a YouTube channel, and we have our Alcorn Immigration Law newsletter. And so that's where we would be public
Absolutely, yes.
potentially.
So, so sorry, I was getting a call. Actually, it's Akshay. I think Akshay, you'll just have to wait a bit if you don't mind. I'm going to call you back in just a short while. I'm going to take up a few more questions because it's calling my system. No worries at all. Please don't be sorry. I thank you so much for joining. Just be patient a little bit. All right. So moving on, to my next question. So, how do you think, also, about the F1 students? There was an extension. Have you mentioned that too, like from October to the next of April, right?
Oh, yes, yes, yes. So that is the CAP gap. And basically what international students need to know about that is that if they're at the very last year of their STEM OPT, or if they don't qualify for STEM OPT, then the very last time of their regular OPT, the H1B lottery happens in March. You find out if you were selected before April. And so basically this CAP gap thing comes into effect if your end of OPT or STEM OPT will expire between April 1st and October 1st, and you get selected. Basically, as long as the employer files the full H1B petition before your STEM, let's just say your final day of OPT expires, regular or STEM OPT, then you're allowed to stay in the US. And if the employer is doing a change of status, not consular processing, then you're allowed to stay in the US, stay employed at the company, keep earning money. You probably shouldn't travel during that time, but you're allowed to be here. And so historically, if October 1st came around and your H1B hadn't been decided yet for whatever reason, you would have to stay in the US but stop working and stop getting paid. which was a really unfortunate situation for a lot of people. Move that date forward to the future where you don't automatically have to stop working on October 1st. They've extended that range for many months. And so that's just going to help give employers and kids more peace of mind as they go through the H1B lottery process. But definitely do look for options if you're not selected, because there are alternative ways to stay in the United States beyond that
Yes.
as well. I've mentioned some of them.
Absolutely. And, best be guided by an attorney. So why not contact Sophie Alcorn herself also, and Alcorn Law, because they're going to be able to guide you as well. What suits you best, because who knows, you could be extraordinary and you could fit in very, very well in an O1 as well. So yes, look out for your options. And thank you so much for
Yeah, and
joining.
occasionally,
Yeah.
oh, thank you. I was just going to say, occasionally I get to have those conversations when an employer and employee contact me about an H1B, and I get to surprise them and say, "Did you know that?" And they're like, "What? That's amazing." So there could be surprises. It's fun.
Yes, and surprises are good. I think, yes. So, yes, thank you so much, Sophie, for, highlighting that as well. So, why not? Look out for your options always. Sophie, I think we will take up some of our questions from the audience. And to start off, I think we should take up Rag's question. And, Akshay, you can call in just right after Sophie answers this. So, Rag's question is: what is your latest guidance for L1A? Recollect your previous advice of smaller firms facing more scrutiny.
Well, thank you, Rob, for this episode as well. I appreciate it and your memory. Okay, so my guidance is that under Trump 1.0, there was more scrutiny for L1s, especially for companies with less than 10 employees abroad and less than 5 companies in the United States. There was no official rule about that got published. That's just my sense based on my experience at the time. On the last time I chatted about that on this show, I suggested that, we don't know if we're going to have a return to that in this Trump 2.0 administration. Still too early to tell, but my initial response is it's less likely that we're going to have a return to that, given tariffs, the importance of U.S. manufacturing, and President Trump's statements that we want come to the United States and that immigration will be essential for that. So I'm hopeful that the L1 will remain more accessible in this administration than the prior. That's a great question. Thank you.
Thank you, Rag, for joining us. He's one of our very frequent viewers, and we're always excited to have you, Rag. Thank you once again. And we have Akshay on call, actually. So thank you, Akshay. Hi, Akshay. You can speak now. Sophie's here too.
Yeah, hi Nipasa, hi Sophie, thank you for doing this. And I just had a couple of questions. Like you had said, even if you're outside of the US, you can have your own company and then try for the H1. Can you just explain a little bit about that?
Thank you. Yes, absolutely. Thank you so much, Rod. Great question. So the companies that are allowed to sponsor people for H1Bs have to be US companies. But anybody in the world in the United States. So let's say somebody is in India and a new US company, they might already have a company in India, in which case it might make sense to have a US subsidiary that they might create with a tax advisor or a corporate attorney. It could be their first company, and it could be a startup, in which situation they might simply choose to use an online service like Stripe Atlas or Clerky to set up a US Delaware corporation. Or it could be your very first consulting company, and you work with an attorney or tax advisor to set up an LLC, perhaps in California, even if you're in India. To having that company, once the company is set up, it will need a federal employer tax identification number. It will need a bank account. You will need to transfer money in to show how you're going to create initial operations. You're going to need some sort of business plan or client base or letters of intent or investors showing that there's some, work to be done. And then we've been very successful at getting the very first employee an H1B at a company that just started operations. Now, most of our clients are funded technology startups that have raised hundreds of thousands of dollars of venture capital investment, but also from time to time, I've represented people with smaller companies, with consulting firms, where they're getting it off the ground themselves. And so a lot of this setup can be done remotely from overseas. And once we have the once we have the company properly established and meeting all of the compliance requirements, then we can initiate the H1B process, either through the lottery, if it's somebody's very first time. If you had an H1B before and there's remaining time, we could transfer it to this new company. If you're already on an H1B, we could set this up for part-time concurrent employment. And if the lottery doesn't, it's great timing right now for the lottery, but if the lottery doesn't work out, then we can explore some of these new cap exempt options, which could involve, one example could be like a university affiliation with a US college or university. And then I'm exploring new pathways there to see if we can help entrepreneurs get their H1Bs approved any time of year with no lottery based on those types of routes. So it's an exciting time. And if you're interested in entrepreneurship, I would definitely, urge you to consider it further. And you're welcome to reach out to the number Nipasa provided or email and at alcorn.law. And we're super happy to help you explore that.
Yeah, thanks for that explanation. And the other question which I had was I'll be applying for an F1 visa for this coming fall. So if I travel to another country, for example, like Singapore, and set up my appointment there, would that be any issue other than Mumbai, because the wait times for Mumbai are very high?
Yeah, and I don't know how those are going to change over the next year. So you'll just have to pay attention to each consulate, because Singapore might offer that right now, but each consulate can change their guidance at any time about which third country nationals they're willing to accept for visa interviews. So theoretically, that option should remain available, but it would just be something that you would want to definitely check. And maybe there would be a different consulate that would be better for some reason, but the wait times are continuous. We saw a bunch of State Department senior officials resign first day of President Trump's administration. That could expand, and the Biden administration hired back a bunch of contractors who had resigned 2.0, and that was how they were getting through the post-COVID visa backlogs, which they're still visa, but those might extend their career. I think to be prudent, everybody who needs a visa should just be aware that there might be persistent backlogs until the border crisis is determined to be clear, and then potentially there could be a renewed emphasis on high skilled and clearing up the consulates. But for now, it's safe to plan all your travel with the assumption that there are probably going to be delays, and you might have to look for alternative consulates, which could change at different times.
Great. Yeah, that's awesome. And also, I can explore the option for entrepreneurship while I'm on an F1, right?
Yeah, but you can't work without authorization on an F1, and nobody in their first year of F1 is allowed to get a work permit unless there's some sort of extreme financial hardship situation. But on an F1, things that legally students can do to explore entrepreneurship would be taking classes in entrepreneurship through their university, getting curricular practical training for paid or unpaid internships, using part-time or full-time pre-completion OPT to legally work on their own startup before they graduate. But you have to get permission from your school to do those things. But there are many, many ways to do it, which is exciting.
Yeah, thanks for the help. Yeah, thanks, Nipasa.
Thank you so much. Thank you so much, Akshay. And I hope you've got all your answers. And thank you so much, Sophie, for patiently taking up Akshay's questions.
You're welcome, Nipasa.
Thank you, Akshay, for joining us on call. That was actually very nice. We hardly get callers on, so it's very nice when we have one, really. So this is real time, and it's really nice wherever you joined us from. Thank you once again. And now I think we should take up more comments. But yes, I think we'll take up one of Rag's last question. Does premium processing invite RFEs off late? He's asking.
Mm, depends on the case type. I've not seen that for H1Bs. The scrutiny on EB2, NIWs, and EB increased, but most of my clients still use premium processing because we're very, judicious about who we accept as our clients. But we have seen delays in premium processing as well, such that the agency takes longer than the 15 or 45 business days. And if so, the title refund of a $2,805 premium processing fee.
Okay. Thank you so much, Rag, for your question. And, we have more questions, some of them on our YouTube channel, and one more actually from my WhatsApp. Thank you so much for, coming in and asking your question. So, Control, if you can display it, please. This is Osman Boy from Gambia, and I'm a PhD student in pharmaceutical science at the University of Mississippi. This is my second year, second semester. I have tried to apply F2 visa for my spouse who has no bachelor's degree, but she has advanced diploma in science working as a junior school teacher. She was denied F2 visa under Section 221G in December 2023 due to missing marriage photos. In January 25, she was denied under Section 214B. I want to buy a property in her and my name so that we can have one shared property. Secondly, all her parents and family are in our home country, and my family is also in our home country, although I lost both my parents. I'm sorry for your loss. I want to reapply, but I am still wondering what to do to convince the consulate officer. So, Sophie, what do you have to say?
Okay, so thank you. And I'm sorry to hear about the challenges you and your wife have been having with this. They can be quite strict with these. So 221G is basically when somebody doesn't appear to meet the eligibility requirements. 221B has to do with failure to establish non-immigrant intent. So these are very common denial reasons. I think, you're also asking how to get her here to buy the property. But one thing is, people in the US people outside of the US are allowed to be property owners inside the US. But if you buy a property in the US under her name, which you could legally do in the US, that would be further evidence of immigrant intent, which would be challenging. In this situation, it might be best to apply for a completely new type of visa that's dual intent, such as an H1B. And so, this would take a longer discussion about your wife's educational background and her skills and where she could get a job and what company could sponsor her. But theoretically, an H1B, which is dual intent and doesn't require if she can find an employer or company and go through the process and come here to pursue work, that could be an alternative way for her to come to the United States. And if she did that route, then if she already owned property in the US, it would be okay prior to her coming, because that wouldn't be a bar to the H1B.
Okay. Thank you so much, Osman, for joining us with your question. I hope you've got your answer. Thank you, Sophie, once again. Let's move on to our next one. This is on YouTube, Sophie. I'm sorry if I'm rushing, but I do hope you
this might have to be our last question because we're almost
okay.
at time here.
All right.
I can
Sure.
do more. I love everybody's questions. It's great.
Okay, then let's just take one more from, or let's just wrap it up, because since we are talking about our topic today, and maybe if you could just tell us, for someone planning to apply for an H1B visa soon, what should they start doing now to make the process smoother with all these new policy updates, and it'll be really nice to help folks out there.
Okay. Figure if you want to be in the H1B lottery this year, now is the time for the company representative to have a consultation with the law firm to ensure that all the documents are in order and we can get the case filed on time in the next lottery cycle. That's the critical one thing at this juncture. If you're applying for an H1B without the lottery, then the main thing is make sure that the future company has the right setup, has the ability to pay. But in any event, talking to an immigration lawyer sooner rather than later is important. And of course, we would be happy to help you. So thank you so much, Napasa.
Absolutely. Thank you so much, Sophie, for taking time out and spending it with us, making this session so insightful and enlightening to so many folks out there who have joined us. And also for patiently answering not just my questions, but also some of our viewers' questions. So I would just say thank you. And if you have any end notes, to wrap up this session, it'll be great to say if you have anything, especially, with regard to what we have been hearing. There have been so many protests also about too many immigrants coming in, and what about Americans and their jobs? So if you can just say wrap it up along those
Right.
lines. Yes.
Well, I think that probably a lot of people at companies listen to this, and a lot of people who are immigrants or aspiring immigrants are listening to this. And so I would just encourage you to remain steadfast. The US is a nation of immigrants. We are a country that's about making money and leadership in the world. And so if you have the skills to help us contribute to that mission, the United States will welcome you. So please, if you have that dream, don't give up because of the rhetoric that you're hearing. You're very much welcomed here. And there's many routes to finding your way that legally exist and are very stable that you can rely on. So please don't give up on your dreams. We're happy to help.
Thank you. With that, I would say thank you once again, Sophie, and thank you to Alcon Law, for participating with us and helping us have this very smooth webinar. And I hope to see you soon again when you have some time to join us. So, Sophie, thank you once again.
Thank you so much, Napasa. Thank you to the show. Really appreciate being here on Immigration Jobs and Talk Show.
Thank you. Have a great day, Sophie. All right, folks out there, thank you so much for joining us. I really hope that you resonated with this session, and I hope this was very helpful for you. Do not forget to like, share, and subscribe to us. And if you have people or friends out there who would really love this content, do not forget to also share with them, and yes, comment. So also sorry, folks, if we couldn't take up your questions this time. Some of you, I'm so sorry, but we will hopefully address it in some of our other webinars. And thank you once again for joining us, each one of you. Rag, AJ, Akshay, also thank you so much for joining us on call. It was really nice having you, and lovely having you all. So stay with us because we have so much more updates here on Immigration and Jobs Talk Show, and also another very important session lined up at 4 p.m. Eastern Time with my co-host Sam, that is Daily Immigration Dose. So until then, keep watching our space and have a great time ahead. Bye-bye for now.
Hello and welcome everyone to Immigration and Jobs Talk Show. Today, we have another very exciting episode that is lined up just for you. I'm your host, Sam, and before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not a legal advice. So, use of information is at your own risk. All right, after this very important disclaimer, I would also like to tell you that, friends, we are live on YouTube, LinkedIn. So do comment there and let us know what your questions are. As today we are going to explore a very interesting topic, and that is about DHS has announced about the new H1B final rule. And today we are going to explore what the employee and what the employer should take advice on and how the future will be. So stay tuned and watch this session till the end. And meanwhile, I would also like to tell our viewers that today we have a very like enthusiastic attorney who will be joining us today, and she'll be back again with us after quite a long time. So please help me in welcoming our very special attorney, Attorney Uma Mantravadi, one of the highest experienced attorney in the field of immigration. So first of all, Uma, welcome back again to Immigration and Jobs Talk Show. And how are you feeling? I mean, what was all this about? How was it all going? And did you miss our viewers, or how was it?
Well, thank you for having me back, Sam, and the whole team from Immigration Job Talk Show. Yes, I did miss some of the segments we were having, the interesting interactive segments with our viewers, where, we get a lot of questions from our viewers, and it also, kind of incites people like me when I give the podcast, with the information. So it excites us to go back and get more information, get more current information, so that we can give this information out to our viewers, which can help them to regulate the path of US immigration.
Absolutely. And I think with that, our audience also, they also missed your insights. And I hope today our friends are very much happy that they are having this another amazing session, that will be very insightful and very timely topic that we are going to talk in today's session. But Uma, before delving into our today's topic, I would also like to know your views on Trump's administration, because as there are only few days left with Trump to come into the office. So what do you think how the future of US will be under Trump's administration?
Well, looking at the history between 2016 and 2020, he didn't do a whole lot about illegal immigration or deporting a lot of, millions of illegal immigrants who were in the country, even though that was his priority, dealing with illegal immigration, stopping the people from coming in from the southern borders. He was going to build a wall there with the help of the Mexican government, but none of those happened. But what really happened was the H1B was much more tougher. We saw a lot of RFEs for H1s during the Trump administration, 2016 to 2020. We also saw a lot of toughening of the rules for student visas. A lot of students were put through a lot of frustrations, which was really not necessary. So we are expecting a lot of new executive orders, regulations. Again, these are internal regulations. This is not going to be some laws passed by the Congress. There will be some that is going to come up. There is one right now pending called the Larkin-Riley Act that is currently pending in the Senate. So we may see some of those come up. And now that President Trump has got the complete support of the House and the Senate, as opposed to what happened in 2016, I think we will see much more toughening rules, laws, regulations, policies, executive orders. I think we can expect a lot more than what we expected in 2016 through 2020. And having said that, on the other side, we also have the eminent businessman, Mr. Elon Musk, who is completely in support of the H1Bs
That's
or
right.
L1s or TNs or E3s. So, he is going to be supporting that because he regularly uses a lot of H1Bs in his companies, in his businesses. So there's going to be some kind of balancing that may come out. We have yet to see that, but again, he is one person, but then the mega is opposing. A lot of senators, congressmen are not in favor of H1Bs. So will they completely take out H1Bs? I don't think that's going to happen. Will they increase the number of H1Bs? There is a possibility, but we don't know how much of a position is going to come about on that. But Elon Musk is definitely in favor of H1s, and if possible, he would implement anything to increase H1s, but not take it out. So
Absolutely.
with all this discussion, I'm pretty sure after Jan 20th, we're going to see a lot more discussion in the Congress, in the White House, and I'm sure the president is going to look at it much more carefully than he did in the first term. He's made a lot of promises to the people who've elected him again, and a lot of it was on the premise of immigration. But of course, it's all about closing the borders, stopping illegal immigration, deporting a lot of criminals from the United States who are immigrants, and which is why the Larkin Riley bill came in, because a family was killed by an illegal immigrant. And of course, nobody wants things like that to happen. None of the immigrant community is supporting that. But it is definitely something we should not promote any immigrant coming from any country to come here and commit a crime, because one, they're getting an opportunity to come here and improve their lives, and they should keep that in mind and not commit any crimes, whether it's small or big. I would definitely not, do that. So, let's see.
Absolutely. And I think that's very well explained, Uma. So, firstly, I was about to ask this question about the Elon Musk, like what influence he might have with Trump, and that you already answered. Because there's so much, that's going on, because Trump has been very much firm about his statement that he's not going to be more lenient for the H1B workers. But on the other hand, his new friend, Elon Musk, is more into the H1B workers. So,
Correct.
now people are very much confused and very much concerned about like how Trump is going to handle all these things. Because now internal, some confusion, some conflicts also we can see, like Mega versus Musk. So there's a
Yeah.
lot to go, and we can't predict right now what's going to happen, because let's see what Trump brings up, and we hope that whatsoever comes, that will definitely benefit our immigrants, and especially the H1B workers.
There's also,
So
I don't know if
thank you so
you,
much, Uma, for this.
yeah,
Yeah,
there's
please go
also
ahead.
a lot of uproar from the farming community, especially from Florida, where the farmers are saying that if you deport all the illegal immigrants, we won't have any daily labor farmers who come and work for us. And, we would be facing a lot of problems finding daily labor who can actually come and pick vegetables or strawberries or oranges. So you've seen that uproar as well, where people are not very happy if they're going to deport everyone. So there's got to be a balance that the government is going to have to come up with. They will have to, see how to first of all stop the illegal immigration, and maybe promote more of legal immigration, maybe allow more um, agricultural workers to come into the country legally to come help the farmers in the United States, and also at the same time the specialty occupation workers who work, whether it's with IBM or a Microsoft or a Tesla or an AT&T, there is going to be demand for these specialty occupation workers, which is going to be the H1. So I have a gut feeling that Elon Musk is going to play a major role for the president in making his decision. A successful businessman, both the other businesses that he's done, I have a gut feeling he's going to have a tremendous influence on the president, So let's hope that it plays out that way.
Absolutely. And I think that's very well put up. So I think that's a very good brief, that we are getting to know about how the Elon Musk might influence Trump's decision. So with that, I think thank you so much, Uma, for letting us know about this. And with that, without any further ado, I think our viewers are waiting to know what DHS has announced in the H1B final rule and how is it going to affect the employers and the employees in 2025. So, Uma, here's my first question to you: that what is the final rule of H1B that has been announced by Department of Homeland Security?
All right. December 17th, 2024, the DHS announced final implementation, which they have been long discussed about and awaited anticipation of the H1B modernization rule. This is called modernizing H1B requirements. They're providing flexibility in the F1 program and the program improvements affecting other non-immigrant workers. And believe it or not, it's going to take effect tomorrow, which is January 17th, 2025. This was published in the Federal Register on December 18th, 2024. And this has been long awaited by both the Republicans and the Democrats. And, less than 4 days away before President Trump comes into play, we are going to see the long awaited rule that is going to come into place starting tomorrow. So that is something I just wanted to give a basic, background about it. And the changes will be, they're going to revise the definition of what is a specialty occupation of qualifying degree fields to meet the eligibility requirements. And the degree must directly relate to the job duties, but it's not always going to be necessary as long as it's sufficient to meet the role. That every word to word doesn't have to match the job requirements, but at least if the majority of the requirements are met, then it would be sufficient for the role. And the other thing they're going to do is the policy of deference to prior approvals. In the past, the USCIS adjudicators were directed that they don't have to really defer to the prior approvals, but now they are going to give that deference to determine prior approvals involving the same parties, meaning the same employer and same employee. Whenever there's going to be any H1B extensions, it would make it much easier for the H1B employer to go ahead and get the approval. If they can show that they've had a prior approval for the same beneficiary, I think that part is going to be definitely something we will be able to benefit from, the employer and the employees. And there's going to be also some updated lottery and integrity provisions. The DHS is again committed to strengthen the lottery process to prevent multiple registration. Sam, as you've seen, even last year, they allowed people to file from different employers, but the same employer with different companies could not file the multiple H1s. And a lot of employers who did the multiple filings, their H1Bs were actually revoked. the USCIS. I'm even seeing right now the 2025 lotteries that were picked up, and I have seen people getting a notice of intent to deny, notice of intent to revoke, where they have filed multiple H1. Of course, this again affects the students, because they're neither in a student status now, neither in an H1 status. So their life is in a limbo when the employer does that. So employers really, really have to be careful and not attempt these duplicate filings, even if they have multiple companies. So these are some of the basic things that are going to come up. And one of the most important thing that is going to be is the third party work sites. In the past, in the last, I would say a few years since 2022, USCIS was challenged with a lawsuit by IT Serve, which is an organization of IT companies in the United States, saying that you cannot challenge an H1B working at a third party work site based just on a memo. And that challenge went to court, and the court agreed. And so USCIS had compromised, settled on that, and said, okay, we're not going to question the third party work site. But now this has come about as a regulation, the modernization rule. So the USCIS is now going to implement this, meaning if, there's usually an employer, there's a vendor, and then there's an end client. There can be multiple vendors also, Sam. There can be two, there can be three, there can be four. And then there is the end client. So they want to get, employer has to make sure that they have a letter from the end client or the vendor showing proof that this beneficiary is going to be working at IBM or AT&T or Coca-Cola, wherever they're going to be working, that they have proof to show that they've actually got a confirmation from the vendor or the end client that they will be working at that location. There's going to be quite a lot of FDNS, work site inspections. You're going to see a lot of ICE or FDNS workers actually coming to the third party work site or to the employer work site to make sure that there is a bona fide job for the employer. There's going to be site visits, and this is going to be happening with this new regulation. So the employers need to make sure that they have a bona fide job before they even do the registration. Now, Sam, you might say, Uma, this is going to be difficult because, we do the registration, the employers do the registrations in March, and the employment doesn't begin until October. True, that may be, but the employers have to be more careful in ensuring that they actually have a job for this individual, whether it's going to be in-house, software development, project development, or they have an actual employment for them. So, maybe they need to start marketing for their employees ahead of time, make sure that they have a job offer. So this is something we're going to be seeing more, which was happening prior to all these, things happening.
Right. And I think, thank you so much, Uma, for that detailed explanation. And I hope our viewers got to know that there's lots of changes, that we can see in this year. And especially for the H1B workers. In fact, lots of difference also how earlier it used to be and now. So, Uma, as you already mentioned about specialty occupation, and you said that it shouldn't be a word-to-word requirements, for the employee. So, do you think it's just your personal call? I would like to know about it. That do you think it's going to benefit the company? Because if it wouldn't be the word-to-word requirement or the skills that's necessary for the employer, then how is it going to benefit the company, or is it not going to benefit the
It would
company?
benefit.
What's your call on
It
that?
would definitely benefit the employer. Let's say you have a mechanical engineer who's going to be doing an IT job, but the mechanical
Yeah.
engineer has done some certifications, has worked in the IT field for several number of years, has had a lot of certifications, whether they've done Scrum Master or SAP certification. They
Yeah.
actually did not have a complete education in IT. They don't have a master's or a bachelor's in computer science, but they have, even in their engineering courses, taken basics of computers, CAD, CAM, whatever they've done. If we can focus on those educational background and a work experience, they should be able to benefit from that. Sam, as you know, no matter what the job may be, you're not going to find an exact fit for the job. Most employers are
That's
going
right.
to, in a practical world, try to find somebody with both the educational background as well as some experience. I know there's going to be a lot of students coming out, with maybe just 3 months of experience with an OPT or a CPT. Yes, you will see those also, but majority of the employers are quite happy as long as they know that this employee can function, can do the project, based on their interviews if they're happy with them. So most employers are going to be hiring those people once they are happy with their background. In a practical world, the immigration world is entirely different. We don't. That's not a practical world.
True.
I'm just
Absolutely.
I'm just
There will
being
need to be
sarcastic
more
about it.
documentation. No, but I think that's very true also, because if we take the thing of the employers and the hiring process, it's completely different. And if we talk about the immigration world, it's lots of differences there.
Correct.
But I think, yeah, that's right. And I think also, Uma, I would like to ask the another question from you. That, as you mentioned, everything, the changes that we are going to see in the H1B final rule. So, do you think it's going to be easier or harder for the employers to hire the H1B workers after these changes?
In a sense, yes, because of the third party work site visits that's going to happen, and also the requirement that you have to provide from an end client. Now, a lot of times, let's say, your vendor, it's Coca-Cola, but then your end client is IBM. Coca-Cola couldn't give a damn if USCIS is asking for an end client letter or a vendor agreement, because they don't care. They're too big to even say, we care about making sure that your H1B is approved or not approved. Sometimes their attitude is, we don't care. So that's where the employer is going to face some problems, because these guys are too big to be bothered by little things like giving a letter, or providing any kind of contracts with the third party, which is confidential. They may not be so inclined to provide this information to an H1B employer. So the employer is going to face some issues on that unless they educate their vendors and the end clients that, hey, we're going to face these problems. So we want to appraise you of this, and maybe you guys can work with us. Maybe that'll help the employers to avoid having any FTNS site visits, or any kind of RFEs or denials. So yes, it's going to be slightly a challenge for the employers and the employee, of course.
Absolutely. And I think it's very much expected, because Trump is here and Trump is going to rule in this year. So it's definitely going to be challenging a lot for the H1B workers. But I think, Uma, it won't be any restrictive kind of thing for the H1B workers. It will be more challenging.
Yes.
as compared to the
It's
previous.
always,
That's what we can
year to
expect.
year, every year there's changes, some for the
Right.
good, some for the, bad, when I say bad, bad from the perspective of an employer. But changes are inevitable no matter which field we are in. Regulations are going to be, coming about. We also have to look from a perspective from the USCIS and the DHS, because there are a lot of employers who commit fraud. They abuse the system. And because of such abuse, we see the regulations being changed from year to year, from time to time. Uh, so we can say partly it's the fault of some of the bad eggs or the bad employers who create these kind of problems. So maybe there should be an education between employers to have some kind of education to say, we all need to comply with these regulations. We all need to make sure we have a bona fide job for this employee. We all need to pay the wages as per the LCA, because we see a lot of complaints coming from employees saying my employer has not paid me for 3 months, or they're not paying me as per the LCA. So where do we go? And we see a lot of employees filing complaints with the Department of Labor. So all these aspects bring about more changes in the regulations. So this is something, when I say we have created, meaning the immigrant community, employers, whoever is doing this, is creating the problems for other employers. There are the good ones who are, who got the genuine job. They don't have a problem. They have the actual employee working there. They're paying them the salary, maybe sometimes even more than what the LCA has said. If it's 105, they're even paying 110,000. So, you have those employers too. It's not all bad eggs. We have a lot of good eggs too. But let me say something very, very nice that's come about with this H1B modernization rule, Sam, for students. I don't know if you remember the
Yeah.
cap gap that the students had. The cap gap was only until September 30th of that year. If the student had a OPT that was valid only till June 31st, the cap gap allowed it until, September 30th. That was the cap gap given in 2024 and the years before as well. But now, with this rule, the USCIS or the DHS has come up with the policy that this is going to be extended until April of the following year. Meaning, if there is an RFE, you comply with the RFE, get the approvals, and wait for all that to be completed, which might take sometimes till November, December, if an employer is doing non-premium, and which may put the student out of the cap gap in the earlier years, and the student had to go back to school. But now they don't have to do that, and they'll be able to actually, the government is extending this rule until the following year, meaning in 2025, it's going to be extended until April of 2026. So this is great news for the students, that they don't have to be
Absolutely.
worried about the cap gap, because the cap gap is extended. So this is absolutely amazing for, the students, and I'm really happy for that.
Wow. I think that was really insightful. And Uma, I really like the way you explained about what can be the reason behind these stricter rules, because most of the immigrants, in fact everyone, they are just looking behind what are the policies, what are the stricter rules that are being implemented each year. But nobody is getting to know what is the actual reason behind these stricter rules that are being implemented. And that's for sure, the we people are only responsible for having those stricter rules, because there are lots of corruptions, lots of misuse, lots of abusive, regarding the system that's happening. And to stop that, there has to be a very tough role that needs to be taken. And for that, I think it was really important to shed light on that. So thank you so much, Uma, for letting us
Most
know about
welcome,
it.
because
And
most of the time we are blaming the government for implementing these regulations, but we're not realizing that we are the ones who precipitated this matters. It's like a cat and mouse game. We start something, they do something, and then again people find another way of finding shortcuts to it, and then again they'll come up with an implementation to prevent that. Then again we find something. That's why I say it's a cat and mouse game. We keep playing this. But as long as we as an immigrant community can be aware, with such podcasts that you're doing, Sam, this is going to be great help. And I would encourage even employers, not just employees, to comply with everything, to make sure you do everything properly as an employer, because you have to protect your employee. If you're doing multiple filings, that's going to affect the employee. And you don't give the right documentation for a third party employment, it's going to affect the employee. If the H1B is denied, again, this employee is out of status or have to go back to school. We don't know what can happen. So, it's got to be from both sides, that the entire immigrant community has to come together, has to be aware and do the right things. If we do the right things, I don't think we will see, all these regulations coming about.
Absolutely. I think that's very well said, and thank you so much, Uma, for making us aware about these important pointers that most of us really ignore and don't give as much importance as it is needed. And with that, Uma, I would also like to know about the students already you mentioned, but we'll come back to that question. About the lottery system, because we can also see that in this H1B final rule, there is some changes regarding the lottery system. But first of all, before that, I would like to know it from you that do you like this lottery system? Are you in favor of this lottery system?
Well, we don't have choices. Let's put it that way. We just have to go.
Right.
The lottery system has evolved so much from the time it was a lottery system where we had to actually send in a full package to the USCIS with the entire H1B. And when your package was picked up, fine, you came to know once you got the receipt, and the rest of the packages were being sent back by the USCIS. That became extremely expensive for the USCIS. That's when they came up with the electronic registration. And even in the electronic registration, the employers started doing multiple H1s. Then they came up and implemented that you cannot do multiple registrations unless it's from multiple employers. And only one is going to be picked up for that beneficiary. So it was last year was all beneficiary oriented implementation of the lottery system. So every time we are going to see different rules because they are only trying to strengthen the system and to maintain the program's integrity. In order to do that, they're going to have to come up with, various policy changes in the electronic registration system. So some may be better, some may be tough. We'll have to go with the flow. That's all I can say.
Absolutely. There are certain rules that we can't do anything about it. But still, if I have to share my thing, then I would say it's little unfair, because it's mostly depends upon the luck rather than the skills and the qualification that what the person has.
Absolutely.
But that's okay. As I said, it depends upon the laws and the rules that we can't do. So with that, Uma, here's my another question that I would like to know. That does the final rule affect the lottery system for the H1B visa applications?
They haven't come up and said anything that would make major changes with the lottery system that they have in place, other than making sure that there are no multiple filings. They're definitely going to implement that much stronger to ensure there is no abuse of the multiple filings.
Absolutely. We hope so. All right. Here's another question that I would like to know it from you, Uma. That how does the rule impact workers in the tech industry who rely specially on the H1B visa workers?
Say that again. Would you repeat your question, please?
Sure. Yeah, so my question is about like how does the rule impact the H1B final rule impact the workers in the tech industry who rely specially on the H1B visa
Well,
workers?
as we discussed, Sam, just a few minutes ago, it is definitely affecting the tech industry, the IT companies, the IT company owners, and the employees, which I said now we're going to see more of the FDNS site visits. If you don't provide the end client letters, or if you don't have a master service agreement, some kind of proof to show that you actually have a job offer for this employee at a third party location. So that is going to be the biggest issue that's going to come about. One is going to be to make sure that the employee complies with the definition of the specialty occupation, and two, the third party placement. These two are going to be the biggest issues.
Absolutely. All right. So I think till now, we have covered quite a long information in today's session, but I would also like to take questions from our viewers who has joined us. So I think welcome Rahul, Pankaj, and Yuri. I can see your questions, and I think let's take Rahul's question first. So, Rahul is asking that as an H1B employee currently working in the US, I'm worried about how the DHS final rule changes could affect my visa renewal or ability to change jobs. Are there any new restrictions or additional requirements that I need to prepare for?
Rahul, we just talked about H1B extensions, and if you're with the same employer, there is the new modernization rule talks about deference. So the USCIS adjudicators are now directed to make sure that they are giving deference to the previous approvals. So they look at the previous approval, and if everything looks good, even if you're changing an employer, as long as everything is in compliance, they're okay with it. But if you continue with the same employer for the same kind of job, you're just filing an extension. I think it's definitely going to be much easier than what it was before, because they were not allowed to do the deference rule in the past. In fact, when we even sent H1B approvals, we got an RFE sometimes, and the RFE would even say, just because you had an approval, it doesn't mean that the USCIS officer will take deference of that. But this was actually put in the RFE, Sam, if you believe it or not.
Absolutely. But that's so heartbreaking, even after getting the approval, also, then it's not sure.
But now it's
But
changing, and they are going to give deference. So the
wow,
USCIS
that's great.
adjudicating officers are now being trained and told that you have to give deference to the prior approvals.
Wow. I think that's a major change, that we are going to see in this new rule. And I think, yeah, that's very well put up because, we are seeing different challenges, but with that also, there are lots of opportunities, especially for the H1B
Now,
workers. So I think it's
continuing,
going to be a good.
yeah, continuing Rahul's questions, will there be any new restriction? Rahul, if your employer is placing you in a third party location, you need to make sure you have all the documents for the third party.
Absolutely.
And
All right.
because
So,
there are going to be stricter enforcements coming about. Now, Sam, maybe, they will be a lot more site visits in 2025, maybe in 2026.
um,
It's also a question of manpower for the DHS and the USCIS. There's a second aspect to it, which I want to talk about also. Elon Musk
sure.
and Vivek Ramaswamy, who are heading the DOGE, have also come and said they're going to slice a lot of federal workers, meaning they're going to cut down on federal spending, take away a lot of workers in the federal government. And one of the organization or the agency is going to be DHS, and USCIS comes under DHS. So we've been told that there may be a lot of employment cuts with the USCIS. Now, if that happens, will there be enough manpower to do these FTNS site visits for every employer? We don't know that.
Right.
Is that a reality, practicality? I don't know that. So, there's going to be
Absolutely.
that. And I'm not telling people to slacken off. By no means am I telling people that. But I'm telling from a practical standpoint, if that happens, then we really may not see that many site visits because USCIS cannot afford it once they have sliced their employees. There's going to be
Yeah.
freeze in the jobs. They're going to take away some workers. Now, if they feel the FTNS workers are essential and keep them, that's different. And we're not going to know about that.
Absolutely. And I think that's a very statistical way, that you have put up because when there is lack of manpowers, then how is it going to continue with that work, and that too, especially for the site visit. And that's what Trump is very much firm about it in this
Right.
law. So I think, yeah, that's very important to shed light on that. And thank you so much, Uma, for letting us know
But
about
then
it.
if you have,
And
let's say you have H2B workers, H2B is different from H1B, where you have
right,
100 workers working in an organization doing a roofing work or laying a foundation work or putting carpet or granite, those kind of workers where there are hundreds and hundreds of them. So it would be
right.
easier for an FTNS worker to go do a site visit there because we're talking 100 people in one place. So when they do that site visit, for them it's more beneficial because they'll make sure whether these 100 people are actually doing roofing or are they plucking strawberries? Are they doing something different from what they said they would be doing?
Absolutely. All right. And meanwhile, I would also like to move ahead,
Sure.
Uma, with another viewer, that is Pankaj. So, Pankaj is asking that what are the key changes to Form I-129 and what steps do I need to take to ensure timely and compliant filing, including any new documentation requirements, edition dates, and rejection policies?
I can't remember the edition date, but I think starting February 10th, they will not accept the new, I mean, the I-129, So they'll have to go and make sure that, they comply with the form. I don't know the edition right now. That's something I'll have to look into it.
Okay, that's all right. You can explain about the documentation requirements and if you are informed about the rejection policies. I think that's okay. We can move ahead with the other viewer. Or would you like to take that up, Uma? What
I'm sorry,
would
I'm
that be
having
okay?
problems with my screen. I'm not able to see it. So give me just a moment.
That's
Okay, I'm
sure.
back. I'm back. Sorry about
All
that.
right.
Something happened. What are the key changes? Again, what is it the person has to ensure with, compliance is make sure if you're working at a third party location that you would give all the documentation of a third party, whether you have an MSA with the vendors or if you have number of vendors. Sometimes they may not be willing to release all the vendor agreements because of the money factors. So some kind of documentation to prove that you are going to be working at the end client location. Sometimes they even have restrictions. I mean, RFEs stating we had this in the past, Sam, and we may see this now in 25 to 29 again, is did you actually post the LCA at the end client location? They may ask for this question because you're supposed to post it at the employer's location. Now, if the employment is at a third party location, they'll want proof that you posted the LCA at the third party location. So this is something that was there in 2014, 15, 16. We had seen a lot of these RFEs asking for it. Sometimes they even asked, did you post it internally in your intranet, the company's, within the company's intranet, So that would be difficult because a third party employer will not be willing to share that information, even if they did, because it's confidential and they wouldn't share it. So we faced these problems back in 2014, 15, 16, even up till 2017.
All
So
right.
we may see
Okay, but
those
I think.
again because third party is not willing to provide all this.
All right. Okay. So thank you so much, Pankaj, for questioning this, and I think it was really important for everyone to talk about it. Meanwhile, if you still have any follow-up question, or if you want to know anything about today's topic, then please go ahead and post another question on the comment section. We will definitely take them up. And with that, let's take Yuri's question. So, Uma Yuri is asking about how will the modernization and improvement of the H1B program, as outlined in the final rule, potentially create unintended consequences or conflicts with existing regulations for other non-immigrant classification mentioned such as H2, H3, F1, L1, O, P, Q1, R1, E3, and TN, and what steps can employers take?
Well, the modernization rule also affects the H2B, and there's a lot to discuss about that. Sam will have to do it in a next discussion. When we have that, we'll talk about H2A and H2B. Who are they? Who qualifies? All that. H3 is a trainee, so this doesn't affect the trainee. Of course, the forms have changed. The I-129 has changed. So you have to comply with what is the requirement for the H3 as per the form and file it with the right edition. F1, as we talked about, the cap gap has increased for the students who are applying for H1. So the cap gap has gone until April of the following year. L1, there is no changes in the regulations. However, the form has changed, and you have to make sure that you comply with the providing all the information as per the form requirements with the new edition and the new fee. Make sure there are a lot of people still sending wrong fees, and the packages are coming back. And there's also a slight discussion in the Trump administration that they are likely to increase the fees. We don't know which ones are going to increase because we just saw an increase in the fee in April of 2024. So, which fee is going to go up in 25 or 26? We don't know that yet. And I don't know if you even recall the conversation that Elon Musk had said. He also suggested that he is in favor of tightening the regulations for H1B to make sure
Oh.
that, he is not in favor of taking out H1B, but he did say that I'm in favor to tighten the regulation. He also suggested that maybe the prevailing wages have to go up, the LCA wages, to make it more tougher for a lot of employers to comply with that, because MEGA has been raising that H1B workers are the cheap workers. They work at 50,000 or 60,000 or 70,000, whereas a lot of workers do not do 50, 60, 70. A lot of workers are getting paid 100 or 100 plus, depending on the job, the location, the county, the city. So, but there was some discussion about all this to increase the salaries as per the prevailing wages with the Department of Labor, and then also increasing the fee and tightening up some of the regulations. So, what are those going to be? We don't know yet, but this is something that's coming out. So, if that happens, then of course, even we'll see the increase in fees for H's, L's, P's, O's, R's, pretty much every form may see an increase to make it more difficult, possibly for people to file applications.
All right. So I think now it's going to be a very, everyone has to be updated a lot, and they have to be very well aware about what's happening, because just few minutes before, we were praising Elon Musk about that he's highly in favor of the immigrants and for the H1B workers. But now when you're saying about this, that now he put up another statement, so it's a complete roller coaster ride. We can't predict what's going to happen. Every minutes, every seconds, this administration is going to come up with new things. So I think, yeah, we have to be very much aware about it, and we have to be very much updated with all the news that's happening. And with that, friends, it's very important to like, share, and subscribe to our channel, because we mostly post those videos only that's related to immigration that's happening around the world. And thank you so much, everyone, for joining us. And I would also like to take up VR's question. And VR is asking about, what if the basic education doesn't fall under the same area of work? Example, from a non IT background working in IT. Will they face challenges in extension?
Well, for example, if let's say I've got a pharmacy degree and I'm trying to work in an IT field, completely IT, then there may be a red flag that goes off. But then again, if I am a pharmacist working in an IT field, but that is again health related, let's say, a lot of us as regular people, we log into something called as the chart, right? We log into our chart. These charts are again maintained by software developers, or database analysts or business analysts, whoever is doing the job. So there is somebody in an IT field who's doing this, but somebody with even a science background or a medical background would probably understand what a chart should look like, rather than what a database for a bank would look like. So again, it would all depend whether the science background enhances this particular IT position. If it's in a healthcare, then it may still work. Now, what are the challenges you face in extension? I just mentioned that earlier. If you're going from a regular employer's employment where you are just working at the employer's location, but then now you're going to a third party location, then you would have to provide the third party proof that you have a bona fide job with the third party. So this is something you may want to look into if you are uh, your background doesn't fit, or you have any issues with third party locations.
Absolutely. All right. So I think, thank you so much, Uma, for explaining this in a very detailed way, and thank you so much, VR. If you still have any questions, then please feel free to pose them. And Uma, would you like to say
Yeah,
something?
I
I think you're
wanted
about to say,
to
right?
go back and talk about the I-129 form that somebody had questioned, and I didn't have the exact information at that point. The new form, the I-129, is set to go into effect starting tomorrow, which is 1/17/2025. So any old editions, which is the 4/1/2024 edition, if it is received before tomorrow, meaning today being the last day, if they receive it today, they are fine. But after tomorrow, it's going to be the new edition and they're not going to accept it. So anybody filing for change of employer or extensions, starting tomorrow, you will have to use the new edition. I thought it was February 10th, but that's the I-485. They've changed that form, and that is starting February 10th. So I just wanted to make sure that I give the right dates. So starting tomorrow is the new form.
All right. So I think it was Pankaj's question about some key changes to Form I-129. So I hope now Pankaj is having a better clarity regarding the dates also and the time limit also that he's going to have. So Pankaj, hurry up and for any details, it would be great if you could contact Attorney Uma Mantrawadi, because she can also guide you in a very good way, and you can also contact her on the given details that I would like to read it out. So her contact number is 713 You can give her a call on that, and you can also email her on uma@mantralaw.com, and you can also visit her website, that is www.mantralaw.com. So I think it would be great to take her advice, and it's a high time right now. So thank you so much, Pankaj, for asking this question and letting us know about it. Also, Uma, as we are talking about a very H1B final rule, that's a very hot topic right now. So moving ahead, I would also like to know about does the H1B rule in 2025 is going to favor large companies over small businesses? What's your call on that?
In a way, yes. Sam, you might say, that's not fair. The reason I say that is, let's say a big company like Coca-Cola or Tesla or IBM or AT&T or Nvidia, whoever they may be. See, they're not placing their employees at third-party locations 9 out of 10 times. They're placing their employees for their in-house projects, because these are huge companies with humongous amount of projects that they have. And let's say even if they do place a Coke is going to place a guy at IBM, they would be able to get documentation easier than a Desi company called ABC Consulting. Okay, because they won't be, a third party won't be willing to share a lot of information with a smaller company, as opposed to sharing the information with a Coke, because they have tremendous amount of business going back and forth with each other. So one, if they are placing at a third party location, it's easier for them to get documentation. Two, they have the benefit if NVIDIA or IBM or AT&T is placing their employees, most of the time they're not placing them at a third party location. So it's easier for them to give their documentation, because they've got millions of dollars worth of projects that is ongoing all the time. They get a lot of federal contracts. They have it going all the time. So for them, it is not difficult for them to prove this. Whereas if it's like me, I'm a Desi company owner and I have, a small company. For me, it's going to be difficult to prove that. So, it's always the small businesses that is affected in such situations. But again, if we are more aware as employers and make sure you talk to an attorney. Sometimes people want to do things on their own, and
Um, I think due to some reason we just got disconnected with Uma. Uma, can you hear us? I think due to some reason she just got disconnected, but not to worry,
Sam, she's not
friends.
here.
She'll be joining. All right, so I think
Great.
she'll be joining us
Okay.
again. So, friends, I think it would be great if you could also post your questions up, and it's almost 1 hour. So, we can extend our session for 5 more minutes. That's okay, and you can put up your questions. And till the time Uma is not back here again, I think we should take a break and should wait for a minute for her to come back. And that's all, friends. Don't go anywhere. We'll be coming up just now with some more information. So, yeah, I think continue joining us and we'll be back again. All right, everyone. So, welcome back. And we have to say sorry because due to some technical issue, Uma cannot join us back. But that's not a problem because next week we'll be coming again with our very insightful session. So, keep your questions with yourself, and we will definitely, take those questions in the next session that we are going to have in the next week. And meanwhile, I would like to take a bye and take a leave from each one of you. And thank you so much, everyone, for joining us in today's session. I'm sure today's topic, that has been very much helpful and very much insightful, not only for the employees and for the employers, but for everyone, those who are looking for the H1B visa. So thank you so much, everyone. And still, if you have any question or having any doubt regarding the topic, then please post them on the comment section after the show. Also, we will definitely try our best to take those questions and answer them after some time. So thank you so much, Attorney Uma Mantravadi, for this insightful session. We are hoping to see you in the next week soon. And thank you so much, everyone, for joining us. It was really a great session, a very insightful session we have today. And don't forget to like, share, and subscribe to our channel. Also, don't forget that we are live on YouTube, LinkedIn, Facebook, and on Twitter as well. So go ahead and like, share, and subscribe to our channel. Meanwhile, me, Sam, signing off for now. Goodbye and take care.
Hello and welcome to Immigration and Jobs Talk Show. I'm Rajni Bharara, your host. And today, before I talk about anything else, I would like to read out the very important disclaimer, which we display on our screens before the show. So, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back, everyone. I'm Rajni Bharara, your host, and today we are tackling a very hot topic that could reshape the future for thousands of foreign professionals. H1B visa updates 2025. What do they mean for you, and how can you adapt? Well, joining us is none other than Ruby Powers, a powerhouse in immigration law and founder of Powers Law Group. With years of experience helping individuals and business navigate the complexities of US immigration, Ruby is here to break down the changes, share insider insights, and answer the big question: how can you stay ahead in this ever changing landscape? So, whether you're an H1B holder, a hopeful applicant, or an employer trying to make sense with all of it, this episode is packed with tips and strategies you can't afford to miss. So, without any further ado, let's give a very warm welcome to Ruby. And yes, welcome her to Immigration and Jobs Talk Show for the second time. Hi, Ruby. Welcome to Immigration and Jobs Talk Show for the second time. Happy to have you back.
Thank you for having me. I'm glad to be here and help answer questions and be a resource for everyone.
Thank you so much. Thank you so much for your time. And now, Ruby, without any further ado, we have so many updates coming, like coming and going, especially regarding H1B. So people are really excited and nervous at the same time. Sometimes, the big names, the politicians and the business people, they are backing H1B, and sometimes they are not backing H1B visa. So, a lot has been going on when it comes to H1B visa. So I would like to know from you that what are the key changes in the H1B visa renewal process starting January 17th, 2025?
Well, there's been a lot going on because, as everyone probably knows, we have a new president who was previously a president, Donald Trump, and we had the inauguration just days ago, and so now the immigration in the news space has been flooded with a lot of changes. There haven't been a lot in the H1B space other than the H1B rule that was announced that would go into effect on January 17th, which was to further streamline and the modernization final rule to improve program integrity and efficiency that was going to go into effect by January 17th of this year. That was put under place under Biden. What is in the news a lot, which just looking at it right now, is this going back and forth between Elon Musk and it's Vivek Ramaswamy and the whole Department of Government Efficiency about something about regarding H1Bs and things like that. So there is a lot of talk because it has been confusing leading up to this moment as we're in cap season, H1B season right now, about to start. And this is a time when you think about it, you talk about it, and you get screened. What will this administration do differently, if anything at all, on H1Bs? I do have some information just generally that I can share about the H1B process, and just to make sure we have some good background, if that's okay, and then we can go into taking in some questions. But let me go ahead and share some information. So in terms of updates and what people need to know, a little bit about myself. I'm board certified in immigration here in Texas, and it is federal, so we can help individuals all around the world on U.S. immigration matters. And the firm is Powers Law Group. It's 15 years old, and I've been practicing 16 plus years. So the H-1B is well known, I think, by our audience here as a non-immigrant visa that allows U.S. employers to temporarily hire foreign workers in a specialty occupation. And usually what we're seeing is in IT, engineering, healthcare, academia, and it's a really great place for skilled workers. Unfortunately, we just don't have enough visas allocated for the demand. And what the process was before, and this is one thing that Trump put into place in his first administration. Remember how it used to be that everybody who was applying had to prepare the entire packet, FedEx it, and for that April 1 arrival, flooding the USCIS locations, and then they would then take those and do their lottery system. But one thing under the Trump administration was to create the registration process where before you did all of that, yes, you need to double check that you're eligible, but what they would do is you would go on the USCIS website, registration, and then they would randomize. There was an opening of about a 3-week period in March, and then you would have that randomization and be able to see who got chosen. Then you would prepare and submit. So this saved a lot of legal fees for companies, individuals, and things like that. And so I really do think that was a great suggestion to streamline the process. But then over time, they called people gaming the system and applying for multiple people and trying to get more chances. And then they were cracking down on that later in 2024 by some of the innovation and efficiencies that they put in place. But in general, you either have a bachelor's degree or higher in a specific field. You can use equivalent experience, but for the most part, we're working with the bachelor's or master's or beyond. and the job offer is in a specialty occupation requiring the applicant's skills. They have to demonstrate that they need this the foreign talent, and so just some of the things to know. There's 65,000 H1B visas annually, and what we're talking about are the cap. The cap is where there's a limitation. There are exemptions to the cap where there's not the same limitation when we're talking about universities and affiliated nonprofits and government and research organizations that qualify for being cap exempt. And back to the annual cap numbers, additional 20,000 for individuals with advanced U.S. degrees. And so that does put a priority on those with, like, mostly we're talking masters from the U.S. That helps with the U.S. schools, but generally people might be here with their F1. They get their OPT. If they don't get picked up for their H1B, and they're in the STEM, they have some more years. And so there's been like an opportunity there to help them. Often what I find is, even though you can do consular processing, that most times it's the employer knows the potential employee and has worked with them in some capacity in OPT or some other visa status, and is willing to, because of that, willing to petition for them. So we in 2024, according to this, they received 758,994 applications. I think that's registration actually, but there's a lot of demand. And so that's the other thing that there's been talk about is, why can't we increase those numbers? And basically, it's a political issue too, because there's just that concern that you're not taking jobs away from U.S. workers. But a lot of statistics and research show that there's not enough U.S. workers to do these jobs. And by bringing in foreign skilled talent, we're infusing a lot of ingenuity and just creativity and just, I don't know, I'm thinking of synonyms for like the amazingness, let's just say, and that later on can turn into other opportunities, because they're making great strides here in the U.S. And what's great about the H1B is that it is a nice pathway can be a nice pathway, with it being a dual intent for perm sponsorship. And so anyway, there's the process. And just one other change that did happen was, because of that final rule that went into effect on January 17th, there's a new I-129 that came out like the same day. So that's a new thing. H1Bs, you can get them usually around up to 3 years at a time, but the 6 years, and then you can get the 1 year extensions while your perm is pending. And the prevailing wage requirement is critical, and that changes over time with Department of Labor and where the person will be working, and based off of experience. And this is how they make sure that they're protecting the domestic job market, and also the potential employee and beneficiary, to make sure that they're paid that prevailing wage. One other thing about the H1B, which I think a lot of people know, is that H4 is for the spouses and married children under 21. There is a small carve out for giving work authorization for H4 spouses if there's a perm pending. That had been going in and out of availability over the years. I hope that remains, because for some individuals with a long time visa wait, then this makes life a lot better, while the spouses are waiting for the green card to be available, especially for Indian nationals, when the visa wait time can be quite long. And because otherwise the spouse would need to get on another visa. And the other thing we always have to remember is, while that visa wait time is pending, watching out for the children and what visa can we move them over to. So like we said, there's a lot of political changes going on right now. And a part of the base in which the Trump administration, or Trump his candidacy was really trying to protect U.S. workers. I think that there's a section that are using the H1B that are not part of his base that would be at risk. But I think just the concept can be very politicized. I'll just say it like that. I don't know. I don't want to go into the nitty gritty, but I think that's why we're seeing a lot of headlines right now where there's a little bit of some confusion as to is he pro H1B or not? And it sounds as if he has been, but then it's been really confusing, honestly. And so anyway, a lot of big name companies have been stepping up for H1Bs, just like they had for DACA, for example, and saying, hey, we need this. We need more of this. We need to stay relevant and stay competitive for us to be able to keep these jobs here in the United States. And so that's a lot of part of this conversation. There were so many other changes, executive orders that happened in the last few days that even though we are gearing up for H1B season, so this is timely, I feel like this is just one of many things that are going on right now to sort of see if he's going to have any substantial changes other than what has been happening under the last year or so under Biden and the improvements. So he has said that he wanted the need for the skilled individuals and supports the personal. He knows about the program. I think he's had employees within the program. We need the best people in the field. Apparently, he said that. But in terms of expanding it, I think I'm not sure what he's going to do. There's a lot of supporters like Elon Musk, who's a part of his Doge, is that the Department of Government Efficiency or something like that. I'm still memorizing all these new things from this week. But and then there's others who are not as are critics of the program. But anyway, a lot of big name companies have used a lot of H1B, have a lot of employees through the H1B process, and are definitely strong supporters of it. I think it says a lot that with Elon Musk in his Trump's ear, that who's a big strong proponent of H1Bs, and we'll continue to see what will happen. But right now, there's the 85,000 visas available, and 20,000 are going to the advanced degree holders, which really is not enough. Like when the economy is strong, when there's labor shortage, I mean, these numbers go by so fast. When we before the registration process, and you flew all your cases there by that April 1 date, usually they would stop accepting them within like 2 days or something like that, maybe 3 days, because they knew that they already hit the numbers and that within that they were going to do their lottery. So I think when you look over time, when historically economy is strong, labor market is tight, these go by really fast. And anyway, well, we know the importance of it. They contribute to the economy, that innovation, and it does provide a lot of options because individuals can have a pathway to, usually it's like the foot in the door. Maybe they were already here on their F1, then they get the OPT, the company likes them, they do the H1B, it gives them an opportunity to get that experience, build their resume, and then the traditional path is to be sponsored by the company. But, if there is a timeline to get that done because the H1B visa is available only for 6 years. So you want to get that perm going usually within a couple of years. That usually works if you move quickly. Other than that, depending on your nationality, you might want to try to move to another visa, or you build up your resume and try to be a national interest waiver candidate of some sort. Or depending on your spouse's nationality and eligibility, you might be able to get on some other type of visa. But lots of global collaboration, lots of options, and there's been different talk. We don't know. Removing caps for U.S. educated international students, simplifying that transition from H1B to permanent residency would be great. streamlining processes to encourage top talent to stay without being so bureaucratic and confusing. But honestly, there's been so much change this last couple of days. I don't know when we're going to get to this conversation, but it's probably going to be hot because we're going into H1B season. So what will some of the changes be? We're not sure, but I think that other issue that was clarified recently was making it easier for the OPT, so F1 OPT, H1B, and that whole gap, clarifying that, streamlining that. And then, that was awesome when there was given more time for OPT for STEM degrees. That gave people more of a chance, bite at the apple, the H1B registration. And so it's hot. It's prevalent right now. This is timely. And other than it being in the news and the January 17th rule and some of the other changes from 2024, with the fact of how that needing to show your passport when you do the registration to minimize the amount of multiple registrations per person beneficiary. Those are like sort of the hot changes that have been happening in the last year. So this is a little bit about my information, and we'll go ahead and open up to questions.
Thank you so much. Thank you so much, Ruby, for explaining everything in so much detail, for pointing out all the changes that has been happening with the H1B visa. So that was very detailed and very insightful. Thank you so much for making the efforts, on creating the presentation. It means a lot. Thank you so much for that. But now I would like to move to my next question after this. So Ruby, with this, I know that you have explained each and everything in so much detail, but still I would like to ask you a question before I move into the viewers' question, because I know the viewers are also waiting to get an answer from you. And guys, if you directly want to give a call, so you can also give us a call on the number 425-436-6335. I would like to repeat it, 425-436-6335. You can put the access code 988888. Yes. We'll put you through and you can directly ask your question to Ruby, through call. So, but right now, Ruby, I would like to come to you and ask you that now, can all H1B visa holders now renew their visas domestically, or are there specific eligibility requirements?
Oh, okay. Well, if you could, if the individual is here in the United States, you can do that. And there's a lot of different considerations about if you're planning, to travel and with your stamp and things like that when you're coming back in. But you can you can do an extension while you're here in the country. One of the other things that happens with this is that one thing that happened a lot under the Trump administration, and just thinking about consulate right now, is that there were a lot of resignations and there was a lot of change. And then they had a hard time filling some of those roles. And so then things just got slower and a little more difficult. And one of the other things that I remember during that first administration was, and I'm just sort of talking in general, so I'm just sort of putting that thing in perspective. So when you're deciding whether you want to do an extension here or, abroad, but I would definitely, if you're here, and I would do it here. And you can also take advantage of premium processing if you need it or things like that. But the other thing that happened is that there was this sort of, even if you had been approved before at the consulate, they were reviewing, under Trump first administration, reviewing things de novo, like looking at it with fresh eyes as if it had never been approved before. And one of the first changes that Biden put in place to basically honor the fact that it had already been reviewed and approved was to give a lot more credence to a prior approved petition and not look at it with fresh new eyes, assuming that it was a brand new case, and sort of giving it the deference of it being approved before. And so I'm bringing that up because there's going to be a few things that are going to happen, like with the change in administration, It just happened on Monday. And we are going to see, I remember when with Biden, it took about 6 months or so to really feel like he had made his administration change footprint and on the and on immigration. And so I think we're going to concede that. But right now, a lot of new cabinet members are getting into office or being confirmed and everything. And then they're changing their leadership. They're changing the marching orders of what they're going to do. And so that's why a lot of this there's going to be a lot of moving parts, more than a typical year. And so I think even though there's lots of questions and I love being able to help give some general ideas, I think that nothing takes the place of just having a good old consultation and with an immigration attorney. And maybe if you have a company that is sponsoring and doing all of the the process, but you want to have an attorney that just is helping you know what your options are, then that's also like what we do as well, or that's an option that you can have. You don't have to just ask the attorney that your company has. You can ask another one just for like a second opinion to know what your options are. So anyway, I went a little bit over there, but I wanted to explain that a little bit for you because there's a lot of different moving parts. And one little policy, even though there's probably only going to be one law that's going to be passed anytime soon that's regarding immigration, and that's the Laken Riley bill act about the some criminal matters that even if you're arrested could have you detained. But what I'm getting at is that for the most part, we haven't had immigration laws in many years, but what we have had is policy interpretations or rule changes. And so when there's a lot of these changes that are announced, like about 80 executive orders were returned or rejected or reversed. I think it was reversed of Biden and Trump on the first day on Monday. But when you think about all the changes that are being proposed, you have to think about where is the source of power or where is the source of law that the things we assume or that we know come from. And sometimes it could be, like I said, a rule, a policy. It could be an interpretation from like USCIS, for example. And after a while, they're like, we may have a new interpretation of it. And they create a memo and they say, this is our new interpretation of it. And so maybe that's a little too nerdy about it. But like right now, that's sort of how immigration works. And so when you ask questions and when there's a constant change, us immigration attorneys have to evaluate these things when we're answering those questions. And with a lot of moving parts, I am starting to liken this to playing 5D chess. I don't know if that's a thing, but it's sort of like what we know, what could potentially happen, and what could change. Anyway, but this isn't going to be that complicated as 5D chess, as like some other areas of immigration right now.
Right. But a lot of things has been happening when it comes to immigration. Since the time President Trump has taken the office, he has signed executive orders and ended birthright citizenship. The courts have also challenged it, and then the mass deportation has already begun, and so many things, and the ban on CBP apps. So I mean, there's a lot to actually talk about, and then these changes in H1B visas. And then sometimes they are backing it, they are in favor of it, then sometimes they're going against it. So a lot has been happening. So what do you think? Do you think it's more than what they're trying to do is they are actually it is more of a political move than what they're trying to do?
Well, I think that one of the things to note is that okay, that's probably where I saw the 5D chess was on Star Trek. Thanks for putting but I've been using it this week in media because I that's why I feel like my brain is like hurting already. Okay, this is the way I approach this right now. There's the political motives, and unfortunately immigration has been politicized, but ultimately life must go on. Immigration impacts so many different aspects of the U.S., from the economy to the movement of people, to the food that we eat, to our culture and innovation. We're in this whole AI revolution and everything in the tech space as well. And so I think on the political side, the way that our president is part of his base, that part of his campaigning is to stoke fear amongst immigrants, and unfortunately, and so I think a lot of that is through the expedited removal expansion, the mass deportation talk, the getting rid of the CBP1, making asylum harder, the Lincoln Riley Act, which is, in theory, it sounds good, but when you realize it, a person who's just arrested could be mandatory detained, even though they haven't had their chance to defend themselves and clear their name. And so that's contrary to what we normally do. And even ICE has said that we're not going to be able to implement this because we do not have the resources. But anyway, so one of the things I've said is that we have to evaluate what really can happen and where are the priorities. I think the priorities really are a lot about border and deportation and with crimes. I think that he may have swayed back and forth about H1B, but I think ultimately he knows it's important for business and companies, and I think for the most part he'll stay a little bit out of it, but it is getting a lot of headlines right now, especially with Elon Musk and such, who is a strong supporter of it, and a lot of other big companies. So I think for the most part, it's not going to be changed that much. And plus, there's not a lot of time to make a lot of change. Like, it's January 24th. Registration should start in early March. It should only open for a few weeks. We already had, rules take time to be put in place. There's a comment period, there's the posting, and then you have to give people advance notice about it. So I think for the most part, whatever was done under Biden in the last year is probably what's going to stay forward for this next season. It could be like the present following H1B season that we see a little more change. But for the most part, I think it's relatively safe. But like I was saying, like, you have to look to see where's the source of power, and how long and how quickly could one person, or could he make a change to it? Or would it require Congress to act, which is going to be a little bit easier because there's a lot more consistency on the Republican side and numbers there. But that's probably only going to be for maybe 2 years. And then the pendulum will swing again, and so forth. So, yeah, those are some behind the scenes type of thoughts about it. But I think, some of the things that we remember under the Trump administration were, he made that registration process. He made it a little bit harder for F1 students, and there was a lot less students. And you know what? F1s, they're the pipeline for H1B. And so I don't know. I don't think there's been a lot of talk about like reducing that, but it could be that target certain nationalities that they target reducing F1 for, but that really hurts the schools because of the international.
If you can give some example, nationality, like what all countries?
Well, it could be like Chinese or something like that, or certain countries that like he might be like retaliating against for political reasons or something like that, or security reasons. But I don't. Honestly, I really try to stay in my immigration lane, but it looks like I need to go up like 30,000 foot high level and see like a whole lot of big picture. But even with immigration, we're still full service law firm. So, I mean, I'm thinking about asylum and complex citizenship and family based on a regular basis. But yeah, I think, yeah, so I don't know if he's actually said anything about F1s, but I was just giving, a student, But what I have said is that what I was mentioning is that was something he did before. He made it a little bit more stringent because, okay, where do F1s come from? Usually the consulate. If you make it difficult at the consulate, which, like, if there's more scrutiny, less discretion, less staff, whatever the policy is, less reviewability. There was a Supreme Court case last June that gave a lot more power to consular review. And so if that's that pipeline. So at the consulate is where all the F1s pretty much were coming in. And then for the most part, you could do a change of status. And then the F1s usually turn into OPT, and then they turn into H1B for the most part, right? One other good thing that happened, and I think that was pretty much only under Biden, was that you could do a change of status to an F1 and pay the premium processing. I remember how you used to have to wait a whole year and a half for them to adjudicate the change of status before you could start school. That was so stupid. And that's another thing that Trump did under Trump 1.0 is that he got rid of premium processing for so many things, which was really unfortunate for USCIS because USCIS, that's extra money. Like, you do something faster, you get more money, and that helps the USCIS be more efficient. But also it makes it more difficult for companies and individuals if you don't have premium processing. And so that was one thing, if you paid attention to that under Biden, having more premium processing for even national interest waivers, student change of status, and things like that. Anyway, I guess I'm going on a little bit of a rant there, but giving a little bit of a history lesson of things and keeping in mind what might potentially happen. So.
No, I think that's necessary and that's very important. What you're saying. You have to inform the immigrants, especially because they are expecting a lot of things. But Ruby, before I take from the viewers, but before I take that, I also would like to know from you that before we already have seen administration, and now that he was coming to power for the second time, I know we were expecting a lot. But then, as an immigration attorney, were you expecting all of this to come on the first day itself?
Well, we had heard rumors that there was going to be a whole bunch of actions on day one. So, I mean, I sort of lost count on the number. I heard 150 or I don't know, 200, I don't know, whatever. But, the one thing to note, it's like there's more to the U.S. than just immigration. I'm thinking his presidency, there's other areas of law and life, but I feel like he just really wants to focus on this one. But anyway, I think we had heard rumors. We knew, I think, as the day was getting closer from him winning the election to January 20th, we were getting more things were getting leaked out and more was coming out. A lot of that first focus in November was really in early December was to try to get a whole bunch of things filed and take care of things that we knew would probably not be run smoothly under the Trump administration. So that's where our focus was. And then as we were leading up, we were thinking a little bit more. But honestly, it does feel like it's like drinking from a fire hose right now. We had a little snow day here in Houston for 2 days. And so there was the inauguration. There was a snow day on Tuesday and Wednesday. We all had to stay home to be safe. And then Thursday, yesterday, I was just like, it's hitting me now. It's really hitting me because it was there's this game like whack-a-mole, or trying to hit the thing or something. I feel like it's a little bit like that because, there's this CBP one, no vaccine needed for COVID vaccine for 45. There's, just all the different things, the mess that talk about the law enforcement being at schools, places of worship and hospitals. People are getting concerned about that. Just so many different things. Oh, getting rid of that. The Nicaraguan, Cuban, Haitian, Venezuelan parole program. So honestly, what I was telling my staff is a lot of these things are sort of like you maybe get 2 a week or 1 a week of these things, but to get a deluge of all of them on a 2 or 3 day period, it's like that going back to the 5D chess, or it's a huge paradigm shift. And so right now we're trying to evaluate all what does that mean for our existing clients and how we can best give them advice for the future.
Okay. Thank you so much again for taking that up and answering the question, Ruby. Now, I would like to quickly shift my focus to the viewers' question because they've been waiting in line for a long time. So let me quickly read out the questions. So MBB is here, and MBB says, I'm sure the USA will lose hugely the talented students from all over the world, especially from India with Trump's executive order, and huge gain for India as brain drain will be arrested. USA's loss is India's gain. And I think it's like a statement that this person is making. And also says, goes on to say that on the other hand, the USA will become, I don't think so that's going to happen. But what do you have to say about this? What do you have to say about this statement of his?
Well, I think that the sentiment of it is whoever can make it attractive to bring in the skilled talent and educated and innovative talent is going to win, right? And what we saw under some of that Trump 1.0, just going to call it that, make it simple, is that we were turning away great talent. And so where were they going? They were going maybe to Canada or Europe, or I don't know where they were going, but some of them were not wanting to they weren't feeling so comfortable to come to the US. And so what does that mean? Well, then those countries were going to get, and those companies were taking advantage of that opportunity. And then that can lead to, more innovation, more profits, more strength. And so, right. I mean, that is the problem with brain drains when there's political issues or there's just not a lot of options for those to move up. And so the countries that take advantage and look around and say, hey, let's make it easy for companies and individuals to come here and bring their awesomeness, for lack of a better word, to our country, they're the ones who are going to win. So I hope that we're not going to see that these next 4 years. What I will say is if we do unfortunately see that, then I will believe that we do have the pendulum swinging back and forth. And so it could just hopefully be a temporary loss. And then we rebuild with new leadership and new insights. But ultimately, I think that there's so many different aspects of immigration to this conversation, from a person who has no status to a person who's had some type of a quasi status to someone who's coming from another country with education, to a legal permanent resident, to a naturalized citizen. And each one of those individuals is taking something away from a lot of this last week's news. And as to how really these things are going to impact them, I think it depends on where they are in the totem pole of their status. But for the most part, Trump was a business or is a business person, and he's surrounding himself by certain ones like Elon Musk and such. I think that there'll still be some reason in knowing that we need to not harm this process. There could be maybe some more potential restrictions, but I think for the most part, it's not going to be too greatly impacted, unlike some of the other areas, like if you you don't have a status or you're trying to come in from the border.
Okay. Thank you so much for answering the question. Ruby, let me quickly move on to next viewer question. Gauravi is here, and Gauravi says, I have been working in the US on an H1B for 3 years now. With these 2025 updates, what specific changes should I be worried about? Could these updates affect my ability to renew or transfer my visa? What do you have to say?
I think for the most part, if you already have your H1B and you're secure with your job and things like that, I think you're going to be fine. I think what I normally would tell someone in that situation is, have you already talked about legal permanent residency, perm? Do you have a plan? Because remember, you're at the 6 years unless you've traveled and you can recapture some of that time. But you're going to be wanting to be having those conversations if you haven't already, because 3 years has gone by fast. What's your plan afterwards? And are you married? Can they get a visa? Can you yeah, what can you do? That's what I'd be more concerned about. The typical plain vanilla thing of what's your plan. I wouldn't be worried about these changes right now. There's not a lot of changes, honestly. There's not. It's really what Biden put in place, and we already knew about that coming in before this administration started.
Okay, so Gauravi, I hope you have got your answer. In case you're looking for more, continue posting your follow-ups in the comment section. And meanwhile, let me move to Rekha's question. So Rekha is also here. She says, I'm currently on OPT and planning to apply for an H1B through a consulting firm. With the 2025 updates, are there additional restrictions or red flags that USCIS might focus on for consulting or third-party placements? What do you have to say, Ruby?
It was for okay. I for the dual intent doctrine, I don't see any changes on that aspect. Oh, right. This is the different question here. I haven't seen about the dual intent one question. I don't see any changes with dual intent. I think that's still there and it's still a benefit. And like we said, it's sort of a gateway to legal permanent residency through the perm, but it doesn't have to be the only way. And there's other options that you could try to pursue. But let's see. So for the I think that there's just a lot more protection for the beneficiary. I haven't seen exactly something completely on point to answer this question about through a consulting firm, but I think that it's just they're just wanting to make sure that there's a lot more integrity and efficiency and protection of the beneficiary, and also making sure that employers are not gaming the system and things like that. They are going to be conducting inspections and imposing penalties for failure to comply, and that proving that it's a bona fide position, a specialty occupation. But for the most part, I don't see anything that is to be of concern for this specific question.
Okay. So Rekha, I hope you have got your answer. But in case you're looking for more, please continue posting your question, and we'll be taking that and asking it from Ruby. Let me move to Lokesh's question in the meanwhile. Lokesh says, in the context of H1B visa programs, dual intent doctrine, how do the 2025 updates affect the ability of foreign professionals to pursue permanent residency or citizenship while maintaining the H1B status? And what are the strategic considerations for balancing short-term and long-term immigration goals?
All right. Well, that's
Yeah.
Well, okay. So I don't see there was a change or a mention about the dual intent. And so, the general path, the general traditional path that we usually see is the H1B, probably after 1 or 2 years, you start the perm process, which can take a couple of years depending on different factors and if there's an audit and things like that. And then you, if you have the I-140, approval, and then you can continue the H1B extensions beyond those 6 years. And so that's generally what we see for individuals. But if for some reason that doesn't work, then there are ways to try to either recapture some more time, stay out of the country for 1 year to restart your H1B clock. I don't see a lot of people do that, but it is something that exists. Maybe you have a spouse that can get on a different type of visa, and like an E2 or an L, and it can include you, and then you are able to work on as an E2 or an L2. Or maybe you're eligible for a national interest waiver, or an O or something along those lines. So I think that those things are still there. A lot of the implementation changes that were announced just a month or so ago are just like little tweaks, but it doesn't have a huge impact on the big picture of those short-term and long-term goals that you want to have. And usually when I have a consultation, we're talking like, okay, short-term, mid-term, and long-term, plan A, B, and C, and the different permutations. And sometimes we're like the individual, the beneficiary's attorney, and we're like there to give ideas and suggestions, but the company is the one who's sponsoring has the attorney in-house or what have you for the H1B. So, those are other potential options to just keep in mind so that you're thinking about the big picture. But I think you're going to be okay. So just as long as you're having a consult and you've already thought about these plans, because if you have your plan in place and then and there's a little change in the policy or interpretation, then it should just be a little bit of like, okay, how do I refresh this and look at it in a new perspective? And it won't be it should be a substantial shift.
Okay. So Lokesh, I hope you have got your answer. Thank you so much for your question. Let me move to Ciara. Ciara has actually posted this question on Facebook, and she says, "Hello, I am Senegalese. I am H1B seeker. I have a master's degree in finance accountant with a non-profit area. Is it possible to get sponsor job in accountant or financial?"
So it can, but one of the things that's important is that the job description and the position requires that you have that degree. But there are a lot of private situations where H1B sponsors accountants, and that's very common. But if the nonprofit, I think one of the things to note is proving that the nonprofit can pay that prevailing wage, has a role that can include a master's accounting professional on staff. Those are some of my little things of thinking a little bit, but that might be a little extra. But it is possible what you're asking for to be. And then if they qualify to be a CAP exempt, then you wouldn't even have to go through all this registration stuff we're talking about. But you have to look closely to that and have it evaluated to see if they are or not. Because if they are subject to the cap, then you have to go through it just like everybody else that we're talking about here.
Okay, so Ciara, I hope you have got your answer. Thank you so much for posting your question. If you have more, please continue posting your follow-ups. Meanwhile, Ruby, I also have a lot of questions from Facebook. I would like to share my screen and ask those questions because, those are some people, who post questions in the Facebook groups. So, yeah, I think it's already shared. So, okay. I would like to take them one by one. Before that, Ciara is actually back and she says, "Okay, thanks, and I have visa B1, B2.
Oh, okay. I was looking at that question. Okay, so for the B1, B2, you're usually only given 6 months of I-94 at a time. You can usually do a one maybe extension inside the country, but you have to realize that, okay, if you are subject to the cap, you wouldn't be eligible to start being in the H1B until October 1, and that's more than 6 months from now. And if you were to do a B2 extension, you might not know how much time, if it's approved or not. It could get a little risky if you're trying to do a change on top of a change. So I would just do a consultation. And if the nonprofit you're talking to doesn't have an attorney that they've ever worked with, then, like we help in those situations. And that's a pretty common thing for us, or if, just in general, is if the company or the nonprofit that you're trying to work with has never sponsored anyone before, then what often happens is they comes to us, they get an opinion, and then they hook us up with their employer and say, hey, maybe this could be a good attorney for the employer. And this usually happens with more of small operations that haven't ever gone through the H1B process before. So that's something that could happen, I'm suggesting, but also just it is possible to do what you're saying, but I'm a little worried about the timeline of it, especially if you are subject to the cap. You might need to just leave the country and, make those connections, leave the country and do the consular processing to finish it all up instead of a change of status, because we still a lot of unknowns. If you're subject to the cap, then you have to be chosen the registration and it has to get approved, right? So there's a lot of unknowns there.
Right. So, Ciara, you can also directly get in touch with Ruby. I would like to share her details. I would like to show the details over here, Ruby Powers. You can, for a detailed consultation, get in touch with her so she can help you because she also by now, she also knows your case. So you can directly get in touch with her for a detailed consultation. Give her a call on the number 713-589-2085. I would like to repeat the number, 713-589-2085. You can also email her. Her email ID is contact@rubypowerslaw.com. And you can also visit our website, which is www.rubypowerslaw.com. So please get in touch with her so that she can help you in a better way. And because of the time constraint, she is not able to. We won't be able to take all of your questions. But then you always have an option of getting in touch with the attorney directly. So here are her details. Get in touch with her. She says, "Okay, thanks. Thank you so much, Ciara." And now I would like to, again, Ruby, I would like to share the screen and show those Facebook questions to you, and would like to get an answer from you. Okay, so this question was actually posted 53 minutes back by an anonymous person who says, my lawyer by mistakenly sent I-485 to family-based AOS logbox instead of employment AOS logbox in Dallas. Now, starting February, they will only accept application on final action dates. I'm filing based on filing dates. It's been 3 weeks already. What will happen? Is there anything I can do? My checks haven't been cashed yet. What do you have to say, Ruby?
Well, that's a very technical question, but like in theory, if something is sent to the wrong place or it's not the right, something's wrong, they usually reject it. And rejections can take, I've seen take 3 to maybe even 6 weeks sometimes. I've actually done a tour multiple times of the Dallas lockbox, and they open everything up, they look at the numbers, and they blah, blah, blah. But I would also check, okay, you don't have a receipt number. They didn't cash the checks, and it's been 3 weeks. And you probably already checked the FedEx or the mailing, and it wasn't, okay. I think I would probably give it another 1 to 2 weeks, and it'll probably be rejected and come back. I don't know off the top of my head if it'll get routed to the correct place. It probably won't. But in those cases, if something is sent to the wrong place, or something is deficient with it, then they reject it, and then it can take a little while, and then they'll just give you that rejection page, and then they'll just send that to you, and the whole packet. Now, I get what your point is that you lost that opportunity because of the visa availability. There can sometimes be, with some great advocacy, being able to, if it's super worth it, there could maybe some advocacy to show when it was sent and trying to retain the priority date of when it was sent, but for the error. But given the situation, I think you have to look at the whole picture and see if it might just be worth just waiting another month for the visa to be current at the right time. I don't have what you're saying memorized, where it is and how, if it's backlogged, retrogressed and everything off the top of my head. But these are some things to consider. But rejections usually can take about 4 to 6 weeks usually, and if they haven't cashed it in like at least 4 weeks, then it's probably going to get rejected and it's probably going to be sent back. So but then watching the visa bulletin and strategizing what you're going to do once you get it in your hands is another thing to have in mind.
Okay. All right. Thank you so much for answering the question, Ruby. Let me quickly move to another question. I also have a question here from Jeremy. But Jeremy, we are going to take that in a while. Let me please complete these Facebook questions before. So this next viewer says, "Hi everyone, I'm currently on an H1B visa and have received a jury duty summons. Am I eligible to serve as a juror, or is there an exemption for visa holders? What steps do I need to take to confirm my eligibility or respond appropriately? Any guidance would be appreciated."
Well, that is quite a fascinating question because I think you have to be a U.S. citizen to be a juror. So, what I've seen be an issue is that they tie jury summons with driver's license. Did at any point you say you were a U.S. citizen when somewhere accidentally? Because as far as I know, you need to be a U.S. citizen to be on a jury. But I think that I don't know if that's a blanket across the country. I think it is, though. Actually, I've never been asked this question before. But let's see. I think that, yeah, I think you have to be a U.S. citizen to be on the jury. So now I'm wondering, how did you get that? But it might have been you might have checked a box somewhere on the driver's license. So look to see what might have triggered you getting that, because I've seen this happen a couple of times, where people accidentally registered to vote when they got their driver's license. So look to that, and then I'd say have a consultation just to see if we need to clean something up there.
Okay. Thank you so much again for answering the question. Let me quickly move to the next one. So the next one says, if we can zoom
And I
it in a
think we
bit. Okay.
might have to make this one of the last ones. Sorry for timing purposes, if that's okay. I've got
Okay. So this person says, Indian citizen living in USA on H1B. I recently renewed my Indian passport from USA. So while traveling to India, do I need to carry both the passports, new and old? Also, while coming back, will I-94 be marked to the new passport? But it doesn't have visa, as USA visa is an old passport. Will there be any issue? Also, I'm planning to go to India for a visit for a few weeks. Any suggestions on necessary documents needed to come back, even if I have stamped visa on old passport that I would be carrying?
Usually this is just that annoying thing that happens because your visa's in the old passport, so it's best to have both of them. Often, I believe they put the visa stamp in based off of where the visa is located, but ultimately, it would be good to eventually transition to having it in your new passport. But this is just sort of what happens. We're going into some new territory, so I don't know if you have an attorney already, with your company, or you need to have a consultation just to make sure what the requirements are at the time. But for the most part, verifying your employment and having those up-to-date information it's always safe to have. And we could be getting some updates as to what the answer of returning or getting, that was one thing I forgot to mention that Biden did, is that they waived interviews, right? They waived interviews for people who previously had like a B2 or an H1B, like in some select situations that they were exempt from that when they were at consular processing to come back. And I'm not sure if that's going to be continued or not, or if they're going to, make them all go do appointments and things like that. So I'd say have a consult in your particular situation. But yes, in general, when your visa's in one and it's expired, you're going to be showing both, and then eventually you'll be trying to phase out the old one. But you always want to keep a copy of your old one and keep scanned of it, because if your long game is to get your green card, you're having those are so awesome, because They shows entries, exits, validity of periods, and so much. So no, always make a copy of that and have it somewhere safe so you can use that in the future.
Okay, thank you so much for answering that. But Ruby, if you can please give us like 2 or 3 more minutes, I'll be quickly
Okay.
be taking 2 more questions. Yes,
Okay.
because they've been waiting for quite some time. So Jeremy is here and he says, "Hey there, we've been living in New York City from 2019 August, and we are using Fregumen and they have told my wife and I from September 2024, we are just waiting for our green card. My wife is on L1 and I on L2. So any clarity on these types of visas and green card?"
Okay. Well, was it the L1A or the L1B? And is it based off of perm, or is it, you didn't say what your nationality was either for visa availability. So I wish I could help give, I don't know. There's so many different factors, right? So what was the basis of the green card? What are your nationalities? What's the visa wait time? And how much time do you have on the L's? And is it L1A or L1B? Because the L1A has 7 years and L1B has 5. But so those are things I need to know to help get, and what's the exact question? Because I think I don't know what the question is, but, or there's a follow-up on clarity of these types of visas, British and Indian. Okay, well, who's British and who's in, okay, well, so let's just say in general, but I mean, you can have a consult just for you, even though there's Bragaman is the attorney for the company, but just to understand some of these things. Okay. The L1, there's the L1A and the L1B. The L1A, like I said, has 7 years, L1B for 5 years. You have some of the same rules as H1B. You can recapture time and there's dual intent. So it's really nice. If you're the L1B, you're usually going to do the perm. And if the L1A, there's another way and it's a little bit, okay, so you're British. My wife is L2 and she's Indian. Okay. So, but you didn't say whether or not you're L1A or L1B. Maybe you're L1A. I don't know. But anyway, if you're L1A, then the green card process, especially if you're British, is probably is a lot faster if the company is sponsoring you. And so I don't know what the original question mentioned, something about September. They have told my wife that we were just waiting for our green cards. So I think if you're saying that they filed the green cards, the 485, then you would have those receipts and you're just waiting for the processing. And you can also go to USCIS website under processing times to see what those processing times are. But if you're saying like they haven't even filed the I-140, okay, the wife is British and she's an L1A. Okay, well then this is a faster process because of that. But I don't know exactly if you're asking me like they filed the 485s in September and you're waiting for the green cards to come in the mail. Check to see what receipts are there. You can check the receipt on the processing times and for the case status, and then that can give you a better guidance. But if the wife is British and she's okay, did they premium process the I-140? So the wife is an L1A. She's British. She's the primary. The I-40 was completed. Well, it's likely the company sponsored. And so I think that you can check for those processing times. And I don't know if the I-140 and the 45 were filed concurrently or not. But anyway, these are some of the things I need to know to help give you a little bit more guidance. But it looks like
Jeremy, maybe you can directly get in touch with Ruby. How about you directly get in touch with Ruby? Yes,
that would
the
probably be
details.
best.
Yeah. The details are displayed here on screen. Give her a call on the number, send her an email, visit our website, get in touch with her. And yes, I'm going to read out those details in the end. But before I do that, I would also like to quickly take one more question before I let you go, Ruby. It's from Hiren. And Hiren says, due to technical issue, my employer submitted 2 applications for the same employee due to this USCIS and sent RFE for H1B. Then how can we handle this? What do you have to say?
You're welcome, Jeremy. So due to my employer submitted 2 applications for the same employee due to USCIS sends RFP for H1B, and then how can we handle this? They sent 2 separate H1Bs completely. What was the RFP asking for? I need to know a little more as to are you talking about registrations or are you talking about H1B complete packets? Like they just sent the same one twice. And then was one of them supposed to be like for you potentially? And there are sometimes you can try to solve problems with liaisons, like with the American Immigration Lawyers Association, we have liaisons. But I really, unfortunately, need a little more about this question to sort of figure out how to troubleshoot it, and how big of an issue it is, and knowing what the RFE is for would be helpful. So, you know, there's been, I mean, I don't want to say second guess your attorney, but there is a benefit to having a second opinion occasionally, just like you would with a doctor, right? And if you want to, if they're not, completely answering your questions, or you just want to have another opinion, there's no harm in that. You just pay for a consultation fee, you get another opinion, and maybe you don't even make any changes, but it gives you a little bit more peace of mind and to maybe think outside the box of what could be a way. These are sort of the situations I call, like, when the train gets off the track and you're like, oh, this is, how do we get it back on track? And sometimes it could be a human error, the firm, or it could be a human error or some type of error at USCIS, and it can cause unnecessary stress. But when people, crowdsource other attorneys, and even those attorneys are talking to other attorneys, they can, and have practiced for a while, they can find out ways to troubleshoot things. I know that I've had some funky things in the past, whether it was because of ours or USCIS, and the more I practice, the more I go to CLEs and talk to other attorneys, the more I'm able to figure these types of things out. So I know that doesn't exactly answer you, but I do need a little more to help answer that question. But I think that is that our last one for today? We went a little over.
It is. Yeah, so Hiren, maybe you can also get in touch with, with your detailed question, maybe write your question in detail with each and every aspect regarding to your case, and send it to Ruby or give her a call on the number. You can directly get in touch with her by calling her on the number 713-589-2085. You can also email her. Her email ID is contact@rubypowerslaw.com. You can also visit her website, which is www.rubypowerslaw.com. And we also had one more question by Vivek, and he wanted to know about EB3 visa from Nepal. But Vivek, we are going to do one more episode on EB3 visa. So you stay tuned on this space. Make sure you subscribe to Immigration and Jobs Talk Show. We are going to give out more, we are going to come up with more webinars and more updates regarding EB3 visa. But for now, that's it. So thank you so much, Ruby, for being here. Thank you so much for, giving us this time, and your answers were insightful, detailed. So thank you so much for everything.
Oh, well, my pleasure. Thank you, everyone. I hope I could give you a little bit closer in the right direction. And nothing takes the place of just having a good old private, consultation. But, it is good to see what's out there and learn. And it's great that you have this forum. So thank you again for inviting me, and I hope we can find some other ways to collaborate in the future.
Of course, we'll be more than happy to do it. And yes, I'll get in touch with you again for maybe another episode. And whenever you have time, please let me know. And we would love to do another webinar with you.
Thank you.
Thank you so much. Guys, thank you so much for being here, for posting all your interesting questions. And yes, if you were able to get your answers, great. And if you want, make sure that you get in touch with Ruby so that you can get your answers in detail. But for now, I'll have to take your leave. Thank you so much again for posting your questions and watching the webinar. make sure that you subscribe to the channel, like the video, share with your friends and family who are looking out for answers to these questions. And like I said, for now, I'll have to take your leave. I'll be seeing you all very, very soon in another webinar. But for now, take care. I'm Rajni Parara signing off. See you.
Hello, everyone, and welcome back to Immigration and Jobs Talk Show. I'm your host, Napasa, and I'm here with another webinar for you. Very exciting one. It's going to be very insightful. But before we head on with today's topic and who's going to be our guest, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks, we are streaming live right now on YouTube, LinkedIn, Facebook, and on X. So, please feel free to join us by commenting in whichever platform you're watching. And better even, you can join us on call, and our guest is going to be here. Maybe you can ask your questions directly by joining us on this call. And the number is 425-436-6335. And the access code when they ask for it is 988-888. And once you're in, just speak. We will be able to hear you. So thank you so much, friends, for joining us. And yes, today's topic is actually a very, very significant one, especially to the Indian community, in the United States. So what do the 2025 US visa rules mean for Indian workers and students? That is our topic for today. And the new rules, especially with regard to H1B, are really creating curiosity among all the folks out there. And understandably, some are concerns about what lies ahead, especially for Indian workers and students. So to help us, get insightful knowledge about this today, we are going to be joined by a distinguished guest, none other than attorney Justin Rivera, a renowned attorney from Wasden Immigration Litigation. And he has years of experience, about different complex immigration policies. And Justin is going to be here to share his valuable insights on what these changes mean and how can we prepare for them. So without further ado, please help me welcome attorney Justin Rivera from Wasden Immigration Litigation. Hi, Justin.
Hi, Nipasa. How are you doing today?
I'm doing great. And this is our first webinar in 2025. So I'm very excited. I'm really wishing you a great year ahead. And yes, I'm looking forward for the session.
It's going to be busy.
It is indeed. So maybe you could give us an overview, what can folks expect from today's session?
Yeah, well, I think, we'll all continue to delve into our crystal balls over what we can expect with this year, with the caveat that there's a little bit more information now kind of starting to trickle out. As we were talking about a minute or so before we started talking, I actually just got off another call that was a pretty extensive webinar with people who actually worked in the State Department and at some of the consulates around the world during the Trump administration. So it was a very insightful opportunity to kind of learn a bit about what it was like under Trump's first administration, what things were done and how those policies were implemented and rolled out. And they also ended by talking about the relationships that they have with people who are going to be going into the next administration, going into this iteration of the administration. And so if you guys will humor me for about 2 minutes, I did want to kind of give you guys kind of a peek behind the curtain, because this was a call that was particularly for attorneys, more so for all of us to get ready to think about challenging things through litigation or devise new strategies to kind of deal with what's going to change. So I'm going to be looking at the notes I took which were very interesting. Biggest thing that I wanted to kind of bring back, there's been talk about the travel ban. Will there be another travel ban? It looks like yes. Pretty much, it seems, if not set in stone, then absolute, then close to, that there's going to be some new iteration of the travel ban that's released shortly after the inauguration. The thing that seems to be up in the air is about whether the travel ban will be a set number of countries, specifically countries like Iran, Iraq, Libya, Somalia, Sudan, Syria, Yemen, or if the Trump administration is going to ask DHS to create their own process where they would make a list of countries based on whatever prerogatives there is that they think are necessary to create this travel ban, or Muslim ban, whatever you'd like to call it. So the travel ban is going to come back. It's just basically what countries are going to be listed on it. I guess we'll have to wait and see. It was really interesting to talk to some of the consular officers who were a part of the last administration about the travel ban. The way that travel ban initially worked, it was a lot of stop and starting, meaning, it was instituted, it was stopped, it was instituted, it was stopped. There's a lot of confusion, not only at the consulates, but even at CBP. I think people, if you remember, there was, days where there were protests at airports because people were not being let into the country because of all of this confusion over who was admissible and who wasn't admissible. The consulates had the same kind of insanity. My understanding is they basically were given a short memorandum and told, hey, 72 hours, this is going into effect, and you're going to have to figure this out. One officer actually went so far as to say that it was not until 6 months into the implementation of the ban that they received a formal training, which I think anyone in any profession would have to say that's insane,
Insane.
But the fact of the matter is, we saw with this previous administration, it's a lot of just shoot first and ask questions later. We're going to go try and do X, and you figure out a way to make it work, or it gets stopped and then we move on. So kind of moving on from that, extreme vetting coming back. The Title 42 ban. The Title 42 ban was previously used during COVID at the southern border as a reason to deny entry to migrants because they were in a country that had a communicable disease. COVID obviously was the name of the game there. There is talks that they're going to attempt to use that again. What communicable disease they're going to use, I'm not exactly sure. I know bird flu is really hot right now. Lots of people scared of bird flu. Maybe that. But that looks like it's something that's going to come back as well. Things that are important for everyone and not just specific nationals. Interview backlogs. Hoping that those will be improved, but I was not very hopeful from the call that I was on that that's going to be the case. Interview waivers being removed. There was talk about what were the easiest ways to make the immigration system function worse, meaning making it more difficult for people. The removing of immigration waivers, which was something that did happen in 2017, is an easy way to make a slow system even slower. So that's a possibility as well. And the last one really hurt me, honestly, because I thought it was one of the things that the government actually had done well, the removal of the domestic visa renewal program. Sure, some people are aware that there was an implementation of a pilot program for the domestic visa renewal. It saw, tons of positive feedback from the community. And of course, that would make sense that if it was a positive thing, it'll be taken away. So those were some of the big things that were noted during the call that I thought that was really, really interesting to bring up. If you're a Russian foreign national or a Chinese foreign national, get ready for, enhanced vetting, probably an increase in the provision of 221Gs. That's going to come up as well. A really interesting facet was the idea of moving consular processing to DHS from the State Department. That argument was basically done under the guise that the State Department isn't adequate or equipped to handle consular processing, and so it should all be brought under the purview of DHS. That's really interesting because it would kind of change the game on how everything worked, because then you're looking at basically USCIS kind of holding all of the cards. And I'm not sure if that would be beneficial because it could open them up to more scrutiny from a litigation standpoint, or it would be harmful because it'd make it easier to implement more restrictive policies. That would require statutory action, though. So that's something that's not a day one sort of implementation. That's something that would have to actually be thought out. The last stuff, which was kind of the hot button issue that I think everyone was aware of during the election, is the challenge to birthright citizenship. Realistically, like I've said, and I will continue to say, I don't think this is something that could really happen. I would be surprised if it did. But what the people on the panel brought up, which I thought was interesting, was you're going to see more of an attack on this idea of birther tourism. So what birther tourism essentially is this idea that you're obtaining a visa for the reason of entering the United States to have a child in the U.S., because if the child is born in the United States, they're a U.S. citizen. So the idea is making it more of an issue at the consulate, making it more open for consular officers to deny visa applications to individuals that are pregnant unless the travel to the U.S. is done so for medical reasons. And right away, and I don't say this to be crass, I'm being genuinely honest. Right away, I thought, and I even asked the panel, like, so do the officers then have to just make decisions on who looks pregnant or who doesn't look pregnant? Like, do they assertively ask someone if they are pregnant at the outset of every interview, if that person is capable of birthing a child? Like,
Maybe there will be a pregnancy test too.
Maybe so, but what they actually came back and said was the consular officers, by and large, they likely don't want to do this because it's an uncomfortable thing. But you know who'd be psyched about doing it? CBP. Apparently, CBP officers seemingly have no problem with doing something like that and would be more than welcome to refuse someone entry to the United States under this guise. Now, I don't have a bad opinion of CBP, but if I could kind of give you an idea of what I deal with CBP on average, I had someone on Monday night in secondary inspection for 3.5 hours because they were related to an employer that had been found guilty of fraud. Now, this person had gone through a lawsuit in which they had won the lawsuit, their fraud claim had been removed, and they were carrying with them a copy of the document that confirmed that the fraud finding had been removed. Despite all of that, secondary inspection detainment for 3+ hours. So my opinion of them is not very favorable, in that I feel that they abuse their powers, and I feel that they definitely make an effort to target not even people of certain nationalities, but people with certain immigration history backgrounds, people that have been in the United States on F1. I think they're much more diligently going after those people than somebody who, is just coming in on an H1B. All that being said, my understanding of all of this was the restrictions on birthright citizenship would outright be very difficult, but there's ways to get around that, and I think it's something that they're going to try to take advantage of. One person made a very interesting point, and they talked about passport applications. And I had never thought about this before until this person had brought it up. They said, what if there is an implementation of a process to determine if someone is a U.S. citizen for the purpose of obtaining a passport? Were their parents on visas when they entered the U.S.? Or something like that. That isn't necessarily stripping them of birthright citizenship, but is creating mechanisms and systems that are in turn going to make their life more difficult. That might be something that we're going to see. And so all of that, which I've taken up, 10 minutes of our hour with that, all that was to say, I just wanted to relay that information while it was fresh in my mind.
Great information, seriously. And latest information, great updates. I think we shouldn't have missed. And we are lucky that you were a part of that webinar and you have so much information to share with us today. Justin, thank you so much for that.
You're welcome. And with that being said,
Sorry, please go on. Carry on.
No. I think we had a little bit of a connectivity issue. No, I was just saying, with that being said, I know we had a couple questions we wanted to address today, so we can turn to that if you're ready.
Yes, but from what you have shared, it really sounds like, Trump 2.0 is going to make everything more complicated, more lengthy, and a lot of scrutiny. they're going to make it difficult, and seems like there are going to be longer wait times as well. So let's see what's going to happen.
Mhm.
All right, so Justin, let's head on to our topic and some questions that we had prepared. So, my first question to you is, what changes in February 2025 visa bulletin will benefit Indian students and even professionals who are applying for US green cards?
So I did take a moment to look at the visa bulletin before the call. The February bulletin's actually already come out, usually does around middle of the prior month anyway. There was some slight incremental growth. I think your EB1 still sitting at Feb 1, 2022, which isn't terrible, but not, the best. EB2, you're looking at October 15, 2012, EB3, December 15, 2012, and you have your final action dates being used right now. It's very slight, very minute incremental growth. I don't know if we're going to see much change moving forward with this year in that regard. I think there's a lot of people putting their eggs in the Doge basket, which is like this idea, that there's going to be an increase in government efficiency, particularly within employment-based immigration, because obviously there's been signals from this administration that there's a favorable view of the employment-based visa programs. I know the H1B has gotten a lot of particularly love recently, or hate if you're on the other side of it. But how that relates or doesn't relate to what we're actually going to see with the visa bulletin, it's kind of a wait and see. We're going to have to see what happens and if there's any sort of big changes planned. I know that there was this idea that it's just something that was floated by Trump, which get ready to go back to that, right? This guy says something, we all think, what does that mean? And then we pretend we know, and then we see what happens. But I know there was an idea floated about tying H1B visa sponsorship to a faster green card path. Obviously, if that's possible, I'm all for it. Let's do it. But until somebody actually sits down and says, this is how we're going to do that, we're stuck with the systems that are in place presently.
Right. Right. Thank you so much, Justin, for taking that up and for the update for Indian nationals. So EB1 looks good, and the others still just have very slight changes. Thank you for the update. And let's go on to my next question to you, Justin. And, there are so many new rules coming up, US visa rules. And do you think that there are new opportunities for Indian students who are looking to stay in the US after graduation?
So I think for people that that get picked in the upcoming lottery, they really got lucky with the cap gap extension, because that's legitimately beneficial. Previously, the way cap gap worked is basically if your case was selected and you were working subject to work authorization, you had a gap. Basically, let's say your STEM OPT ended in May or something like that. If you had a timely filed H1B change of status, you were able to continue working all the way up to 10-1 on what's called cap gap. However, that ended on 10-1. So unless your case was approved by then, you would still be able to stay in the United States, but you would lose your work authorization. The problem with that is if you're an employer and you have an employee and the employee can't work, why are you going to keep the employee? So what I thought was a very interesting and beneficial move from the DHS was they moved it to April 1st of next year. And what that does is it no longer puts pressure on the employer and the employee to rush to get that case approved by 10-1. A lot of times what you would see is the wait and see filing and regular processing around, May, June, whatever. And then a rush to upgrade to premium in September, because everyone needed that 10-1 work authorization. Now that that's not the case, I think you have two circumstances. The employee continues to have that work authorization until April if they don't want to pay the $28.05 for premium, the employer. And CIS no longer sees this mass strain where they're having to prioritize all of these cases, and instead can just allocate their workload accordingly, keep it at the same level. The other thing that I think was legitimately beneficial was the ability to move the start date. Most of the time, all the time, 10-1 was the definitive start date. First date you're eligible for H1B, 10-1. Looks like now you have more wiggle room. You can move that back. And I think that that's great for someone who has, let's say maybe another 8 months, 10 months of STEM OPT. that they want to utilize before they start that 6-year clock on H1B. I think that's a benefit as well. So I think we've gotten some good wiggle room, things that are going to be helpful for anyone transitioning from F1 to H1B, and that should give people more opportunity. The other thing that's beneficial for graduates, they have expanded the qualification for CAP-exempt employers. For anyone who lacks familiarity, CAP-exempt employer is an employer that is able to sponsor an individual for H1B without that individual having to go through the lottery. Now, it was fairly restrictive to basically like nonprofit organizations and research institutions, universities, things of that nature. They have opened the door so that individuals are now able to work with companies who are maybe placing somebody at that research institution, or maybe they're working for a company who not all of their job falls within the prism of the nonprofit or whatever service it is to be CAP exempt, but what they're specifically doing does fall within that prism. It'll be interesting to kind of see how those rules are implemented and how that dynamic is shaped once those cases start to get filed and there begins to become precedent, essentially. But I think that it's beneficial, and I think it's going to hopefully open the door to more people being able to obtain H-1B sponsorship without having to go through the lottery, which does cap at $85K every year.
Yes, definitely. And these are some good news. Thank you so much for the updates, Justin, and for the detailed explanation. Thank you for taking that up. So now I have another question, and that is with regard to permanent residency. So how will the surge in visa availability this year, 2025, affect the timeline for Indian nationals who are awaiting permanent residency in the US?
Can you hear me okay? Uh-oh, I think we had a connection issue.
Are you able to hear me? So my next question is on the screen already. It is, how will the surge in visa availability in this year, 2025, affect the timeline for Indian nationals, who are awaiting permanent residency in the US?
Yeah, I can't really see anything.
Yes, we can hear you, but Justin, can you hear me? I really hope there's some connectivity issues though at your end. Really hope that. Maybe you can just rejoin. Yes, that'd be great. So, folks out there, thank you so much for joining us. In fact, you can even contact Attorney Justin Rivera. He's going to join us very, very soon, immediately, I guess. And what you can do is call him up on his number, or even leave him an email. But definitely go check out Wasden Immigration Litigation in LinkedIn, and his phone number is 844-592-7336, and that's where you can call him. You can even email Justin at support@wasden.law, and go visit www.wasden.law to get to know more about Justin Rivera. And Justin is back, so I think, yes, let's take up the question. I'm going to repeat, Justin.
I got
So,
it.
yeah, thank you so much for just coming back. So, my question is, how will the surge in visa availability in this year, 2025, affect the timeline for Indian nationals who are awaiting permanent residency in the US?
So, I mean, I'm hoping that people who have that 485 filed or close to filing, they're going to at least see a timeline drop. I mean, you can even go look right now, and if you even Google it just off the top of your head, and you're like, what's the timeline for I-485 processing? You're looking at, like, I saw 8 months to 2 years. I mean, it's so ridiculous that they're not even willing to put out a defined timeline. That being said, this is where I'll kind of hope that we do see an efficiency boost as a result of the administration change. No offense to the Biden administration, but I don't think they did the best job at processing these green cards. That's just my opinion. I think you could see it. I think that there was a lot of times where these cases dragged on for a long time. And yes, people have the opportunity to work subject to an EAD. And yes, they can travel with AP. And yes, they can remain in the United States while their case is being adjudicated. But they're in the United States in a constant state or a near constant state of worry, because unless they've remained on their non-immigrant status, their future is dependent on the adjudication of the 485s. I'm hopeful that with this suggestion that there's a favorable view of employment-based immigration, that we're going to see 485 processing become more streamlined. That is a hope and not a certainty. You could even say it's a wish, but it's something that I would like to see, because I think it's an area where they could actually implement fairly quickly changes that are going to help streamline something. I think for a lot of these employment-based cases, these 485s, it should just be a quick review of immigration history. I mean, 9 times out of 10, you're not dealing with somebody that was a member of a terrorist organization, or has ties to a questionable community, or entered the country in an unauthorized status. All of these people are typically people who have come to the U.S. legally, have remained in the U.S. legally, and just want to move over to a green card holding position so that they're not constantly having to renew their H or whatever that they're on. So I'm hoping to see processing improve. From what I explained earlier, I don't know if that's going to be the case at the border, at the consulates, but maybe with USC.
Okay. Thank you so much, Justin, for taking that up. And, we have a lot of Indian workers who are working or are looking for jobs in the tech and healthcare sectors. So, if you could update us with what new visa rules that are coming up this year, 2025, that they need to know about, especially with regard to green card and processing times. I think we lost Justin out there. But folks out there, thank you so much for joining us. Hi to Yash and Sneha. You can even join us on call. You can dial this number 425-436-6335, and the access code is 988888. It'll be really great to have you here. And I think we should take a short break. Oh, and I think Justin is back actually. So, yeah, Justin, something is wrong with the internet today, but technical issues are always there, I think. Anyway, so were you able to hear what I was asking? And even if not, I'm going to repeat the question. And the question is, we have a lot of Indian workers in the healthcare and the tech sector. So, and there are new rules and updates this year, 2025. So, if you could tell us what they need to know, especially with regard to green card processing times. Are you able to hear me, Justin? Looks like some bad connection out there, but we really hope that Justin can be back. So, of control, if you can just maybe guide him a little bit.
I don't know what's happening, guys.
But
trying.
we're just glad you're back somehow. Uh, are you able to hear me properly?
I can hear you, and then what keeps happening is I can hear you for like the first 15 seconds, and then you freeze up, but I still have audio, and then it says oops and kicks me out. Now, I just closed out a bunch of windows. I did have Zoom open still, so I don't know if that was a problem.
Probably.
But I got rid of that, and I'm hoping maybe that helps. I did get a message from Xfinity, who's my internet provider, who conveniently has decided that they're going to be working, which is like the worst possible timing. See, and there we go again.
I know. But as long as you
So
can hear me, I think we can
Yeah,
carry
I
on.
think, sir, control here. Sir, I think this is a bit of your connection issue. Did you try clearing your browser's cache?
No, it's
Maybe,
me. It's my end.
and maybe try to remove
Yeah.
close all the windows, and then we can pick it up from there again. Nipasa, let's go for a break.
Thank you, folks, for being patient, but stay tuned on Immigration and Jobs Talk Show because we have Attorney Justin Rivera from Boston Immigration Litigation. And don't forget to go check out Boston Immigration Litigation on LinkedIn as well. So, yes, let's go for a short break and don't go anywhere.
I'm back. Maybe. We'll see.
Welcome back, sir.
Wait 5 seconds and then we'll know.
No, let's not wait as long as it's working. So let's go for it. My next question for you, Justin, is that, we have a lot of Indian workers in the tech and healthcare sectors, and there are new rules and updates this year, 2025. So if you could tell us what they need to know, especially with regard to green card processing times.
So, not so much for tech, but I would definitely say for healthcare, I think that there should be a really close look at the new changes for cap exempt employers. I know that healthcare was definitely one of the institutions that people could attempt to utilize, especially for those hospitals that are connected to universities for cap exempt employment. So I think that with the expansion of the cap exempt rules, hopefully that gives even more opportunity for people in healthcare to find an alternative to having to go through the H1B lottery. Tech, we're going to have to kind of see what happens with EB2 NIW. For people that are familiar with the national interest waiver, it's one of those few ways where someone can actually self-petition for a green card. Really kick off that process. Now, that being said, I have heard through the grapevine, if it's not one thing, it's another. I have heard through the grapevine from people who specialize in EB2 NIW that we've actually seen kind of a more stringent application of NIW over the past couple of months that could correlate to a little bit of oversaturation in the market, particularly from individuals in the tech industry. And what I mean by oversaturation is you have bad attorneys filing bad cases. And what that has done is put officers on guard, essentially, put them in a circumstance where they're saying, oh, if this is a tech case, I don't know if it qualifies by virtue of the fact that, 5,000 other people in the tech sector think that they qualify for an NIW. So I will be interested to see if there are any changes policy-wise that are made for NIW, especially for tech, when we're going into next year. Because as we've heard from Elon Musk, who seemingly sits at the right hand of the president, tech is good and we need tech immigration. So that might be something where we see a little bit better of a path for people to getting green cards in tech.
Thank you so much, Justin, for taking that up. And looks like it's going to be good for healthcare sectors, even if not for tech yet. So thank you for that update. And next up, I wanted to ask, what are the key differences in the 2025 US visa rules and the previous years? And how do they specifically benefit Indian applicants?
So I think that kind of goes back to if you're already here and you're working on F1, that cap gap opportunity, the extension of cap gap, I think is going to be really positive. I think that'll be very beneficial. Moving the start date, the fluidity of the start date, I think is going to be beneficial too for everyone. But you have a lot of Indian foreign nationals, Chinese foreign nationals that are on F1s that work subject to STEM OPT. Maybe they want to push that start date back, giving them an opportunity to remain on their NIV, their F1 status. Where I think it's going to be interesting is part of the modernization rules for the H1B did include this idea of the bona fide job requirement. And the bona fide is allegedly a way for USCIS to adjudicate the viability of an H1B petition based on the fact that there must be a bona fide position available for the person that's a specialty occupation. And how does that work against moving a start date? Or how does that work when you're filing a case in, let's say, April or May, and the start date of the H1 is October 1st? Supply documents that show that there's going to be work available on October 1st, or by virtue of the offer letter showing that you're providing the position to the person, is that enough to get you through the gate of this bona fide job offer? If you're only able to provide state orders that show that there's only work available for 6 months beyond the start date. USCIS is claiming it won't, but it's also claiming that it now has the right to request all of those documents in order to determine whether the position is a offer. So I think things are going to be wacky for the first 3 or 4 months. I think decisions come out as officers begin to play with these new definitions. Hopefully it's all more established by the time we get to quota and people are filing those initial H1Bs, to go through the cap. Because cap denials are always terrible because you only get so many shots at the lottery. But yeah, I think the one thing that I've taken away from this is there are things that I like that have been changed. I do not like the bona fide job requirement change, and I'm hoping that it's something that sees litigation pretty quickly after it's implemented.
Absolutely. I think, yes, we will have to have some buffer time. I mean, Trump is only joining after 5 days. So after he joins, we will hear a lot of rules coming up and more updates. So we'll just have to wait a little more and see what's coming up in 2025.
Well, and it's wild. You think about it. These new policies, the H-1B modernization, they were going into effect whether or not Trump won. They go in on 1/17.
Right.
That's on Friday.
Yes.
And then the following Monday, his administration's inaugurated. And then I'm assuming they start issuing EOs on the 21st or the 22nd. So there was already change that was going to happen regardless of who was president, whether Biden won or Trump. And now on top of that, there's a new administration. So yeah, I definitely think it's going to be a crazy first 2 months. I cannot imagine middle of January to February being fun for anyone in this.
So true. So true. And everything is planned, and we'll just have to wait what they're going to throw at us. So thank you, Justin, for that. And I have another question, and that is if you can explain, if these 2025 updates, can ease a green card process for Indian nationals who have been waiting for years, all these backlogs.
So yeah, I think, like I said, you'll be seeing a wait and see for the 485 processing. I think there's mechanisms that can be put in place that can actually speed up the issuance of the green cards themselves. Whether or not they're able to actually move the bulletin up, I mean, we'll see. I think that's going to take a little bit more leg room. I think it's a lot easier to just issue policy memorandums, to USCIS to say, look, if everything looks good, just approve the case, rather than going into enhanced vetting of a process. I do think that barring any weird changes made by Stephen Miller, we should see hopefully a pretty streamlined lottery this year. I think, the beneficiary-centric lottery, it was done last year. It seemingly has worked in that it's vetted out the ability for multiple registrations to occur, which is a problem that USCIS had. So I think that hopefully we see a better lottery process with the introduction of the extended cap gap and the moving of start dates. I'm hoping that there's less stress on filing for everyone. So I'm hopeful for all of that. And I do think that that'll be beneficial. I think for Indian foreign nationals, they do typically represent a large amount of the individuals that are selected for H1Bs. So I think these changes will specifically benefit them. So it's just, we'll have to see, but I do think that that'll help. Deference, I think, will be a big thing too. Part of the H1B modernization is that we're supposed to be reinstituting deference. So if an extension is filed for, an H1B visa and it's the same employer and the person's doing the same job, it's supposed to be a quick approval. You're not supposed to be rehashing old issues. So I'm hoping with that being instituted as well, we should see very quick approvals for people that are on extensions. I think the people that are hopefully that are going to be in the best circumstance are going to be people who are, they've already got their I-140s approved. They're maybe waiting for their opportunity to file their I-485, but they're just staying with a company and they're just working with that company, waiting for their time. Hopefully they get to just kind of run through the process and they're okay. And administrations are only 4 years long. So in theory, you should only have one extension. So yeah, but we'll kind of see how that goes. I think the other thing which I brought up on previous conversations is the entrepreneurial H1B.
Yes.
This idea of being able to do H1Bs for themselves now, as their own owner of their own company. I think that's going to be really interesting and can be really helpful for someone maybe that's an Indian foreign national who's maybe been working in the industry for a couple of years and wants to strike out on their own. And they want to take an opportunity to open their own company or organization. That being said, I reserve the statements that I've previously made, which is those are only approved, I believe, for 18 months. Lots of new businesses fail. So we're going to have to see what those extensions look like. But I'm eager to work on those. I will promise you guys this. When I get my first entrepreneurial H1B approved, I will let you guys know about it.
Thank you so much, Justin. And I do hope H2B is where Indian nationals are excluded. So I do hope that doesn't happen with regard to H1B ever. So
no way. What would they do in the tech sector if that were to happen? It'd be insane. No way.
All right, Justin, thank you so much. And I think we'll take up a few questions from our audience, and we have about 10 minutes from you. So let's take up some Facebook questions first. Control, if you can display them, please.
If I can stay online.
I really hope so. But yes, meanwhile, let's take up Yash's comment. And he's saying, if the cap of H1B visas gets stricter, should Indian students like me consider applying under different categories like O1 or EB1A? What's the realistic timeline for these pathways? Maybe you can give a comparison.
Yeah, so I mean, like I said earlier, the NIW, I think your biggest issue is scrutiny that you're going to receive from USC. Right now, I've heard that the scrutiny is pretty high on those cases. I think you're going to have to prepare a really work with a pretty knowledgeable attorney, and hopefully you end up coming out with a positive adjudication. But like I said, NIW, I've heard from others. I don't do very many of those cases. I really try to only take them if they're surefire wins. I've heard from others who dabble more so in it that the decisions are getting wacky. They're getting weird. There's cases that seemingly look like they should be approvals that aren't getting approved, or cases that are getting requests for evidence that seem like dead ringers. The O1 is one of the most heavily scrutinized NIV applications, okay? Can you qualify for an O1? Maybe. It really depends on who you are and what you're doing. Is it easy to qualify for an O1? No. Qualify coming out of school. You have to meet the requirement to do so. I would tell, looking at an O1, you can look online. Go to USCIS's website. It's going to tell you the requirements. Ask yourself if you fall into enough of those boxes to qualify for an O1 before you're going to move forward. Benefits of an O1 are pretty immense. You don't go through a lottery. You're not subject to a labor condition application. And your company, if it's a startup, can even pay you in equity rather than having to pay you, a high salary. So there's definite benefits to it. The caveat to that is that the O1 is going to be more difficult for you to get than an H1B. It's just going to be seen as a higher level of scrutiny. can get them. Again, no one should file an O1 on their own. I would work with an attorney, make sure your case is set up from the outset, and move forward so you can get it done. I would say for anyone in the next couple of years, if you're going to be applying, if you want to do an O1 in the back of your mind and you're on F1 and you're trying to apply in the lottery, work on your resume for your O1 in tandem while you're building your H1B up. That way you're able to apply in the lottery. If you get selected, great. If not, you've got that O1 in your back pocket when it comes time. Maybe you're in year 3 and you're not sure if you're going to get selected or not. Register in the lottery and file the O1. Just do them both and see which one can work. But start working on that. You should be working on building up your O1 resume when you are finishing college, not the third year where you're in your last year of STEM OPT.
Okay. Well, thank you so much, Justin and Yash. I hope that was very helpful. Thank you for participating. Let's take up our next one. This is from Sneha. Sneha is asking, will the potential changes in wage levels for H1B applications make it more expensive for companies to hire Indian workers? And how should we prepare for this impact?
I mean, you're going to have to see if that's an actual implemented policy where the wage levels are moved up. This has been something that's been toyed around with last time Trump was in power, and now it's probably going to be rehashed. The easiest way to make the H1B program less appealing is to make it harder to qualify for an H1B and make it harder for a company to pay someone an H1B. I think at the end of the day, if you raise wages, the people who are weeded out are the smaller organizations. Bigger companies aren't going to really care if they got to pay somebody $20, $30, or $40,000 more dollars. It's not hurting their bottom line. The people that care are the 25 and under employee companies, where that's a big thing, a big decision to make, whether or not you're going to pay this guy $40K more or maybe pay a less qualified person who you don't have to sponsor. And so that's kind of what becomes the issue. I think when it gets to that point, you're going to have to really start looking at what are the benefits that can be provided. I know that there are certain, and I'm not a tax lawyer, so please don't, pretend I know these things. I know there are certain tax breaks that people can get for someone that's on an H1B if they've only been in the United States for a set number of years. Look into those policies, see if that's something you can present to your employer as a way to recoup fees, if there is an increase in the amount of money that has to be paid. That being said, there's not really a great workaround because the wages are set if the wages are set. So if you got to pay someone X amount to be a software developer in Austin, Texas, that's what you have to pay them. If they're a level 2, you pay level 2, level 3, etc. But we'll kind of see what happens with that. I can't imagine that a business-oriented individual who has the ear of the president, that would be, Elon and Vivek. I can't imagine those individuals would seek to make companies pay more money for employees. So we'll see. But yeah, that would be it. I would just say you're gonna have to find workarounds to make yourself look more appealing in that circumstance.
Right. But thank you so much for taking that up, and thank you, Sneha, for participating with your comment on YouTube. So we'll take a couple more questions quickly, and Control, if you can display them, please. So this first one is, my initial H1B was expiring on September 30th. Employer put in an extension for a few days before under premium processing. I received an RFE for maintenance of status since I got laid off by the end client, and my employer did not run payroll for 2 months. Now the employer told me they respond to the RFE. The deadline is 10th January. What are my options now? I'm really worried. Can I convert to B1 or F1 visa?
So not real. I would say a couple of things. First off, I would say you should report your employer to the DOL, because if you are still in the U.S. working subject to an H1B with the employer and they're not running your payroll, that's a violation. I don't know if they're operating under the guise that because the extension's not approved, they don't have to pay you. But at the end of the day, USCIS views maintenance of status pretty solely through the prism of, are you getting paid by your H-1B employer, and are you working where the LCA says to work? If you're not getting paid by your employer, you can't show maintenance of status. Yeah, I mean, it's very difficult for you to attempt to file a change of status to another status right now because you're going to run into the exact same problem. At the time of filing, how are you maintaining status? If you couldn't show that at the time you were filing your extension, you can't show that now. So I would probably say, post a bag. Period of stay authorized by the Attorney General allows you to remain in the United States up until it's denied. If the only issue on your case was maintenance of status, they should approve your H1B, but deny the I-94, deny the extension. So what that means is you should have an H1B that you could subsequently utilize if you still have an active visa, or if you have to go abroad to get a new H1B visa stamp, you could do that as well. A problem, though, with all of this is if your employer's not paying you, I'm not really sure how you're employed with them. So even if your H-1B gets approved for consular processing, the denial of the maintenance of status goes into your immigration record, and it's going to be available at the consulate. It's going to have to be something that you can explain. So you're going to need some sort of new support letter from your employer explaining that they intend to bring you back. That all being said, I don't really know what the employer put in your RFE response that was due on January 10th. So we would kind of have to wait and see there too. So I would say this. You need to see what the decision is and abide by the decision. The decision is denial without the H-1 being approved. You need to timely depart the United States and apply for a new visa abroad. If it's an approval of the H-1B, exit and take whatever steps are necessary to reactivate your H-1B to come in. And then you're going to have to work with your employer on that. But I would not really recommend filing an attempted change of status at this point to a B1 because it's just you don't have the ability to prove that you're maintaining status.
Right. Thank you so much, Justin, for taking that up. And all you folks out there, thank you so much for tuning in today. And a big thank you to you, Attorney Justin Rivera, for sharing your expertise today with us.
Thank you. Before we go, because I saw there was a couple of questions about F1. Oh, apparently I'll be allowed to. My connection is lost. Well, if you guys can hear.
Yes, we can.
Let me see if you guys can.
We can hear you.
Yes, sir. We can hear you, sir. No problem. Go ahead.
Nope. Again.
Oh, God. Sir, we can hear you.
All right. So I would just say thank you so much, all you folks, for joining us. And Justin, if you can just wrap up what you have to say before we leave.
Real quick, just a quick thing about F1. People who are looking at F1 status. OPT, initial ownership, not on STEM OPT. So no one should be taking unpaid internships on STEM OPT. I've seen a recent uptick in RFEs on that. OPT, you can take an unpaid internship. I have seen 2 decisions now, not my cases, for other people, where USCIS has denied STEM OPT, saying that the OPT employment, the unpaid internship, should have been paid. And they're using an interesting justification to do that. They're basically looking at employment law and basically saying they're kind of making up what can and can't be an unpaid internship, which is kind of crazy, but it's denials for these people. These people that are going for STEM extensions, their STEM is done. So they're in a bad spot now because they're now not able to get that extra 2 years. So what I mean by all that is this. Everyone moving forward, be careful with working on an unpaid internship while you are on F1. I would recommend staying with paid if absolutely possible. If unpaid, work with your school to make sure that it's going to fall within regulatory requirements.
Okay.
And that being said, I am done. Thank you all very much for your time.
Thank you so much, Justin. Really, we had some great updates, and we're really lucky that you could share them with us today. So really a big thank you to you, Attorney Justin Rivera from Boston Immigration Litigation. I'm really looking forward for our next episode already. So thank you once again. You have a great day ahead.
Thank you. Pleasure speaking with you guys. Y'all have a good one.
Thank you, Justin.
Bye.
So, folks, don't forget to like, share, and subscribe if you resonated with today's episode and you liked our insightful webinar with Attorney Justin Rivera. And yes, thank you so much for tuning in today. Don't forget to also hit the bell icon. Uh, we are Immigration and Jobs Talk Show, and we are on YouTube, LinkedIn, Facebook, and on X as well. So please feel free to connect with us. And you can also email me, and my email address is neepatstaffingme.com. And yes, connect with Attorney Justin Rivera. You can call him up on his number, and his phone number is 844-592-7336. And you can email him at support@wasden.law, and go visit www.wasden.law to get to know more about Wasden immigration litigation and Attorney Justin Rivera. Once again, thank you, folks, and stay tuned on Immigration and Jobs Talk Show, because I and Sam are going to come with a daily immigration dose at 4 p.m. Eastern Time. So until then, you guys keep having a great time ahead. Hello, everyone, and welcome back to Immigration and Jobs Talk Show. And we have another very interesting and very, very important session lined up for you. And before we have our guest in our episode today, I have this very important disclaimer, and that is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks, thank you so much for joining us. We are streaming live on YouTube, LinkedIn, and on Facebook and on X. So, please feel free to comment wherever you've joined us, and maybe you would want to know more with regard to the topic. And it's super exciting that we are going to be joined by our very special guest who has been with us for over a year now. So please help me welcome him, none other than Attorney Chand Parvataneni from SPB Law Firm, Dallas, Texas. Hi, Chand. So good to have you back. And this is our first episode this year. So here's wishing a wonderful 2025 ahead.
Yeah, thank you, Nipasa, and thank you for all the viewers watching, and a happy new year to all. This is my first show with you this year, and hopefully, we'll have a lot of engaging, knowledgeable sessions throughout this year.
I am already looking forward for all of them, and especially this one today, because we hear a lot of changes that are coming up. And yes, with regard to H1B starting tomorrow, right? It's the 17th of January. So we are going to have a lot of updates. And also with those new changes, new rules, we are going to have new H1B RFEs, site visits. So would you like to tell us what people out there who are watching us right now, what can they expect from today's episode?
Sure. So what happened is Biden's administration, under Biden's administration, Department of Homeland Security, DHS, they published a final rule in December. So December of last month, that's 2024, the final rule was published. And 30 days after the final rule is published, it takes into effect. So a lot of changes were codified, and they were published. And the 30th day ends today. So tomorrow, starting tomorrow, which is January 17th, all these new rules kick into effect. And these rules are proposed to strengthen the H1B program. And some of the rules are good, some of the rules are bad. But overall, I think it's yeah, I mean, one thing that's going to happen is things are going to change because now we have new rules. New rules have been codified, so a lot of things will change. And to give a perspective, what happened in 2020 is that in 2020 there was a lawsuit, and after the judgment, USCIS went and rescinded a couple of old memos. So these old memos talked about client letters, contracts, and a couple of other things. So USCIS, based on that lawsuit, based on the final outcome, these old memos were rescinded. And starting from 2020 June, what has happened is client letters were not mandatory, and contracts were not mandatory, and a few things were changed based on what has happened in 2020. So for the last 4 years, things were happening in one way. And because of the lawsuit, because what really happened in that lawsuit was USCIS failed in that lawsuit because they did not follow a proper procedure. So they have to follow procedures under Administrative Procedure Act, APA. And if they do it, the rule will be valid. And because these old memos did not follow those rules, they lost that lawsuit. So over the last couple of years, they went through the process. This time they did it properly. So they went through the APA process. They published the draft version of the final rule. They gave some time for public commenting. They went through all those comments, and then they published the final rule. So this time, so basically whatever happened in 2020 with that lawsuit, I think they used all that experience to finalize this rule. And going forward, because a lot of things are codified, USCIS is required to follow these rules. And because of this, we can expect a lot of new RFEs. The reason is in the last 4 years, we did not see RFEs for contracts. We did not see RFEs for employer-employee relationship and client letters. Now, these kind of things will change. Now, again, contracts are mandatory. USCIS codified the definition of specialty occupation. They changed the definition of specialty occupation. They also codified some rules around site visits. Previously, site visits were done differently. Now, site visits are going to be done differently. So, all these rule changes are what are going to come into effect starting tomorrow, which is January 17th. USCIS is also publishing a new I-129 starting tomorrow. So, starting tomorrow, a new I-129 has to be used. And this incorporates a couple of these final rule changes. And because of these new rule changes, USCIS can start looking at things differently. And based on that, they can start issuing new RFEs if the documentation does not conform to what is required as a part of this new regulations.
Right, right. So thank you so much for that overview, on what we can expect, especially that there are changes coming in starting tomorrow. And with those new changes, we are going to have new H1B RFEs as well and different site visits as well. So thank you so much, Chand. And moving on, let's just hop in directly to our questions. So I have this first one with regard to specialty occupation. It's a new rules which are effective and the changes of getting an RFE, for H1B applications, and what can employers do to get ready for all of that?
Sure. So, in terms of specialty occupation, so the rules have changed a little bit. So now what they're saying is it doesn't have to be a single degree. Multiple degrees that are related can be used. So, for example, if you say a job requires a computer background, for example, so a computer science degree might be the right field. Maybe software engineering also might be the right field. So, what USCIS is currently saying is yes, you can have multiple degrees required, but each of those degrees should somehow correlate with the job duties. So the job duties are going to be very, very important. And we probably will see increased number of RFEs for specialty occupation. The reason is now USCIS is emphasizing that a job must require a bachelor's degree. And not only that, that degree must be related to the job duties. So basically, what it means is the jobs, sometimes the jobs are a little bit broad, and the job duties are what is going to determine whether you require a bachelor's degree or not. And if the employer requires, say, a little bit wide degrees, for example, computer science, IT, and software engineering or software engineering. So USS is now not going to come back and say you are requiring multiple degrees. It doesn't have to be a specific specialty. It can be different specialties, but all of the specialties that the employer requires has to have a correlation with the job duties. So what that means is USCIS will look more closely whether the degree requirements are actually essential for performing the job duties. So they're going to look at the job duties, they're going to look at the requirements. And what it could mean is sometimes it could result probably in more RFEs. And so what employer has to do is you have to demonstrate that there is a direct connection between the job duties and the degree of the employee. So if all of those don't match, you might probably see more RFEs. We also probably will require more documentation because the employer will claim a particular degree is required, will claim that the job is complex, will claim that these are the normal industry standards. But based on the new rules, that is probably not enough. And one of the things that the new rules are saying is the client requirements, the end client requirements. Sometimes when there is a third party worksite kind of an arrangement, the end client requirements also determine what whether the job is specialized or not, specialty occupation or not. So more than likely, we might require client letters where the client actually talks about the job requirements. So USCIS will also ask for documentation that the client, the degree that the client requires. So tomorrow, if there is a third party worksite kind of an arrangement, if there is no documentation from the client on whether a bachelor's degree in a specific field is required or not, tomorrow we might see risk of more RFAs, probably more denials. And not only that, some occupations I think will see more RFEs, and occupations like marketing, for example, marketing analyst, and also probably certain IT roles where the job zone. So every occupation, normally what we do is we go and check in ONIT, Occupational Outlook Handbook. We see what is the degree requirement. And some of the jobs, like for example, computer systems engineer or web developer, if you go and look in ONIT, the job zone, it is a zone 3 occupation, not a zone 4. Zone 4 is basically the normal requirement is a bachelor's degree. So more and more USS is going to look at the ONET requirements, and if a job is not in job zone or higher, more than likely we might see issues. And what that means is certain IT roles more than likely will start having issues. And the immediate thing I can think of is definitely computer systems engineers, web developers, and there are a couple of occupations. So all we have to do is go and look in Own It and see what the job zone is. And if the job zone is 3 or anything below it, more than likely you'll have a problem. 4 or above, more than likely you at least meet the initial test. So all of these things, what it means is employers can expect to see more and more specialty occupation RFEs, because we had a way of USCIS doing things all along. And into the future, the new rules talk a lot about specialty occupation. They have made a lot of changes about specialty occupation. They talk about end client requirements superseding the actual employer's requirements. So all of these things mean we'll see more RFEs on specialty occupation that we have not been seeing in the last 4 years. And employers have to be ready. And what that means is ensure your job descriptions are very detailed. So when you're filing a H1B, if the employer does not give a proper job description, a very, very detailed and very, very elaborate job description, you will definitely see RFEs. So definitely try to give elaborate job descriptions. And in my opinion, if you're not giving at least a whole page of job description, a detailed job description, USCIS more than likely will come back at you. The reason is when you're filing a H1B, you're filing a H1B for 3 years. So you really have to tell USCIS what your employee is doing for the next 3 years. And if it is like a very, very small, short summary, USCIS probably will not be happy. So try to keep your job descriptions as detailed as possible. And not only that, you upfront you have to show clear evidence of job's complexity. So employers should be prepared to submit documentation demonstrating that the role is indeed a complex occupation. They can probably include expert opinions or industry standard documents upfront, basically the own it, the occupation outlook handbook. Those documents should be part of the file upfront. And the petition should upfront establish that the job cannot be performed by somebody that at least does not have a bachelor's degree or above. So this is very important. And going forwards after Jan 17th, you also have to focus more on employees' qualifications. So if an employee does not have a degree in the right field, so if the employee has a civil engineering degree or a mechanical engineering degree or a commerce degree or a business degree, and employer is filing for a job in IT field, more than likely you'll see more and more RFEs, more and more denials going into the future. So documenting employees' qualifications, maybe their experience letters, maybe their prior experience, if their job is not in the relevant field, putting evaluations upfront. These are probably very, very important. If not, you'll see bad RFEs starting from Jan 17. And that being said, I think the rules are going into effect starting from tomorrow. So more than likely in about a month or so, we will have more data because we will see more RFEs based on the new regulations. And as regulations evolve, employers need to stay up for further clarifications or guidance from USCIS. More than likely, what I think will happen is down the line, USCIS probably will issue a memo or some kind of a guidance that will summarize how they will process cases based on these new regulations, and being proactive, being up to date with the guidances from USCIS, detailed job descriptions. That is the only way to reduce the likelihood of specialty occupation RFAs, because the new rule changes make a lot of changes for specialty occupation.
Well, thank you, Chand, for the detailed explanation and for highlighting the many changes that are coming up, and they're all going to come into effect from tomorrow itself. So, folks, just be ready, and especially employers out there, it's important that you take note of the points that Chand has clearly highlighted, and see that you follow, especially the detailed description for any job. And Chand, we also have viewers who have joined us with their questions. So I think I'll just say hi to K. Vishwanathan, Kavita, and I think we should also take up K's question quickly, just so we can move ahead.
Sure.
Yes. So blanket L1 petition being filed tomorrow. Can you confirm the timeline to get approval, and when can I get my visa interview and passport stamped?
Sure. The good thing is for L1s, no rules are changing from tomorrow. So the rules, whatever rules we have today, will stay even tomorrow. It's only the H1B majorly that the rules are changing starting from tomorrow. So for L1, I mean, the company is going to file the case. The company has to wait for an approval. And for L1 cases, company can do it in premium. So if a case is urgent, normally the companies do it in premium. And the minute you get an approval for the case, the company gets the L1 approval, and you can, at that point of time is when you actually look for going up for stamping. And stamping, if you keep monitoring the dates, typically within a month, more than likely you will get dates. Even though it looks like you might not get a date, you have to keep on checking the website. So once the case is approved, probably within a month, more than likely you can go for stamping. And at least L1 at this point of time, we are not seeing any proposals to change the rules. So at least we don't think anything is going to change for L1s, and the rules that are currently there probably are going to stay at least for the next couple of months.
Okay, thank you so much, Chan, for updating us. And I hope, Kay, that you got your answer to this. And if you have more questions, please feel free to keep commenting. And I think we would love you to join us on call. Anybody out there watching us, if you have any questions for Chan directly, you can join him and me here on call by dialing this number on the screen that is available. So the number is 425-436-6335, and the access code is 988888. So please feel free to join, and yes, we will be hearing from you. And Kavita, please stay with us. We are going to take up your question very soon. But Chand, my next question to you is, what do you think will USCIS check during site visits, under the new rules, and how can employers follow the new rules to avoid having their applications denied or cancelled?
Sure. So one of the things that majorly changed and was codified as a part of the new rules starting tomorrow is the site visits. So we had the site visits since almost 2010. The site visits are conducted by the FDNS officers, and as a part of the site visit, normally what they do is they come unannounced. They come to the employer, they come to the work site. Sometimes they come to the home and start asking questions. And the rules that we had so far, all along till today, end of today, January 16th, is that the FDNS site visits, when the officer comes, participation in an FDNS site visit is voluntary. So what that means is we do recommend the employers to participate. We do recommend employers to give as much information as possible. That being said, if an employer does not participate in an FDNS site visit, if in the current rules, if the employer or the employee say that they don't want to participate in the site visit, normally what happens is the site visit ends. And if USCIS is not satisfied with the answers, they normally issue a notice. And as a part of the notice, they ask for answers, but at least they don't revoke the cases, they don't deny the cases. Uh, if employer or an employee say that they don't want to participate in a site visit, and that was the rule all along. Site visit participation in site visits is voluntary. Starting tomorrow, Jan 17th, what has changed is, as a part of the new rules that were published in December last month, that will be in effect from tomorrow, site visit participation in site visits is now compulsory. It has been codified as a part of the new rules. It has been codified. So what that means is, if there is non-compliance, if they don't cooperate with the officers, if they don't participate in the site visits, the cases might be denied. The cases might be revoked. How exactly USCIS will do that? We don't know yet, but they now have that authority. Based on these new regulations, they can do it. And we think that that is what will happen. Now, things like what USCIS will check during site visits. So typically what happens is, they verify the employment and the job duties. So the USCIS officer, they will come to the company or to wherever the employee is working. Maybe it's a client location. Sometimes they come to the client locations. Sometimes they come to their home. They go to their apartments. They go to their homes. So this is something what has been happening, and starting from tomorrow, it is actually codified. And what they want to check is, so typically what officers want to check is the employee actually working at that location? Is the employee actually working on the job duties that align with those described in the petition? They will check whether the employee's role matches the description of a specialty occupation, and if the required skills and educational qualifications are actually being applied to the job. This is something what they check. They also look at employer-employee relationship. They want to make sure the company is paying the employees. They want to make sure employees being paid the right wage. They want to make sure the employees' work schedule, the work conditions, everything is appropriate. And uh, they also look at the work location. One of the things they want to make sure is the officers, they want to make sure the LCA is being complied with. And what that means is the work location. They should work as per the terms of the LCA, in the right occupation, right work location, right salary. So all of these things are something what USAS wants to verify. And that is what they will do as a part of these site visits. How they do it? They simply come, they show up unannounced, they make sure the employee is actually working at that location, the employee is actually uh, available at that work site, the employee is actually getting paid. They ask for pay statements, they ask for various documents, and they actually make sure the company is actually operating. I mean, if a company is just filing a case and not really operating at that location, they have a problem. So these are the kind of things that they will do. And why this could be a problem is sometimes employees are working at the client location. The clients may or may not be happy with the USCIS officer coming for a site visit. So now the employer and the employee, they're also dependent on the client actually letting the officer verify the information. If the client says, no, we will not let you come into our work site, tomorrow the H1B, it could be revoked. It could run into an issue. So these are the kind of things that could be an issue, because in the past, if the end client said, no, we don't want to participate, we don't want you in our office, at least we didn't see direct denials, direct revocations. Now, probably more than likely, we might see issues. And how do employers do things in the future? So in the past, some employers, because it was voluntary, they simply said they don't want to participate. In the future, there is no choice. So what that means is employers have to keep accurate and consistent documentation. So employers should be readily have that information available. What is the job description? What is the job that is being assigned to the employee on a daily basis? What is the work location? What are the terms of employment, as in salary and so on? They need to maintain accurate records, because USS officer might ask for pay statements, and USS officer is not going to be giving them a lot of time. So always employers should have a process in place to give this information to the USCIS officer. And employers should constantly look and see if the duties are changing, because sometimes assignments change one project to another project. At every stage, they have to make sure job duties match. If there is a change, a material change in job duties, employers must file a new case, a new amendment case. So this is very important. And not only that, employees also, every employee should have a copy of their LCA. And if an employer is not giving a copy of the LCA, that is illegal. Every employer, they don't have a choice. They have to give the copy of the LCA to the employees. So every employee should have that LCA in their hand. They should look at the data in the LCA, the salary, the work location, the occupation. And if employer is making them do something or not paying them on time, make sure you point it out to the employer. Make sure you document it. Maybe send an email, or you call them. Make sure you document how you're contacting your employer to notify them of any violations in LCA. This is very important, because when you have a site visit, you have to make sure your LCA is completely 100% complied with. If not, tomorrow your H1B is jeopardized. and make sure your employer is retaining control over you. They're paying you, they're in contact with you, they're helping you with any employment problems. If not, there is not proper employer-employee relationship. Make sure that is being done. And complying with the wage requirements, that is the number one thing for any company filing H1B. If a company is filing H1B, they better pay the employees as required. If not, the employer is going to have definitely have a problem. And sometimes we see employees being penalized because employees are not getting paid. They try to do a transfer because the employer is not a good employer. And now when the transfer is being done, unfortunately, USCIS is punishing the employees. Even if the employer is not paying, employees are getting punished. So it is highly important that if an employee is not getting paid, keep documentation, keep proofs, contact your employer, let them know in writing that you're not getting paid. And if an employer is benching you, benching is illegal. Benching is illegal, not paying you on time is illegal. So this is very important. And if you're working with an employer that is doing these kind of things, immediately move away from those employers, because tomorrow your H1B will be jeopardized. Because we had cases where we had a case and employer is not paying somebody. We notify USCIS, we show proof that employer is not paying. And then in spite of that, employer is having an issue because USCIS will come and argue employee is not maintaining status even if the employer is not paying the employee on time. So be very, very careful. Don't work with any employers who are benching you or not paying you on time. And number one thing is everybody should be prepared for a site visit, because going into the future, the new regulations give a lot of power to site visits. And what that means is every employer that is filing a case, you should be prepared for a site visit. If you feel you cannot handle a site visit, do not file the H1B. So, and from an employee perspective, be prepared that you will have a site visit. And what that means is be prepared, because if you don't have a site visit, it is good. But if you have a site visit, at least you as an employee should be confident that everything is legit. Because if something is going wrong and the employer is not doing things properly, you should not stay with that employer. Look for another employer. Okay. So always do an internal audit. The employers should do an internal audit, and even the employees, you as an employee should always look at things. Look at your LCA, demand the LCA from the employers. If the employer is not giving it to you, they have to give it to you. And if not, you always have that you should always be able to complain to USCIS. You should be able to tell USCIS if an employer is not giving you a copy of the LCA. LCA cannot be hidden from you. You should know what the LCA says. Okay, so that is very, very important. And everybody, the employer and the employee, make sure you're complying with the terms of LCA. And if not, you'll have a problem with the site visit. At the time of site visit, if you're getting paid like you're supposed to, if you're working from the location you're supposed to, don't worry about anything. Nothing is going to happen. Okay. So all that needs to happen is if you're working as per the terms of the LCA, you're getting paid as per the terms of the LCA. Site visits are not problematic at all. Site visits are problematic only if you're not getting paid and if you're not working as per the terms of the LCA. So the bottom line is, your LCA, look at your LCA, you're working, you're getting paid as per the terms of the LCA, the site visits will not impact you at all. It's only if you're being benched, that's when the site visits will cause a problem. So the summary is there should not be benching. If there is benching, try not to stay with that employer.
Thank you so much, Chand. I think those were great things to keep in mind. And thank you so much, really, for the detailed explanation. Now let's head on to my next question, which is about the I-129. So there are changes that are happening to it too, and the effects of the chances of getting an RFE. What common mistakes should employers and workers avoid? Just in short, if you could just name a few.
Okay. So the old I-129. Today is the last day for USS to receive the old I-129. Starting tomorrow, that I-129 is not even published yet. It's going to be published tomorrow. It will be available in USCIS website tomorrow. And starting tomorrow, USCIS will only accept the new I-129, the new edition I-129 that will be made available very soon. And in this new I-129, they made a couple of changes. And the reason they made a couple of changes is because the new regulations, the final rules starting from January 17th, they are looking at some changes, looking at some new things. And to correspond and to confirm to the new final rules, what USCIS has done is they've changed the I-129. They published a preview version, and in the preview version, they made some changes. And the major change that we see USCIS has made is now in every I-129, they're very, very clearly asking about the third party work site. So if somebody is assigned to a client, upfront in I-129, they've added some data points where they're collecting information about the worksite. They're specifically asking if it is a third-party worksite. And if it is a third-party worksite, they're upfront asking who's the entity that is maintaining or managing that worksite. So what that means is tomorrow when USCIS officers are looking at the I-129s, upfront on the I-129, they will look at cases where somebody has a third-party worksite, and they will look at cases where there is no third-party worksite because the rules are different. And what to me that means is third party worksite kind of cases probably will have more scrutiny, will have more burden. And the reason for that is the new rules, they clearly talk about client requirements. So the officers, I think, they need to analyze cases differently. So whenever there is a third party worksite kind of a case, an end client, vendor, these kind of cases, they have to look at who the end client is, what are the requirements of an end client, and then based on that, they have to process the I-129s. So from a USCIS perspective, things have become a little bit more complex because now they have to look at all these things. But because of the new rules, that is what they will be doing. And from an adjudication perspective, from an employer perspective, from an employee perspective, you have to be ready, and you have to be ready with client letters. You have to be ready with vendor letters because USCIS is going to demand those documents because they need to know what the client requirements are. They need to know that it's indeed that client. So bottom line is there will be more scrutiny on the I-129 because of these changes that are happening to the form I-129 starting from tomorrow, because of these additional questions about the third party worksite, third party client name, etc. on the I-129 going forwards. So definitely, if you don't have client letters, your cases probably more than likely will have increased scrutiny. You'll have challenges. So for every case that has a third party worksite, somebody's working for an end client, we have been recommending starting from tomorrow, you have to go back to your end clients. You have to ask them for documentation about confirming the job assignment, confirming the educational requirements, and so on. And if not, you will see more challenges. And from an operational perspective, you need to provide more supporting documents. Documents we didn't have to provide in the last 4 years are now having to be provided. So H1B filings probably for third-party work site now will take a little bit more longer because now you have to wait until you get all the documents to file a H1B. If you file without these documents, more than likely you'll get an RFE. And what we are suggesting is until you have these documents, do not file the case. Even if it takes time, it takes time. But you rather provide all these documents thoroughly upfront and file the case rather than you get a very, very big RFE and then realize that you cannot solve the RFE. So things regarding the end client assignments, I think, are what needs to be attached. And for those employees who are working for full-time companies, more than likely this is not a challenge because you don't have a third-party work site. Anybody with full-time employment on the I-129 form, we don't see a lot of changes. It is only with third-party work site kind of cases that is the additional information that got added in the new form I-129. And some mistakes to avoid on form I-129. This is more for the employer because employer is the one that is doing I-129. The main thing is employer should make sure they provide everything that is required on the form I-129. Do not accidentally miss any information. Things like wage details, employee qualifications. Make sure everything is accurate, and demonstrate specialty occupation upfront. Demonstrate specialty occupation, okay? Because there is a way the burden of proof has to be proven. Make sure it is done as per the new regulations, and also complete documentation of work locations. So the new form adds multiple work locations in the form itself. So every employer should make sure the complete documentation of work locations is done on the I-129 form itself. And what that means is some people are working from client side, from their home, and so on. They have multiple locations. So all of this has to be a part of your I-129 upfront. Any incomplete or unclear information about all the work locations will be an RFE. So if you have multiple work locations, make sure everything is put upfront in the I-129 itself. So not properly putting the worksite information, the multiple worksite information as a part of your I-129 is not only going to be a problem with the initial filing, but even when there is a site visit, if it is not listed on the I-129 and you're working from home, it could be an issue. So always make sure the I-129 is thorough with the worksite information. If you're working from multiple locations, make sure it is documented. And so doing these things, making sure the form is thorough, I think things will be easier. That being said, third party worksite kind of cases, they have to ensure that the new I-129 form, the new changes are appropriately filled out, and the supporting documentation is not only accurate, consistent, and it should also be complete. And doing so, I think, will avoid the new kind of RFEs.
Well, thank you so much, Chand. And yes, so the I-129 form is also going to be a new one starting tomorrow. So, do you think that it's going to affect people who have already filed their I-129 up till today? Will they also have to?
Up till today, they're fine. Yeah, up till today, they're fine. So any H1B application that USCIS gets until today, it's still going with the old form. And those petitions, they should not run into an issue with the new rules. The new rules will be in effect from tomorrow. So any filings being done from tomorrow, where USCIS receives the file starting from tomorrow, those are the ones that have to make sure all these new rules are confirmed with, and make sure all the supporting documentation is appropriately attached. Until today, it's still the old rules, so still the old forms. So as long as the burden of proof as per the old rules are met, they should be fine.
Okay, that is awesome. Because, we've had so many viewers who've been asking if theirs is going to be affected. I mean, these new rules are going to affect them or not. So, thank you so much for the confirmation. And, we have Kay again with some more questions. I think we should quickly just address to them. So, hi back again at you, Kay.
Sure.
So, we have L2 processing is after I get my L1, he says. Will L2 qualify for Dropbox, but they never been to a face to face? If no, when can they visit an interview in the next 3 to 6 months, as would not like them to get rejected? L1, I have team.
So anytime after
Okay.
yeah. So L2 is basically the dependent of L1. So whenever the principal L1 employee gets the visa processing done, immediately after that, at any point of time while the L1 is still valid, the L2 dependents can go for stamping. So L2 dependents, whenever they're ready, they can go for stamping once the L1, the primary employee, gets his visa stamping done. And they will have to go for an interview because looks like it is the first time they're going for stamping. And based on the current rules, they will not have an interview waiver. They just have to fill up the DS 160, book an appointment, and then go for an in-person interview.
Okay. And he was also saying L1 have team at NJ, New Jersey, but while I manage that team, I have too much of travel to meet clients. Can I still live? I'm in central US for ease of traveling. What has social media IDs impact in DS 160 and interview?
Yeah. So in terms of the work locations and traveling and so on, so as a part of the L1 filing, the employer will document what is the nature of the work, what kind of work is being done, what kind of travel is being done, uh, what are the work locations, and so on. So from an employee perspective, he has to make sure that he coordinates with his employer and works as per the terms of the I-129. So for L1, we don't have an I-129. So as per the terms of I-129 in general, they have to make sure they're complying with the regulations. And in terms of what is the other question other than travel? So traveling is
Social
probably what
media.
he has to coordinate with his employer. I think there was another question
Yes, he
after
was asking about
traveling.
social media. What has social media's IDs?
Oh, social media.
Yes.
Yeah, yeah. Yeah. So in DS 160, for everybody, they ask for social media. And what is happening is the computer systems that Department of State uses, USCIS uses, they're very, very powerful. And what they do is they do a lot of data mining. They check for a lot of stuff because it is in the interest of national security. So they do want to make sure the social media sometimes is checked. And the reason they do that for all DS 160 applications is because they want to make sure for all the people that are trying to get a visa, whatever their intent is really their intent. And sometimes they use social media, sometimes they go and check to make sure that's the right intent, because they want to make sure somebody is not coming into US saying they want to come to US for something on DS 160, but their intention is different. So for that reason, they ask for social media, and they definitely do check. I don't know how deep they check for each and everybody, but based on some red flags, they do keep checking it.
Okay, Chand, thank you so much. And I think, Kay, you've gotten your answer. So thank you so much for participating. Please join us on call. We would love you to join. You can call us on this number 425-436-6335, and the access code is 988-888. So once you're in, just speak with us and we will be able to hear you. And this goes out to Kavita and also to we also have Namrata. So please join us on call. It would be really nice to have you. All right, folks. So we will quickly take a short break, but before that, I also want to tell you that you can even contact Attorney Chand Parvathaneni, and you can do so by calling him up, or you can even email him, and even visit his website, that is spblawfirm.com. And to call him up, you can call him on his number, and the details are on the screen, please. His phone number is 817-523-8247, and you can email Chand about yourself, your case, especially Kay, since you have been asking a lot of questions. I'm sure your case is going to be very different. You can even email Attorney Chand Pravathaneni at his email address is law@spblawfirm.com. And definitely don't forget to visit www.spblawfirm.com to get to know more about Attorney Chand Pravathaneni and Sin. Yes, and SPB law firm. So yes, thank you so much. We'll take a short break and going to be right back. So stay tuned on Immigration and Jobs Talk Show. Welcome back, everyone, to Immigration and Jobs Talk Show. And today we are having none other than the special guest, Attorney Chand Parvathaneni from SPB Law Firm, Dallas, Texas. And we have been discussing about the new RFEs that are going to come up and site visits, especially starting with the new rules, which is starting tomorrow, 17th of January, 2025. So, Chand, before this, we were speaking about so many things, the new updates, of course, and we even took up K. Vishwanathan's questions, and I do hope that K has gotten his answers. And we will be taking up the rest of the questions also, folks out there. Please stay with us. But my next question to you, Chand, is also about remote working, since it is the trend now. And you were speaking about, the systems in US being so strong that they're able to locate where their employers are working. So, for H1B workers doing remote jobs or working in different locations, what extra paperwork will be needed to stay compliant with the new rules?
So remote work is completely legitimate. And when somebody is working remotely, either from their home or from their apartment, it's completely legitimate. And normally, the kind of cases that we see are 100% remote, where somebody is working completely from their home, or remote, where sometimes they have to go to their client location, sometimes to their employer location, sometimes at their home, a mix and match of locations. So, from a regulation standpoint, both are allowed. The only thing is, it has to be done properly. And the way it has to be done is in the LCA. So whenever a company is filing for an LCA, they have to make sure they put all these work locations, multiple work locations, in the LCA. And they have to determine the salary at each location and use that LCA for H1B filing. And when the H1B is filed in the I-129, so if the employee is working remotely and also from the client location, for example, two locations, they put it. If the employee is working 100% remotely from their home, they put it. But the bottom line is it has to be filed in the LC and then it is allowed.
Okay. Okay, so it's very important to be filed in the LCA. And thank you so much, Chand, for the detailed explanation again. And Yes, we do have more questions, so I will quickly take up this next one. This is also about site inspections, the site visits. So, how will the increased site inspections or site visits affect the third party work sites and even the staffing companies? So, what can they do now to prepare for all these lately, I mean, the new rules that have come up and the extra site visits or inspections that are going to happen?
The site visits for third party work sites, that is going to be challenging, and that is what I think might impact a lot of people. The reason is some clients, they don't have any problem. They will work with the USS officers, they will verify things and move ahead. They will let them come into the work site. And the reason is the contractor who's the H1B employee, they're not the third party company employees. So that is why sometimes they do let the officers come in. Sometimes they say, no, we will not let you in because so and so is not our employee. And in the current rules, if the client is not cooperating with the USCIS, they're not validating the information, there is a possibility that that H1B could run into an issue. So, so how do you prepare? So, in order to prepare, I think every employee who's working at a client location, they should at least let their client know that as a part of the H1B process, a site visit could happen, and be prepared. And if possible, try to get a contact in case there's a site visit. Who do you contact at the client location? So if the employer tomorrow finds out that there is a site visit or USCIS is trying to do a site visit, because USCIS will definitely notify the employer at that point of time. They, at least if there is a contact with the client that they could work with, at least they can immediately let that client contact know, so that client contact could coordinate with USCIS on answering their questions. So the site visits could happen at the client location, and the companies have to be prepared for that. And part of it is convincing the client that, hey, this is a part of the process, please do cooperate with them, because if they don't cooperate, it could jeopardize your H1. And some clients don't have a problem, some clients could have a problem. And if it looks like it's a client that you could have a problem, probably you have to look long term in finding another project, because if a client for sure is not going to cooperate with USCIS and will not validate anything, tomorrow we don't know what USCIS will do. Maybe in the next couple of months we'll have more data, but in the current rules, the current rules that came out last month, if somebody is not cooperating, somebody is not participating in a site visit, and that includes the third party client locations, it could jeopardize the H1B.
All right, Chand, and thank you so much again for those updates. So, this is what we heard after. I think these things came up right after the elections, right? These new rules are going to set in. So, but then Trump is only coming to the office on the 20th of January. So, you mean there was no real connection with Trump? I mean, these new changes, with or without Trump hitting, or whoever would have hit the office, these changes were supposed to happen, right?
So all these changes are actually by Biden administration, and the way the rules were put in, it's not really like a quick process, because the Biden's administration was working for almost a year and a half, 2 years on these things, because a long time back, these rules were actually published in the draft mode. So this was happening for a long time. And actually, the new rules, some rules are actually very good. Some rules are bad, but some rules are very good. So it's a mix and match. It's a mix of good news, mix of bad news for H1Bs. So it's again not something that the Trump administration or the Trump team has done. It is what Biden's administration has done, and they've done it after following the proper procedure. So they're actually working on this whole changes for the last, I would say, 2 years at least, because the step number one was publishing the draft. So these rule changes, they published the draft almost 2 years back, a year and a half back, and they took comments. And the only reason I think they published it in December is, if they publish the rules and they get active, which is effective before President Trump takes his office. So President Trump is taking his office on January 20th, and if a rule becomes active before January 20th, the new administration cannot immediately change it. It is not easy for the new administration to immediately scrap the rules like in one day. It is going to take them a lot of time. So Biden's administration, I think, probably strategically finalized the rule last month, so it will get into effect before President Trump takes his office. So tomorrow, if the rule is getting active, the new administration, they cannot change the rule that quickly. They can definitely change it, but they have to follow a big process, a big APA process. So if they really want to change something, it is definitely going to take a little bit of time.
Okay.
So for those reasons, it's not the Trump administration at all. It is Biden's administration that finalized these rules,
Okay.
and they are the ones that are making sure these rules are active starting tomorrow.
Okay, okay. Thank you so much, Chant, for taking that up. And we also hear that the updated cap gap rule for F1 students, which is who are moving to H1B status, match with the new compliance rules. Do you think these new rules are going to reduce the RFEs for these students?
So the cap gap rules, so that is like one of the good things that happened in the new rule. So the cap gap, it's not going to reduce any RFEs, but what's going to happen is, so this is what cap gap says. If somebody gets picked up in a lottery and they're about to have their EAD card expire, so say they got picked up in the lottery in March and in June their EAD card is expiring. So what cap gap used to previously say is, if somebody files a H1B for you, even if your EAD card expires, even if your work authorization expires, you can still continue to work until October 1st, September 30th. That is what the old rule said. So pretty much for a few months, even without an EAD card, they were able to get a automatic EAD card extension till September 30th. That was what the old rule said. So the new rule, which is a better rule, what now it says is, if you have a H1B filed by a company and your EAD card expires after filing the H1B, you don't have to stop working. You can continue to work even after October 1st, all the way until April 1st. So it's like another 6 months of additional time. And this is very good news because sometimes USCIS does not adjudicate the cases by October 1st. So a lot of people, because cap gap was a good thing, but it expired starting from October 1st, they had to stop employment. So in the new rules, because they got a little bit more time on cap gap, a lot of people on OPT whose EAD cards are expiring after H1B is filed, they can continue to work even if the H1B is still pending even after October 1st. So all it is doing is it is helping people who are students whose EAD card is expiring to continue to work even after October 1st if their H1B is still in process. So this is one of those things that is really going to help a lot of students
Yes.
starting from this year.
Yes, yes. One good news. Yes. Thank you so much, Chand, for highlighting. And Chand, we also have a couple more questions, even from Facebook groups, that we would like to take up. So without further ado, I think we should take them up. So, Control, if you can display them, please. This first one is: Hi, all. Is it worth doing day one CPT if H1B is not picked in all three attempts?
So I think rather than say, is it worth, first of all, we have to look at the legality. So is it legal? CPT is legal, for example. So if H1B is not selected in the lottery and their OPT is expiring, so there are two choices. Either somebody leaves the country or change their status to change their status or do something that will maintain their status in US. So what people do is, if their OPT card is expiring and their H1B is not selected in the lottery, they have to change to a different status or maintain their F1. So if somebody is married, maybe they can look at H4 option or some other status option. If not, what they can do is they can continue their studies because somebody has F1 and before their F1 status expires, because they're not selected in the lottery, they can continue their F1. So what that means is they have to maintain status, they have to enroll in a college, and they have to strictly follow the rules of F1. And the rules of F1 require them to go to college, attend classes full time, pay the tuition, and progress towards getting a degree. So they can't fail classes. They have to progress getting a degree. So that is what they're supposed to do. And as a part of it, if that school requires CPT, because CPT has its own very, very strict rules. So as a part of it, if the school requires CPT, definitely they can do CPT. But make sure the CPT regulations are all met. So there is nothing wrong in doing a legitimate CPT, but the bottom line is they have to maintain F1 status, which means they have to do everything that is required as a part of F1, which is attending classes, successfully trying to progress towards your degree, and so on. So now the question is it worth it? F1 is a very expensive program because again they have to pay tuition, they have to go to college, they have to do a lot of things. And in their career plan, if getting that second degree is worth it, yes, I would say it is not a problem. Continue to do your F1 program. Make sure you attend classes, and as a part of it, if your school requires CPT, it is valid. Document everything that you're doing because tomorrow if USCIS asks, you have everything to show that you're maintaining status in a legitimate way.
All right. Thank you so much, Chand, for taking that up. Now, Control, if you can display the next question, please. So this is also on Facebook. Let's. Hello, all. I need your guidance regarding my travel plans. I'm planning to visit India in February, and I'll need to go for my H1B visa stamping during this trip. Considering the new administration transition, could it be advisable to travel during this period? And if yes, what steps should I take to ensure everything goes smoothly? I would greatly appreciate your insights and suggestions. Thank you.
Sure. So during last Trump's administration, President Trump's administration in 2017, when he just took office, what happened was immediately in a few days there was a travel ban, and this travel ban was limited to a few countries. So I think the whole reason, like a lot of people are confused, is there going to be another travel ban? I don't think there'll be another travel ban on H1B in the next few months. So I definitely don't think that is going to happen. But because there is this rumor that there could be a travel ban, because last time there was a travel ban, I think people are worried. I don't think there'll be a travel ban. But again, you have enough time because it's February and President Trump is going to be in office next week. So if there is really some kind of a ban, you'll know about it. But I definitely don't think there is any kind of a travel ban, and at some point of time you do have to travel. So I don't think that you should change your plans. Just monitor what's happening in the next 10-15 days, and just take your decision. And I would not worry about it, because as long as you have a legitimate job and your company is supporting you because they want you to work for them, go for stamping. I don't think you'll have any problem. And more than likely, because you're going from US to India, you already had a US visa in the past, which means you actually get Dropbox. You don't have to go for an interview. So more than likely, your process will be a little bit more faster and smoother. So I don't think you should worry about traveling to India in February, unless there is some kind of a travel ban in the next few days, which I don't think is going to happen. I don't think there'll be any kind of a travel ban for H1B employees.
Okay. Thank you so much, Chant, for that. And we also had Kay with another question, but Kay, I really suggest you to join us on call. So yes, you could ask the question yourself to Attorney Chant Pravathaneni. And once again, I can repeat the number 425-436-6335, since you're in NJ, or sorry, in Texas, but you can call us, and the access code is 988-888. Please feel free to join us. And Chand, we still have, maybe we can take up one more before we go. So if you can display that, please, Control. Hello, immediately attention is required, it says, and I'm traveling to India on January 31st for my H1B visa stamping, another travel. I submitted my DS 160 form in July 2024, but I recently realized I mistakenly updated my employment information in that section. To provide some content, I graduated in December 22. My first job started in February 23 and lasted for 1 month. After that, I got research work at my university until the end of May. Afterwards, I started another job in June 23 and still work here. I just updated the current employment section. Do I need to update my work? Additionally, could you advise me on how to change my DS 160?
So if the DS 160 is already submitted, more than likely they cannot make any edits. But what they can do at that point of time is email the support and let them know so it is documented. And I think if it is not submitted yet, they can make an edit. But if it is not letting you edit, just email the support line.
Okay. Thank you so much, Chand, for taking this up as well. And I think, yeah, we should take up Kay's question, since I was really waiting for you to join us, Kay. I mean, but yeah, let's just take it up. So he says, hey, thank you. I love Chan's respond and attitude than the other podcasts I had in the past 4 months on your channel. Well, thank you so much, Kay. That really means a lot. And thank you for the compliments for Chand as well. And thank you for taking it up. I appreciate. And sorry, he says, but he has one last question. And he's saying, Under L1A managerial expertise, I am employed in NJ, but can I stay in Texas and get caught in W2 or IRS?
I mean, again, in terms of the pay statements and IRS reporting, always make sure that your pay statements reflect wherever you're working from, because the taxes will be different. If you're working in Texas, for example, you don't have to pay state taxes. If you're working in New Jersey, you have to pay New Jersey taxes. So, so if your payroll is not reflecting the actual place you're working from, tomorrow you're probably not paying the right taxes. So tomorrow IRS can come back and claim that there is some tax fraud happening. So to avoid it, always make sure your employer, they report to USCIS where exactly you're working from, and on your side too, from your perspective too, wherever you're working from, your payroll should reflect that, because tomorrow you don't want IRS down the line to come back and say you didn't pay these taxes properly, because the state you live in will determine your state taxes. So sometimes the taxes will be different. How much money you owe the state governments will be different. So for this reason, your payroll should accurately reflect wherever you're actually physically working from, and doing so, you should not have a problem. And your company can always make sure they notify USCIS appropriately by doing the right I-129 filing. So that way they report wherever you're supposed to be at, and then they pay you wherever you are at. So that way there is no problem with USCIS nor with IRS down the line. Because you are under L1A, more than likely you will qualify for a green card very soon. So you'll have to file for I-485 also very soon. Because the typical transition is L1A, they do I-140 filing under EB1 category, and you probably will be able to get a green card soon. But what that also means is you're doing an I-485 filing. So you don't want any of these steps to be jeopardized, because when you do your I-485 filing, you'll be submitting your tax returns and a whole bunch of other documents. So just make sure everything is aligned. If not, at this point of time, the company can fix it, make sure the I-129 filing is appropriate. But definitely the good thing is you are coming under L1A, which means as soon as you come, the company should be able to pursue the I-140 under EB1C category, and you should be eligible for a green card in a lot faster way than the other EB categories.
Well, thank you so much. And I think with that, we took up all the questions from Kay. And we're really happy that, Chand, you covered so much on this topic we had the discussion on today. And that is not, I mean, with the new rules that are starting tomorrow, January 17th, what new RFEs can we have, and about these different site visits as well. So thank you so much. And maybe last but not the least, if you can wrap up with anything more or a few more points to keep in mind, just to highlight to all our audience out there, it would be great, Chand.
Sure. I think the big thing is, I think in the H1B world, there are two things. One, a full-time job where you work for the same company, there's no end client. And the other model where you're working for one employer, but there is actually an end client. So the full-time guys, I think all of you make sure that you have the right LCA. Make sure you compare your LCA to whatever you're supposed to do at your job. And for the third-party client worksite kind of folks, make sure you have the LCA and you're complying with the LCA. And not only that, make sure you get the client letters, because you will need the client letters for your extensions, for your visa stampings, and so on. And that is very important. Not only that, let your client know. I mean, you need to have a client contact in case there's a site visit. Be prepared for a site visit. If there is a site visit, you need to have a proper protocol in place. So you're not like running around at that point of time. Site visits are not bad. All they want to check is you're getting paid. It's actually going to protect employees, because they want to make sure employees are getting paid. Employees are not being exploited. So in a way, site visits are not bad. Only thing is you need to have a protocol where you're not worried at that last minute. Be prepared. All they're going to ask you is your pay stubs, your job duties, and confirm that you're actually working at that location. So it's nothing huge. It's just that you confirming that everything is right and you're getting paid the right amounts. So doing so, I think you will be prepared for site visits, and we will have more data in the next couple of months. But again, as long as you're working and getting paid, the companies are paying you, nobody should have any issue at all.
That is great news. So all we have to do is follow the law and do everything correctly, have all the documents right, all the information right in proper details. And I think, yes, nothing is going to um, be too bad for us, right, Chand? So with that, I think that is a wrap
That is
for,
correct. That is
yeah,
correct.
for
Yeah.
today's episode. But folks, thank you so much for joining, and you can call Attorney Chand and his number as well to contact him further on your case. His number is 817-523-8247. And you can email Chand at law@spblawfirm.com and go visit www.spblawfirm.com to get to know more about Attorney Chand Pravathineni. And thank you so much, Chand, once again. It was a real insightful session. You have a great day ahead.
Thank you so much,
And
Nipasa.
folks, if you still have questions, keep commenting because we will make sure to address to them and even take it to our attorneys who can give you proper answers to each of your questions. So please feel free to keep commenting even after the stream has ended. And you can even email me or contact me. And my phone number is 408-335-6444. You can even WhatsApp me in the same number. And my email address is nipa@staffingme.com. So thank you so much. Y'all out there have a great day ahead. And don't go anywhere. Stay tuned on Immigration and Jobs Talk Show because we have another webinar lined up with host Sam and our guest attorney, Uma Mantravadi. So stay tuned. Bye-bye for now.